Someone make it make sense.
Probably a couple.
Hello, guys. Have y'all heard? Dude, what is going on with StreamYard? StreamYard's like, I don't know what's happening. Last night, StreamYard was being really weird. Like, had like redone all the settings in terms of like the colors of the banners and all this other stuff. And now it's like, what is going on with the screen? I don't even know what I'm looking at. This is very odd. I don't understand this. This is very weird. Have you guys heard anyone else talk about this stuff? Or is it just my StreamYard? I don't know what I'm looking at here. Anyway, wow, today. So, y'all, I was trying to figure out how to go about today because I wanted to cover some of the BK docs. But, you know, it's kind of up in the air when you have a hearing like today because you don't know how long the hearings are going to go. You don't know what's going to happen. And once I kind of started to hear a little bit of what went on today, because I was teaching lessons and stuff, I wasn't able to hear the hearing at the time live, right? I was like, well, yeah, we're not going to be able to do both in one day. We're going to have to just prioritize this, and we'll get back to the docs tomorrow. But what I wanted to show you guys is the part that I heard. As in, I hadn't really heard any of it. And then the hearing was still going on. And I clicked on EDB and I literally it wasn't live. I just took the slider thingy and I just literally moved it to a random part. I just was like, I slid it back to like, you know, whatever. I just moved it. I was like, let me back up and let's just hear a chunk and just wherever we're at. And literally, this is what I heard at that time.
Any of you that are new here, Code Red is a lovely bumper. I love the music. We are reworking it so it's less flashy, but it is flashy. If you are flash sensitive, the flashing stops when the music does. We are going Code Red. It's going to take me a minute to reset the lights. Don't worry, they're coming. Lol. I told y'all, when my gut says we can't go to Code Red yet because more fuckery might pop off, we're always going to trust it. Because a note from the desk of that says, this is how it records lol, is not what I had anticipated at all. I'm going to change the lights. We're going to let him talk. Oh my God.
Is laughing.
Hold on. We're going to just back it up.
Or how she came to possess them at the time, but she did write on that little pad, quote, that is how it records LOL, no tampering, end quote. LOL.
Hold on, guys. Listen to this again.
On that little pad, quote, that is how it records LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24 you received?
This is what I heard. Literally the moment I just, again, randomly clicked into a random part of the hearing. This is what I heard. But it gets worse than that.
Was that the date?
10/10/24. That's correct.
Niece, love you. And
By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video.
It's too late. It's too late.
So why didn't we get this from Canton PD until October 2024? Well after trial. What was the delay? And why did we get another video in January of 2025? What was the delay?
Where was it?
How could this be seen as anything other than intentional? We know now that Sergeant Bukhenik, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant material surveillance video be turned over immediately. And it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday.
Oh,
So now we're going to get to the reports from Friday. This is where I just didn't, I was like going to throw up. And then I think I just like started crying. Not even kidding.
From Sergeant DGM Petro, he reveals the following. He writes this report on the 27th, which was last Thursday. And then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022.
no, just quote the whole thing. Jackson, just mount up. Quote the whole thing. Just read the whole fucking thing.
Requested Lallyport video of SUV inside Lallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Lallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him.
Wait for it.
Assuming it was February of 2022, that would have been before the override, I presume. Because I think the math in my head is 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Lallyport video again of the SUV exterior footage. Quote, this is from his report, I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station.
One more time, just in case you missed it.
That I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the law.
I'm going to back that up. The entire time? The entire time? The entire time?
Bring the jury.
Judge Newman.
The whole time? The whole thing we requested the whole time? The whole time? Well, then where'd they go?
Requested Lallyport video again of the SUV exterior footage. Quote, this is from his report. I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote,
where are they?
Due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting.
Where are they?
This is the first we're hearing of any
Jesus
of this.
fucking Christ.
Last Thursday.
Friday. The entire time. We're not even close to the entire time being turned over. This is why there needs to be an evidentiary hearing. This person needs to come and testify to what they did. This is what I downloaded. This is who I gave it to. It took a while to download. We downloaded it in 6-hour chunks. This is how I downloaded it. This is our practice. This is where I put it. Where the fuck did it go next? An affidavit's not going to be enough.
How is that?
An affidavit's not going to be enough. So that's a snippet of what I heard when I randomly was like, what's going on in the hearing? So yeah. Then later on, I did catch other random parts, but basically, I know that, they were in federal court and then they kind of got delayed to start. And anyway, but I wanted to give some context for what blew my mind today, because that's what I heard. So with that in mind now, all right. So one thing, I don't remember if I mentioned this yesterday, but one thing I from yesterday. So I guess, what is CourtTV? Okay, they're just waiting for it to start, I guess. Okay. And I know that they were the first to get the cameras rolling once they returned to court from federal court. So what I was going to say though from yesterday, so, the whole thing about like, is she going to kick the attorneys off the case? For any of you guys who've heard the other coverage I've done on this, not yesterday, but at the previous hearing, we were talking about this. We were talking about, will she remove these attorneys? What will be the sanctions, right? If she does find that there was an issue with like the candor to the court. And when I ended up doing, I think it was towards the end of the episode, I was like, or the end of the live stream, I was like, you know what? Here's the thing. If nothing else, we know Judge Bev wants us to go to trial on April 1st. And if she does anything where she removes counsel, she's going to have to continue that date, right? And so even if it's something that she normally would have done, if you have to weigh out, like, what does she want more? To get rid of like Alan Jackson or to go to trial on time? And I was like, I think she would pick going to trial on time. So I kind of had put that out. In other words, I was already feeling like, I don't think she's going to remove counsel, even if for no other reason than the fact that like she wants to start trial on April 1st. So I kind of I forgot that was like a concern that maybe was still out there, in the universe, that like, oh, is she going to kick somebody off the case? I kind of had ruled that out. But to that end, what I will also say is that yesterday, my thought was, if that was something that was even remotely on the table, that would have been dealt with first in the day, right? Because why else would you be going through all these other motions and whatnot? Like, if you're going to remove counsel, then that's going to retool the entire thing. Like, why are we doing everything else, right? Like, that would be the first thing you would have to do, because the rest of the shit's not going to matter, because now we have to continue the trial. So, while she hasn't ruled on that, to my knowledge yet, I don't think that it's anything that needs to be a concern. I think that if anything, we're going to be dealing with potentially maybe something like a fine, which is what I was thinking would be the case anyway. So I just wanted to follow back with that. But now we're going to jump into the hearing from today.
Ordinary governmental misconduct, are true and correct to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state is fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you.
So here's what's going on here. So first of all, again, like I said, this CourtTV was the feed that got on here the earliest. So other court feeds, I think, actually missed some of this part. But we were kind of lost anyway, because this whole bit with Lieutenant Fanning and stuff, remember, a lot of that was redacted in the court filing. And so we didn't really have the context for what was going on here fully. So this is kind of a jarring place for the hearing to start, where it's like, but this is not the motion to dismiss, for like particularly. This is well, it's a facet of it, right? But this is like, she's addressing a specific issue as it pertains to Lieutenant Fanning. And I think that this was also something that was brought up from Hank Brennan yesterday, as it pertains to like why he was kind of asking for like a gag order, saying that they had violated the protective order because he had said that they were making false allegations and whatnot. And so we didn't have all the information related to this juror, but we're going to get some of that now.
What your good faith basis is for that. And I'd like you to start there.
If the court recalls the discussion at sidebar,
Yeah, Denise, again, I haven't watched the entire hearing, so I don't know yet if they brought up the candor to the court issue again today, but just from yesterday alone, right? Because we covered that entire hearing already, obviously. From that hearing, you know, it did look like that she could find that there maybe were some issues with the candor to the court, and that would be separate, of course, from the motion to dismiss, completely separate. So, like, for example, I guess he could prove his case for the motion to dismiss, but he still could be found to have not been fully, you know, following the ethical guidelines for candor to the court from yesterday, because separate, right, in my understanding. But good night. Hopefully we'll see you tomorrow for PK stuff.
We're told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that because that was the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously
You were not, just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury.
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember. No, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yanetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us, we were told he was the commander, not part of a security operation that was outside the court.
So I want to just reiterate, you know, again, I started this live stream by showing you guys the part of the hearing that I randomly heard, right? And what is coming up. And that is related to the motion to dismiss, okay? However, keeping in mind, we've just gone to the beginning of the hearing, right? Obviously. And so at this juncture, anything that comes up with the motion to dismiss in the Lallyport video, that's not in context here, right? So what's interesting here is we were actually just talking about where we had left off from court yesterday, right? With the candor to the court and everything regarding like the invoice. And then there was also Brennan was complaining about, you know, making statements outside of court and whatnot. And so now they're talking about this issue with Fanning, but what it sounds like to me is it's actually Judge Bev brought it up first because it's almost kind of still getting into that realm, potentially in her mind, of, you know, trying to roast the defense potentially for exaggerating, maybe in a way. So maybe not quite the same type of issue, but in that same realm, because she's pissed. It's clear that she's pissed. Again, they were supposed to start like with the motion to dismiss, but she's asking about Fanning, and she's like concerned about this whole thing with the jury tampering. And not that there was jury, she's not concerned that there's jury tampering. She's concerned that they're saying there was jury tampering, right? When she's like, you should know better. So in other words, the point being, at this juncture with Judge Bev, the way Judge Bev has done this, Jackson is still in the hot seat right now. Okay. And she's basically grilling him about, could you make these types of statements on, you know, on a good faith basis, right? Mr. Yanetti knows that's not how it's done. Da, da, da. So that's where we're at.
Not part of a security operation to help parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Yanetti and I asked the court to take evidence from Lieutenant Fanning.
I think it was Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So, of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxon. He interviewed all of those individuals or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case. And he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without,
I don't know. The problem is here, if it's a stretch, if it's an exaggeration in any way, it's just not going to be good, right? Because, like, again, the defense is already on the chopping block right now, especially Mr. Jackson, right? And when it comes to Judge Bev, you have to think about your audience, right? And that's really the thing. You have to think about your audience. So it's almost feels a bit risky for me if you're exaggerating this, right? If you can't produce receipts that there was any type of interference by Mr. Fanning. And the other thing is you don't want to be misstating or misrepresenting something that was said at sidebar.
additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 20.
Uh-oh, hold on. Oh, dear.
2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
She said Mr. Yanetti should have known now.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
now
there
that you
evidence
know
that-
it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
So we will move on from that, Mr. Jackson. We'll move on from that. So
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case. And he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror? That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view.
Right.
And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the courts.
Yeah, Heather, and I agree, and that's kind of how I'm feeling about it. Like, bro, trying really hard to swing, right? That's why this was really interesting to me, because it's like he's going to be arguing the motion to dismiss, right? But again, we haven't gotten there yet. We're coming out of yesterday where he was already in the hot seat. She's not yet actually at this point ruled officially on what she's going to do about the sanctions. You know, the whole thing about the invoice, the comments made at sidebar. Then we had the whole thing from what Mr. Brennan said about the statements. You know, that's kind of a separate, but could play in a separate issue, but could play into how Judge Bev is just viewing him at the moment, right? And we already know how she tends to be anyway, right? Again, you have to think about your audience, right? And she's the audience. And then coming in and starting out this way. Now, of course, this wasn't his plan, but this is what she wanted to start with, but I'm thinking about this too, right? Because we know that, you know, they added Mark Betterow to the defense team, right? It almost makes me wonder, I don't know. I'm just thinking out loud. Like, was this because there was a thought that potentially Jackson could get removed? Like, I don't think that's going to happen, right? But were they thinking along the lines of just in case that does happen? Were they foreseeing some issues with the invoice? I mean, because they added Mark Betterow, that motion to add him pro vice was recently. And I'm trying to think about the timeline of that, because I feel like it could have been around the time when they turned over that other discovery, because that was in February, right? When they had they turned over the other discovery with the invoice and whatnot. But didn't at the same time turn over the fact that it was paid. I don't know. It's interesting to think about, right? Like, but the reason I'm saying that is this, because if they were thinking, okay, just in case there's some sort of issue, just to be on the safe side, just in case, because it's Judge Bev, let's say she does remove Jackson, we need somebody else, we're going to add Mark Betterow. If that is at all what was going through their minds as a defense team, then maybe you go ahead and say, you know what? Like, let him go. Let him make these arguments, even if it's a little bit of an exaggeration as it pertains to this, you know, Lieutenant Fanning. Let him risk it with Judge Bev. Almost kind of like being a martyr in a way, right? Because it's like better to fight for it and hopefully maybe make these arguments and get it dismissed, right? If she's going to remove you anyway. Like, in other words, if you're thinking that she's going to remove you anyway, right? You've nothing to lose and you've already got other counsel, you know, back up. I mean, I don't know. I'm just thinking out loud. I'm not saying this is what's happening. It's just really risky. It's really risky, in my opinion, to start out this way when you're already on the chopping block. And it's this judge, you know what I mean? So Kit Smits is back. Welcome, welcome. Yeah, exactly. Thin ice. Yes. And again, you just have to read, it's free. It's all about the audience, right? And that's the thing. Because she's not happy with him. She's not happy with him, right? She wasn't happy with him before today. And knowing that he's going to be the one arguing the motion to dismiss, right? It's almost like you would, and to me, it's almost like why are we starting out this way? Are we just like, you know, is this sort of like one of those movies where you're going to get fired? So then you just like come in and just like, you know, set everything on fire or whatever it is that they talk about. You know, it's like you're going to get fired. So then you're just like giving everybody the finger. I don't know. It just feel like it comes up in movies or whatever, you know, where it's like, you got nothing to lose. I mean, I'm just because it is interesting with the Mark Bettero timing and he's not there yet, you know, I don't know. But we'll continue on. See what happens. So, oh my God, things are falling over.
All right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
Interesting, right? Okay, hang on. So that is very interesting considering all we were just talking about. Give me just a second because my computer stuff all just fell. Okay, let me see if I can skip ahead here. I mean, I know I can. So I wonder if this is because Yanetti is like, dude, hey.
Yanetti just indicated to me that.
Okay, here we go. Let's see what happened. It's interesting.
Thank you for that. The court invoked Mr. Yanetti and said, as local counsel, he knows this not to be true. Mr. Yanetti just indicated to me that that's not quite the fact. And so Mr. Yanetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yanetti.
Interesting.
So if the court would allow Mr. Yanetti to explain what his experience is.
That is important because so Judge Bev had just made that statement a few moments ago. You know, you guys remember she was like, Mr. Yanetti knows da 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 da. And so Mr. Yanetti's like, well, hang on, that's not exactly true. Wow.
That may elucidate on this issue.
If we have time later, go on with your argument.
Exactly, Heather. Yeah.
I'm happy to, Your Honor, and thank you for giving me the opportunity.
All right.
The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Lallyport videos.
Okay, so they're just moving right into the motion to dismiss. Hold on, what? Back up. This is insanity. Too fast? Are you really a 19-year-old?
Through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon.
I did not go back far enough. I'm just like, wait, what? I thought we were, what is happening?
I'm happy to, Your Honor, and thank you for giving me the opportunity. So if the court would, as the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yanetti. So if the court would allow Mr. Yanetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
Oh, if we have time later. Okay. Now we're on to the motion to dismiss. After that, going out in a blaze, like Heather said. I mean, I would not want to be doing this in this situation. I'd be like, no, can we resolve the other shit? Like, you know what I mean? She's like, no, we're not going to resolve any of this. We're going to have you argue now. Like, what? All right.
I'm happy to, Your Honor, and thank you for giving me the opportunity.
Oh, wow. That's cool.
The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents.
My brain can't process this. Like, this is just not normally how it's done. I'm going to swoop because I feel bad. Like, he didn't get a swooping moment, and he's just like going right on into that. Right. So we're going to swoop and we're going to do this one.
Whenever I talk about this theory that I'm like, I don't even know how to explain it because it makes no sense. We'll listen one more time. We'll put too much food. This is it. This is the whole thing right here. This is it.
I'm trying to tell her that this is a big deal. Like, if we go to the police on the second extortion, they're going to catch the second extortion, and when they catch them, they're going to turn, and the second extortion is going to turn in the first extortion. And then when you catch the first extortion, the police are going to come talk to us. And then when we tell them what happened, you're going to be in a lot of danger. There's no way I can talk to the police. So by catching the second, it's going to turn in the first. And that's exactly what I say in there.
And there it is. We updated our command here. So that there we get the third extortion. So, and 122 times or 123 times, as Heather kindly reminds us, is 123 times is how many times Charlie said the word extortion when he was under direct examination. Freaking love it. The thing is this. I was literally, again, the way I started out the live stream, I showed you guys literally the part that I heard of the hearing, and that was my first exposure to like what was happening today. I played that for you guys, that little bit. That was what I heard. And like, it was so funny because I was like, thinking about like, I don't know why it came to mind. But what came to mind is like, what is something that can always make me laugh in a situation where I'm just like so upset about this stuff, the injustice of it all. And literally the first thing that came to mind, Heather, you'll appreciate this. The first thing that came to my mind was Wendi Adelson. Literally the first thing that came to my mind when I'm like, was really just so upset and distraught because of the shit that we learn. And I don't even know all of it yet, just from what I heard, right? The first thing that came to my mind was this is the thing that can always make me laugh.
My friend Elizabeth is a mortician. She's the prettiest mortician I've ever met.
You guys, Andy's friend, the fucking mortician. What is happening?
I mean, and not just that one, all of them. All of the Wendi, all of the Fievel, Charlie with the double extortion. Literally, the thing I thought of was the Adelsons, the entire case. And I just thought, like, whether it's Donna laundering the money. I mean, literally, I'm like, oh my God, like that can totally pull me out of like, I don't know. It's just funny. It's like the first thing that came to my mind. So, yeah. That's funny. Yeah, we do have I can't remember. I think it's code. We do have a command. For Code Red 2. So wait, you never watched Breaking Bad? Huh? Wait, hold on. Is that you never watched it? Well, I don't one of the best TV shows of all time. Definitely watch it for sure. Oh my God, that's crazy. I think you're the only person I've ever known that hasn't seen it until now. Like, that is crazy. I can't even believe it. But it is fucking phenomenal. It is one of the best shows ever. Wow. Yeah, he does launder the money. That does happen. Wow. God, I remember, Jesus, that was a long time ago, wasn't it? Yeah, you're in for a treat, though, Kit Smits. I'm sure you've heard, though. All right, so we swooped. We're on to. Oh, I have a banner for this. We're jumping in. Here we go, guys.
I'm happy to, Your Honor, and thank you for giving me the opportunity.
All right. Get your goats ready.
The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers through their agents, has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers. But I want to concentrate my argument for the court this afternoon on the exculpatory Lallyport videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Lallyport issue, or the Lallyport video issue. The Commonwealth, to start off with,
I think this is how funny is this, right? I mean, with all this, the way that this has been is, oh God, if I was Jackson, I'd be like, fuck, can we just do it? Can we just take 5 and come back and start new? Like jumping right into it. And now we have like all of the sirens, which they happen, but it's like way louder than usual. And the timing of it all.
2 facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it.
Where's Twins?
Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? They also bring in a newly revealed sergeant, a sergeant by the name of DG Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing.
Oh, for fuck's sake. All right, so this is the retired dude. All right. Yeah. We're going to get to learn more about this. This is the dude, right? We heard about, oh, there's another drive on another computer. We're retired. This dude. The part that we didn't know until now, he was retired. He retired. What does he say 2 days after the disclosure? Okay. Y'all, again, at the beginning of the live stream, I showed y'all the 30 seconds or whatever of what I heard of this hearing earlier. When I randomly just clicked in and where EDB, and I just went to a random spot and what I heard, and literally I texted Twiz and I was like, the goat will break today. The goat is going to die today. I don't even know how I'm going to be able to handle this. And again, I haven't watched all this, right? So it's just, but already I'm like, okay, let's pace. I have got to pace myself for the goat's sake. Because the timing of the guy retiring, right?
Why not? And they also bring in a newly revealed sergeant, a sergeant by the name of DG Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Lallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious. So he's still around?
He is.
Okay.
Yes, and it's cooperative.
All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them.
That part's important. Let me back that up. And y'all have heard the goat has been recently rejuvenated. The goat went to the hospital and got his ear fixed, and had replacement goat batteries. But still, I think I'm gonna pacing myself. But what's Brennan chiming in here with? Remember, part of what's on the table here, let's keep in mind, besides just dismissing the indictment, is also an evidentiary hearing. So let's keep that in mind.
For disclosure revealing previously withheld Lallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious. So he's.
The reason I mentioned that, because that's an interesting question from Judge Bev. Is he available? Interesting. Okay. I don't want to get my hopes up. However, what that signals to me, Judge Bev asking if he's available, you know what that sounds like? Evidentiary hearing. That's what that points to. I don't want to get my hopes up because it's Judge Bev. But asking if he's available because you want, and then Brennan's like, well, not today, but he could be. Interesting. Because that, At a minimum, I think we need the evidentiary hearing so we can just learn what the fuck was going on, and then it needs to be dismissed. I mean, it should be dismissed, right? But please, for the love of God, can we get we've got to solve, we got to close the loop on these fucking videos. So I would rather have an for my own, like, this is not, I'm just saying, for my selfish purposes, I would rather have an evidentiary hearing first so we can learn of all the fuckery and then dismiss it. So I'm in my, selfishly, I would say I'm rooting for the evidentiary hearing, although dismissing it would be appropriate regardless.
Still around.
Yes,
Okay.
yes, and it's cooperative.
Right.
All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received.
Wait, are you saying, Kitsmits, did you hear us talking about this yesterday? Because you were there, right? Because we were talking about him being a speed reader. Is that why you're saying that? I think that's why you're saying that. I feel like you were there because we added it up and did the math, and it was like there's no way you could have read all those pages. Yeah, I'm pretty sure you were there for that. But yeah, I think he's a super speed reader for sure. Yeah, it's the Boston accent.
Receive them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Lallyport at Canton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Lallyport video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Lallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Lallyport. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Lallyport interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant DG Petro retired, we received four videos.
Wow.
The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Lallyport. And I highlight the word exterior because it becomes extremely important in just a moment. These are four videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022.
That's so funny. Google Translate asked if the person speaking had a speech impediment. That is fucking hilarious. Oh my God, that is so fucking funny. That is so funny. I was going to say another good one. I can't even do it, but the way they say Norfolk is really funny. I can't do it, but there's a certain way whenever you hear them say Norfolk, I don't know. It's like Norfolk. I can't do it. I don't even know, but it's really funny.
On January 28th, 2025, the Canton Police Department main driveway side exterior Lallyport was given to us. That's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Lallyport video that we ever received. One on October 10th, one on January 28th, 2025.
Oh, Alabama, cool.
Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Bukhenik.
Oh dear.
Dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony.
Oh God.
He goes on to say, quote, at this time,
Okay.
I
All right, let me back this up. Okay, this is so important. And remember, the last, was it yesterday? Anyway, yeah, I think it was yesterday. We were watching the hearing, and we went back and looked at Yuri Bukhenik's testimony from trial, and we looked at the Lallyport videos, and we're getting more information on that now because none of that made any sense.
On Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Bukhenik, dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Lallyport. Exterior Lallyport.
Oh.
That means that the Massachusetts State Police not only had in their possession exterior Lallyport video, but they knew about it and were reviewing it during trial. Oh, but we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had had, or was it the same Wobbly?
Same.
Okay.
Same. Wobbly, Grainy, can't make heads or tails out of hardly any of it. No.
Wow.
The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Bukhenik admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Lallyport video? We now know that Bukhenik watched some sort of exterior Lallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos.
Okay.
So either they reviewed together the inverted video that was then played,
wow,
and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Lallyport video and intentionally withheld it from us. This is binary. It only happened one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Bukhenik was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody.
I thought we too fast. Yeah, or aren't we turning 19? Oh, Twiz is finally here. Well, where have you been, Twiz? By the way, if you go back to the beginning of the stream real quick, you're gonna see I started the live stream out with literally the clip that I was referencing when I texted you, and I said that I just caught a random chunk, and then I was like, I'm gonna break the goat today. And like literally, it's just like a 30-second clip of the part that I saw when I texted you. If you feel like going back and watching that and then popping back into where we're at now, because that will give you some context for, this. Oh, is it hot outside or something in there? Wait, why are you in shorts and t-shirt? And hose? So what do we have? We've got hose now. Goddamn, I got bitches, wifey, girlfriend, and mistress. Why are we not dressed for the weather, Twiz? What is happening? You guys. Y'all. We've got Kitsmits who didn't watch Breaking Bad until now. We've got Twiz who's wearing summer clothes in 33-degree weather. We've got Too Fast who might get washed down the shower. Heather seems to be doing all right, although we've got Heather's dog having issues with the goat and also walking. What is happening, y'all? Y'all. Why are we what? Why can't we put clothes on? Why?
It's pulled into the salad bar. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through.
Now or no? If you can, if you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided. It's just very obvious.
Wednesday,
there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them.
Right. That's
on April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But at the point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had that's in it to their opposition was this joint affidavit.
She said, what are we wrapping up? I'm going to back it up a second. I just wanted to say, because we love dogs here, as you guys know, I just want to say, so if this has happened to Frodo's had the paw thing. There's been random times where Frodo will have like an issue similar to what sounds like Heather's describing, where like he's got one leg or one paw that's like he can't put weight on it, and he's like limping and kind of gimpy. And it's really funny because I don't know what it is. And it just resolves itself. I'm not saying that I in other words, I hope that for your dog, Heather, Hippopotamus, I hope that whatever it is, it resolves itself. But Frodo is 14, and I've seen this has happened, right? I mean, number of times throughout his life, and I've got stairs, going out into the backyard, and that's sometimes it's like he's just trucking right along, and then other times it's like he's got a certain leg he's not really putting weight on. I don't know, but I hope it's nothing serious, and I hope he's fine. He hates his paws touched. So does Frodo. Frodo can't handle having the paws touched. Yep. Right. And there you go. Right. It could just be he pulled a muscle. Right. Yep. That's the thing. Yeah. He gets the zoomies and goes bonkers. Yeah. Less than 30 hours. I think he'll probably be, how old is he again, Heather? He's pretty young, right? That's a good tip there. Yeah, soaking it in a warm wash rag that's been soaked in it. Yeah. That's a good tip. Okay, so let's get we're wrapping something up here. Let's see. We're wrapping up. Okay. We're wrapping potentially Hippopotamus's paw, but also we're wrapping something up in this hearing.
It's just a few minutes ago that they're now adding to their exhibit list and to their opposition. But at the point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had that's in it to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Lallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs,
Okay.
crime scene photographs in support of the vehicle in the Lallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Lallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Lallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Lallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Lallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Lallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Lallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen, we can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. It's Michael Proctor milling about at the passenger taillight.
Milling about.
These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense quote struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Lallyport, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the
right.
Lallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video. It's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight.
Mm-hmm. And that was really important. It's really important, that part as well. Wow. So yeah, so we had tornado watches in New Orleans, tornado watches in Alabama, tornado watches here. Interesting. Stupid wind is right. My brother, I'm sure was excited though. For anyone who doesn't know, my brother is a professional storm chaser. And I had a question. Oh yeah, Twiz, did you see the George emoji? Because I can't remember if you've seen that or not. And like, I'm sure Heather is going to do exactly what I'm thinking she might do. I can't do it, by the way. It's funny. Like, I can't use the custom emoji. Like, maybe if I go to YouTube, but anyway, I don't know if I can because I can't be a member of myself. So I don't have access to them. Otherwise I would be doing it. So I need y'all to be my hero baby, you know? Thank you, Heather. Heather's being my hero. Thank you. You can be my hero, baby. Wait, that's not how it goes. It's I can be your hero. Wait, anyway, I don't know. I don't remember. Yay. What's what? What's what? Five-all. See, I can do it this way. I can do five-all this way. I can do a groundhog this way. What emoji you put? It looks like you did, see, it doesn't show up normally in StreamYard. It looks like you did George. I know you know what that is. I guess road trip crew. Is that what you're saying, Twiz? Road trip crew? Is this what you're asking about here? Murdoch people will get this. So this is there's so many, we have so many long standing, I don't know if we want to call them inside jokes or whatever, as it pertains to Murdoch, that just developed over the course of the entire trial. So I understand why people who weren't there wouldn't understand what they're looking at on the screen. I will explain it. Kit Smiths, feel free to chime in. What you're looking at there was a day. Okay. There was a day when we were doing What the Truck, and we were trying to figure out the shit with the trucks and the shenanigans. And we were all so brain dead from trying to figure this out. And then we realized that what we thought was the guest house was really the skin-in shed. And we were looking at the picture, the exhibit of the skin-in shed. That's how they say it. And then we realized there was a tractor in the background, way in the background of the skin-in shed. And then I think it might have been Black Witter. Honestly, shout out to Black Witter. It might have been Black Witter. I think it was her, but somebody suggested, because we were like, the math wasn't adding up. We were like, there has to be another vehicle involved. I think it was Black Witter who was like, what if it was a getaway tractor? What if it was a getaway tractor? I could have been Black Witter, could have been DSN, maybe. But what if it was a getaway tractor? And this tractor was way in the background of this exhibit, of the skin-in shed, okay? And we were just dying laughing. We were just dying laughing about the getaway tractor, because it was like the only other vehicle. We were like, how does this add up? We couldn't figure it out. The getaway tractor is what you're looking at. That's why it's so blurry, because it was way in the background of this exhibit. I was able to extract it from the rest of the exhibit and make it big. That's what she said. So the getaway tractor. So now you've got, this is the road trip crew. Okay. So this is the story. And so you've got Alex Murdoch. The original road trip crew was Alex Murdoch with Bubba and the chicken. And then there's a shrimp weasel. Now the shrimp weasel is Alex's spirit hybrid animal, because we know we have these for everybody, right? Just like how Ezra has like the shark weasel. Wendi is 5-all. We got this. So Alex is the shrimp weasel. And because weasel, like weaseling, but also shrimp because he kind of looks like a shrimp. The color of his skin is very shrimp-like, so he's shrimp weasel. So in all the different thumbnails for Murdoch, you'll see that there's a shrimp weasel somewhere. It's like a little like a, what do they call it, an Easter egg or whatever, kind of like a Where's Waldo. If you go and look back to all the different, the shrimp weasel's always there somewhere, kind of hiding, and it's usually somewhere on Alex Murdoch, if it can be. So like, for example, when you go back to this, you can see the shrimp weasel. So the original road trip crew was Alex, Bubba, Chicken, and shrimp weasel. And then I added Pooch. And then it got new and improved, or if you will, with this one, with Lolly, the Lolly bird. Now, this is the one where he wanted to be a part of the road trip crew, but he wasn't invited. They didn't want him. So the getaway tractor is now trying to get away from the Lolly bird. So he's trailing behind. Kit Smiths, I think it was you who made a joke, trailing behind like a bunch of trash, like, the cans or whatever, or like, I don't know. I think you made a funny joke about this. Trailing behind like garbage. Anyway, he's trailing behind. And then even lower on the totem pole. everybody's trying to get away from Amber Heard. And that's Amber Heard wearing her, what was it? The North Korean dictator costume outfit. What is it called? What's his name? I'm blanking on his name. The dictator dude, the North Korean dictator dude. Anyway, that's that outfit. So because that was one of the funnier outfits she had. So anyway, hopefully that explains things. So that's the story behind the road trip crew and the, and so then we had like the road trip crew, gangs all here, gangs all here, right? And that's the first swoop I made, by the way. The first swoop I made was for the road trip crew. And remember last night I was explaining how the It's a House that came from Alex's 911 call. So just to tie it all together, let's take a look. This was the first swoop ever, the tractor swoop, road trip crew. So this is the road trip crew with Lolly, but this is the swoop. And you're going to hear the It's a House from the 911 call.
It's a house.
I was able to animate. This is my first. I was able to animate the road trip crew plus the Lolly bird. Let me take the banner down. Hold on. This is important. I was able to animate it. But here's the thing. Remember when I was talking about the photo exhibit with the skin and shed and with the tractor in the background? The background of this swoop is that photo exhibit from trial. This is the trial exhibit. So if you look at this background, you will see the actual tractor in the background. That became the tractor that they're riding.
It's a house.
Okay. Let me see what you guys are saying here. Kim Jong, right? Kim Jong, that's his name. Thank you. Yes, it is. It is. That's Iago, or yeah, it's from Aladdin. Yes, because whenever we were doing the trial the first time, I was always making fun of Lolly for his squawking and being like, "Squawk, I'm Lolly, squawk." And so then at some point he became the Lolly bird. And then somebody made a joke about the bird from Aladdin, and I was like, "Oh my god, I wonder if I can make his hybrid animal him plus the bird, the Iago, I think his name was." And I was like, "I don't know if I can do it." So I did that, and then I was like, "Hold on, his closing arguments tie. That was the biggest challenge." And so I actually had to take a picture from him at trial wearing his closing argument tie, get the tie, remove it, and attach it to the Lolly bird. And so that's the other thing, is that it's him, the Lolly bird, plus his actual closing argument tie. So we make magic happen, or we try anyway. Yeah, the shrimp weasel's there. Yeah, Kim Jong Il. Yeah, or whatever. Kim Jong, whatever they say. What's Kim Jong Un, or what's his last part? Anyway, Twiz really wants to know how old Alessi is. I don't know. I've Googled it. I can't find it. I haven't been able to find it. I have no idea how old he is. Oh, Jeff H is here. Hi, Jeff. Welcome. I've only ever seen you for BK stuff, but welcome. Right. Alec Murdoch. Well, and what's funny is it's spelled Alex Murdoch, right? But it's pronounced Alec Murdoch. Go figure. All right. Kudu cuckoo. Kudu cuckoo. Calling all squirrels. Kudu cuckoo. But it is funny that the first four letters, yeah, murder, yeah. It's really funny. It's really funny. I've got a funny clip thing somewhere. Anyway, I'm not going to go look for that now, but with that. But yes, the squirrel call. Kudu cuckoo. Yeah, so Alec Murdoch. So anyway, hopefully everyone understands now what the deal with the road trip crew. And every time you hear, because you'll hear that it's a house. That's from his 911 call. And it's freaking hilarious. So, all right.
Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay.
Underpinnings, like an undercarriage.
Hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports are affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time.
All right.
So the Commonwealth battled us, and this is something I think the court has to really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Lallyport. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath.
That is being so funny.
And all the while they were battling us on the time that it got there. No, the defense is all wet. They're wrong. They just didn't account for daylight savings time. No, this was just a little mistake. It's not a big deal. It was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the Lallyport at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Lallyport until 5:30. So the Commonwealth was well aware in 2022. The Commonwealth and their agents were well aware in 2022 that the SUV got to the Lallyport, and that was the centerpiece of the defense.
In case anyone hasn't heard, right? Remember, when it comes to this shit with like the evidence, comes to this shit. Okay, let's just regroup. So when he says the Commonwealth and its agents, he's not talking about like dun 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 da da da. It's not like James Bond or like 007 spy shit, right? It's like, remember, when it comes to things being exculpatory and Brady violations and stuff, right? If it's in law enforcement's possession, custody, or control, it's in the prosecutor's custody and control by definition. Vice versa is also true, right? They're one and the same. So the Commonwealth, prosecutors, the DA's office, law enforcement, CPD, I almost said Moscow PD, but that would not be true in this case because that's a different state. So, but they are all one, they are all considered the one entity. And why? Obviously, they're all the government, right? So they are all responsible for having knowledge. Like if law enforcement has it, prosecutors are responsible and whatnot, right? Vice versa.
In this case, they knew that the videos would directly impeach the lead investigator on this case. And they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it. It's their struggle to acknowledge it. Of course, that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Lallyport, would it show the condition of the taillight before Trooper Proctor had access to it in the Lallyport? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. That is, this is not a game of Wordle. This is not something that's supposed to be parsed.
Wordle? Okay. All right. Well, he said that. So we're going to just real quick. You guys, there's something that I do every day. I do the Wordle every day. I do the Wordle every day. And I do the Loodle every day. That's spelled Lewdle. So the Wordle, the Wordle, and the Loodle. And if anyone wants to know what any of those are, let me know. But they are super fucking fun. And I've been doing them every day for probably, Wordle for a long time, but I learned about the Wordle and the Loodle maybe like 2 or 3 years ago. And I don't think I've like missed a day except for like maybe when I had COVID, maybe I've missed maybe, let's say if I were to estimate in like a couple of years, probably 3 days if I were to guess. Yeah.
All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of holding exculpatory evidence by playing some sort of gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has. So we have to be as broad as we possibly can when asking for evidence to be preserved.
This is interesting. So Jeff's saying a Lallyport is called that because it combines the word sally, meaning a sudden military sortie or attack, derived from the Latin salire, meaning to jump, with port meaning gate or door. Very interesting. I love the I love learning and I love the history behind the name. However, remember, I'm trying to make sure everybody, we have to remember it's actually the Lallyport. So while we appreciate the history of the origin of Sallyport, whenever they say Sallyport, I hear Lallyport. Because Lallyport.
So all physical evidence clearly includes the entirety of all the Sallyport videos.
Lallyport.
The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sallyport because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene.
Right. That was
So
a
they can't have
very interesting moment at trial. You guys remember that part? Jesus Christ. That was wild.
Both ways. They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department of Sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sallyport video existing until we received the federal grand jury paperwork showing the Michael Proctor.
I can see where this is going. That doesn't matter because if law enforcement had it, which they did, at least to a certain extent, right? Somebody did. Then it doesn't matter. You can't just say we didn't know. It doesn't work that way.
Testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case.
What I was just saying.
Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581. And this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Bukhenik and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor.
Okay.
I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Bukhenik. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed.
That would be fun.
Another point of fact, by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite.
Okay. All right. I'm gonna back this up. This is okay. We're getting into the information that we have all been seeking, but I wanted to take a minute here because Scroll Crew is awesome, dude. We love the Scroll Crew. The Scroll Crew, we've got so many awesome Scroll friends that are all good at different things. And I have a question for you guys. Because there could be a way to do like a stream version. It could be like a members only thing. I wonder if there's a way we could set it up to do like a game. Like I'll have to think about this because I mean, there totally has to be a way to do like different games, right? Like that we could do. That'd be super fun. But what I was thinking is like if you guys like for people that are like if you were at a trivia night, right? You know how like everybody's got like their strengths and weaknesses, or it's like if you're at trivia, like categories you would excel in, right? So what would you guys, if you feel like saying like what would y'all be like, okay, like I've got this category on lock. Like for me, that would be music. Unless there's some trivia about orchids and that's probably not gonna happen. Right? What is it? Like usually music, like movies, sports, history. I'm trying to think what other categories are. What else? I guess those are the main ones, right? But and that's so true. And that's so true. Kits is saying that if the Bev, right, of course, but she's never going to hold it to the same standard. And that's the thing. That's why she's biased. It's sad, right? Words that start with the letter Q. Sweet. That's a good one. That's a good one. That's a good one. Kitson's just answering that. Okay. Yeah. Well, good. Well, looks like we got that category covered. So I'll have to think about that though. If there's a way we could do like a game thing, that would be really fun for like a members only live stream or something. I'm sure there's ways to do that. I invented this game a few years ago called Flag Masters. Anyway, that's a whole thing. All right, let's keep going with this.
Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact. By his statement, Michael Proctor admitted that, quote, we pulled, in quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C is in Charlie.
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Lallyport at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video. That was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least. but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry.
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers but on it.
Sorry. Anyone that's just listening is gonna be really confused. You guys, the chat, Squilker is the best, and we're just, the chat is what's making me laugh here. We're doing words that start with Q, and then Too Fast was like foods that start with Q. And by the way, they're killing it over there with the foods that start with Q. And then Kitsmith said, I don't even know how to pronounce this. Quince? I don't even know. And then she said, ugh. And then I said, is that a food? And then she said, quince or ugh. I'm laughing. Oh my God. Right. Yes, she has. I don't know. What is that? Quince? I don't know. I mean, like, I know, like quinceanera, but I don't think that's what you guys are referencing here. Quince. Okay. Quince. What the fuck is that? Is that a food? So we got people quoting some Star Wars. I mean, I can get. Can we go back to quoting like Monty Python? If we're talking movies, oh, it's a fruit. Okay, I'd never heard of that. Interesting. Cool. Quince. Wow, I've never heard of that. I can't even picture what it looks like. Found on cheese boards. Well, you know who might know what it is then? Speaking of cheese, would be Fievel. Yeah.
April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Lallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We weren't sure. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably 45 minutes, let's say.
All right, so we'll break.
Okay, we're taking a break. So by the way, Twiz made the funniest joke earlier. If you feel like sharing your funny joke, Twiz. And what we're gonna do is for a swoopy swoop deal for the break, we're gonna do this because we haven't watched this in a while, and I was just thinking about this. Let's just, here we go. Get low, Canton style. Woo! Do 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 do. 339 Canton time. Jackson, Yanetti, it's time to shine. There's snow, there's snow, there's snow, there's snow. To the window, to the wall, to the wall, to the bartender's last call. At the waterfall. I sleep, sleep, motherfucker. I sleep, sleep, goddamn. I sleep, sleep, motherfucker. I sleep, sleep, goddamn. They'll crunk and act and meet. Friends will be rest when they have too much drink in their minds. Everything's fine, they've been active already together about 50 damn times. To the window, to the wall, to the wall. The bartender's last call. At the waterfall. I sleep, sleep, motherfucker. I sleep, sleep, goddamn, goddamn. I sleep, sleep, motherfucker. I sleep, sleep, goddamn. Do 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 do. Yeah, the funny joke was about, he had to do with the tampons. I don't want to spoil it. And I don't know, I want you to, unless you would rather me tell it, but it, yeah, had to do with, I don't want to spoil it because the punchline is really great. That was amazing. Remember I told you I took a screenshot of it because it was so funny. Yeah, I don't know how I managed to do that. I just got really lucky, I think. The way that it zoomed in. I mean, it is pretty crazy, right? Yeah, I'll sleep. All right, so now we're going to go past their little breaky dindle. Oops. Okay, so lunch break. And we're off like a herd of turtles. Anyone know what that's a quote from?
All right, Mr. Jackson, go ahead and continue.
All right.
When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know, it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally, perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them, and that's the galling issue. Then the Commonwealth writes, the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Bukhenik with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth during this debacle had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Bukhenik under direct examination by Mr. Lally, going into the next day, still under direct examination by Mr. Lally. They played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Bukhenik or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Bukhenik about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Bukhenik started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Bukhenik was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least in its initial comments to me, was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. It's he's on the other side of the car.
Right.
That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head.
Right.
He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner.
The point is this, right? In other words, because you can't see him, you can't see that he isn't touching it, and you can't see that he is touching it. So where does that matter here? Well, right. Remember, the evidence has to be material and exculpatory, and essentially, I think that what matters here, right, is if it wasn't inverted, you would be able to see what he was doing. That's my understanding of the way. I mean, we still don't really understand how it got inverted and why it's inverted and whatever. But my understanding would be that because it's inverted, right? If it wasn't inverted, you would have been able to see what he was doing. And that, to me, is the thing that is that issue, because the problem is the video, right? The video is inverted, and therefore, not only was it misrepresenting which side of the car he's on to the jury, there's that, but also you can't see, you're not seeing what was actually happening, and you can't see him because he's on the other side of the car. And again, if it wasn't inverted, wouldn't he be, then you'd be able to see what was happening. So like my understanding of the whole thing with the inversion is like essentially whatever was going on with that corner, that tail light and Trooper Proctor, if inverting the video was something that somebody did on purpose, right, potentially could that have been so that they can show that moment in time and you can't see what he's doing. Maybe. I mean, that I'll just be honest. Like at the time during the trial when that was played and it was like, that's inverted, 100%, that was my interpretation. I was like, oh, they inverted it so you can't see what he's doing. That obviously, like that was my automatic, why else would it be like that? So it's ironic then that the fact that you can't see what he's doing is then flipped against the defense of like, well, you can't prove that he is fucking with it. It's like, that's not how this works, right? Oh, okay. So Kismet is saying you wouldn't be able to see the other side of the car by uninverting. Okay. Yeah, I guess I'm still trying to, in my brain, figure out what it would have looked like. It's a mirror image. Okay. It flips it the other direction, I guess. Okay, so that makes sense then. Yeah, and then it's really interesting because then why else would it be inverted, right? Like if they weren't trying to invert it so that they could obscure what he was doing, why else would it be inverted? I don't know. Maybe we figure it out because again, I didn't get to hear all this. I only heard that one certain chunk. So
out of the view of a camera, and then when the Commonwealth plays the video, it's switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight, and all of that.
And you cleared that up,
right? But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos.
Well, they call it inverted. I mean, it's been called both, right? So, I mean, I'm just calling it what everyone else is calling it.
That we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutor sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence: the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter.
Oh dear.
And it actually wasn't a letter. It was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations.
And what was the date? 10/10/24 you received that? Was that the date?
10/10/24. That's correct.
So now, we'll do that again. We are now at the part where we started this entire live stream with the random chunk that I happened to hear earlier was starting right around here, I think, with the LOL. Oh my God. Oh my God. Oh my God. Also, hi, Leslie and Billy. Well, happy to see you again.
She came to possess them at the time.
Oh dear.
But she did write on that little pad, quote, "That is how it records, LOL, no tampering," end quote. LOL, laugh out loud. So the chief of police is laughing. In the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct.
Here's the thing. I just don't even know how to process this. Like, literally, like I said earlier, like when I heard this, I was like, am I going to throw up? Or like, am I going to just start crying? Like, I don't even understand this. I don't understand this. This is so upsetting.
So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/20.
I need to hear the part. I need to hear
pad
the part. I need to
how
hear
she
the
came
part.
to possess them at the time. But she did write on that little pad, quote, "That is how it records, LOL, no tampering," end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24.
The goat is ready.
That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, "The prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video," end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, "all relevant and material surveillance video." So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Bukhenik, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, maybe Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday.
Oh dear.
This past Friday. Additional reports from the Commonwealth, in a report from Sergeant DGM Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Lallyport video of SUV inside Lallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Lallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Lallyport video again of the SUV exterior footage. Quote, this is from his report, "I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station," end quote. He goes on to say, quote, "Due to the large size of the files at that time."
Hold on. So now we know that not only would it not have been overwritten at the time, but that also they had the entire footage. The entire footage of from the entirety of the car being there, and that it would not have been overwritten yet. Okay.
I had to break it down into 6-hour blocks for ease of exporting. This is the first we're hearing of any of this last Thursday.
Incredible.
How is that? Sure. Ms. Lou just handed me a clean copy of the DJ and Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes.
You probably did.
So I've seen it.
Okay. May I approach?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if
Sure.
that's all right, Your Honor.
I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
Okay.
So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
Exhibit 1 so marked.
Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DG and Petro, he downloaded every single bit of video of that car while in the Lallyport or while at Canton PD in Lallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day overlay. It's the only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DG and Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out for the first time that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG and Petro admits that he, Rafferty, and the Canton Police Department had Lallyport video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Bukhenik, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, They downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed. And to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Bukhenik's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022, he knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Bukhenik with a yellow Post-it note. I further added Canton PD 12922, and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony. So it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Lallyport. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Lallyport, which was grainy and had a camera vantage point from the front of the Lallyport. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Lallyport camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned.
Now that, hold on.
They were returned.
Let's hear that part again. Hold on.
Prior to my May date review. I later learned that this video was provided in an inverted manner.
Right there, that matters because that means that it's not automatically recorded that way, right? Like if that's how it was always done, then you wouldn't say that. You later learned it was provided in an inverted manner.
After I reviewed
and also provided, not recorded, right?
All the provided video, the thumb drive, and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
Oh.
Are the two still marked?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
Do you have an extra copy? Is that one clean?
No.
Almost. No. Is it a copy?
May I approach your-
This one has highlights on it. I apologize.
It's okay. Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Bukhenik? Who's at the center of all these Lallyport videos? Who does he say was requesting the Lallyport videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Bukhenik to review? It stands to reason, could have been Trooper Proctor. Seems to be reasonable, but I don't know because Trooper Bukhenik doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing. Michael Proctor was receiving the footage directly from DG and Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Bukhenik, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this, none of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with because we didn't have any of the evidence that had been secured concerning that Lallyport. Question, there's surveillance video from Canton Police Department Lallyport garage that wasn't turned over, right? Answer, that video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing she
I'll provide that to you
can.
in just a moment, Your Honor.
June 10th?
It was either June 10th or June 12th, but let me double check.
While she's looking for that, Your Honor, may I
Please go
proceed?
ahead, yep.
Okay. The only thing, it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the Lallyport that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it and he received it, according to Sergeant DG and Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible with all this sort of years-long flurry that we just talked about surrounding these Lallyport videos that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question, to believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor. And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Lallyport garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic. that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Lallyport. The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors have never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed the review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry, it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went and why we don't have them and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith. And this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument. But the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298, 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and finds that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession, and it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though, and it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. The Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
I understand that does not help the defense.
It doesn't help the defense. I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the Proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just for the court's reference, lines 8 through 12.
Great.
Thank you.
I have a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, And again, you just saw I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dayton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not really Sergeant Barrows' testimony.
Well, it sounded from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No,
As Dayton Police Barrows testified. All right, where do I find that 47 pieces?
The 47 pieces, I can get a multiple transcript sites, but those were the photographs the Commonwealth presented at trial, that there were that many pieces found at the crime scene.
It's the number of pieces that were booked into evidence.
Okay, yeah, great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it, because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight recovered.
That's not clear to me the way this is written, so I'm glad I asked you. Okay. All right, so with that, now, Mr. Yanetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you.
Hey.
As I started with a question for the defense. So I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Lallyport videos, and why the dribs and drabs of the way the discovery came in.
Dribs and drabs.
It may
Okay.
be most helpful if I give the court history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand, perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Lallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial. At that point, there had been no request by the defense for video of the Lallyport area. What I learned is that Trooper Proctor had requested Lallyport video from the Canton Police Department. And the person who was the custodian of Canton Police video, who would download it from the DVR, was Sergeant D. Giampetro. He made a request shortly after this event on January 29th, 2022. Sergeant D. Giampetro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Bukhenik, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Bukhenik did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video
Doesn't matter.
is the same video that Sergeant D. Giampetro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Lallyport and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of
That's not good.
2023,
I don't like that at all.
Trooper Proctor then made a second request from Sergeant D. Giampetro
Even though we already had it?
for different cameras. He wanted cameras, camera angle of outside the Lallyport area. So when the tow truck dropped the car off, leading into the Lallyport, which is now characterized as the exterior Lallyport video.
Right.
Again, Trooper Proctor asked Trooper Bukhenik to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Bukhenik went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Bukhenik's name, and Trooper Bukhenik
Freaking
wrote in
Post-it
the
notes.
case file on that yellow sticky. He brought the CD to
Yellow
Trooper Proctor.
sticky.
Again, Trooper Proctor in June 2023 had a copy of the exterior Lallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal
Dormant?
grand jury,
does that mean?
essentially he testified, was
Yeah, being
asked about
dormant.
video, and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial.
Oh,
ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022,
I mean,
shortly after January 20.
at the very least, I think what's clear here is there needs to be an evidentiary hearing for many reasons, but one of them, this chain of custody is a complete and utter mess, right? It's a complete mess. And there's things about this that are still very unclear, but there needs to be an evidentiary hearing, clearly, for many reasons, but I'm just adding to the list here in my head, another one being the chain of custody here.
9, 2022. I'm sorry. It was provided April 4th, 2022.
2022 or later?
No.
It was later, right?
It was
Because
later.
the
It was-
federal grand jury was later.
He provided it on the eve of trial. So it was April 4th, 2024. So we know this production on
Oh,
April 4th,
2 years
2024 was in the hands of Trooper Proctor in shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Bukhenik's name on it, which shows the exterior Lallyport. As trial began,
The thing is, like, so Trooper Proctor had it for 2 years. Obviously, they needed to turn it over, but like, why the fuck? This is crazy. And again, the fact that he had it does not absolve the Commonwealth. That counts, right? Law enforcement are all the same.
there still was no specific order or request. The chief of police saw something about the trial and
Huh?
rephrase. Prior to the trial,
Oh my God.
it's reported that Attorney Yanetti was discontent because the video of the front camera Lallyport was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yanetti's concerns, then asked Sergeant D.G.M. Petro to see if there was another camera or to produce any other video from the Lallyport. Sergeant D.G.M. Petro then downloaded video from the DVR, which is the second camera that is inside the Lallyport, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior Lallyport has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Lallyport and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite
Oh my God.
on that system, the system had a number of backup hard drives. And because of the backup hard drives, the video existed longer than 30 days.
This is crazy.
She wrote an extensive report that was turned over to the defense, and this is after trial.
Why?
The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial. And it is noted in the sergeant's letter, the chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the
Yeah,
department.
that's insane.
And they were saving video, in their opinion or from their perspective, to help defend against future false claims against them.
So he's admitting that. I mean, he's not fighting that. So this is crazy. Okay, so here's what I'm getting so far. My takeaway of this is that so they clearly had all the video. We still don't know what the deal is about it being inverted or whatever, right? But I pointed out a few minutes ago, it was interesting how they said it was produced that way, not recorded that way. Anyway, but they had the entire thing. It wasn't overwritten. It was on a backup hard drive or whatever. But instead of turning it over at the time like they should have, it was given to Trooper Proctor, apparently. He had it for 2 years. And then only when they heard a claim like made by the defense, like Brennan was just referencing, only then would they turn over, quote unquote, dribs and drabs at that time for like in little segments, right? Only to then try to dispute something that a defense might say versus turning all of it over, which they should have done back in 2022. This is crazy. I don't know. The only way to remedy this is to dismiss this. And there should be a huge lawsuit as well. I mean, this is crazy. They need to I hope that there's a way in which she can sue and get at least her legal expenses reimbursed by the Commonwealth for this. This is crazy.
They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I've said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned about the videos. And then as a consequence, I spoke to the chief, other officers, and the sergeant. Unexpectedly, the sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files.
Again, listen, no written chain of custody. This is crazy.
My investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything. So I asked that the parties of the Commonwealth look through all files.
Brennan, when he learned of all this, he should have said, fuck this amount. Like, this is crazy.
All databases so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Bukhenik's name on it. That is the exterior Lallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Bukhenik to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's. Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
The defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. They have produced absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything.
No.
And so the idea of intentionally withholding or bad faith is just characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which is about 3 sentences. But if you actually read a number of pages of his testimony that deals with this video, and it begins on page 133, what you will see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the Grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton police.
I thought, hold on.
And you can also see.
How is that possible though? Because I thought that's the way that the video automatically was. Are there 2 versions of this entire thing? Is there a version that's inverted and a version that's not? And if so, why is there an inverted version and how did it get that way? Maybe they'll talk about that.
That he in no way was hiding the June 2023 video. Because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Lallyport video, and also there's an exterior video outside the Lallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Lallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Lallyport and there's the exterior video. So clearly, Trooper Proctor was aware of the exterior Lallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course. And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory. They seek evidence that they think is relevant and material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. put in context that the defense theory was a evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe. In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now, that recently has changed. If you see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to put the Commonwealth on notice. They're supposed to chase down every potential idea.
The thing is the defense is allowed to have their theory evolve. That doesn't make a difference in terms of what you're supposed to turn over. That's completely separate. Discovery is what discovery is, regardless of what their theory is, right? The only reason this would even be relevant is based on what we heard earlier about how only when there's new allegations or new claims or whatever things that are being said by the defense, that then they're like, oh, well, we need to turn this over only because we want to be able to dispute what the defense is saying. That's the only reason that that would be relevant. But that's not how it works. You have to turn it all over.
Creation that the defense has. It's important to look at the motion that has been presented to your honor on behalf of the defense where they claim that they moved to preserve video evidence.
Exactly.
And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
And so, Attorney Yanetti,
Wait, she agrees with, but that, I mean, again, it's like he's trying to blame the defense, right? Because their theory is evolving, we don't turn over discovery. It doesn't make any sense, but that's what he seems to be trying to argue here.
The Stoughton District Court motion?
It is.
Okay.
And I know the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so, Attorney Yanetti, and I've mentioned this before, was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yanetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for your honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yanetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard pressed now at this moment where they are trying to create prejudice that doesn't exist to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when
I was like sitting here, like rolling my eyes and face palming, and then the closed captioning said applause. Look at this. The timing of where it says applause is like exactly when it's like, this is the dumbest thing I've ever heard.
The Canton Police Department is somehow the crime scene. It doesn't convert.
Right there. No, not applause. Not applause. You should say like booing or something.
In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when we read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Bukhenek's testimony,
it's so funny, right? The reason I think they were saying that those questions about the thing, because that was said in like, okay, they weren't even eliciting that. Like that was so funny how it came out when they referenced the crime scene and it could be Canton PD. And then they followed up on that because I think they interpreted it as a Freudian slip, as in the crime scene being when they fucked with the taillight, right? Or whatever Higgins was doing. like like that's how I interpreted it when it came out from law enforcement, when they called it that or whatever. And then they're like, oh no, like that was so interesting because it was all, I interpreted it as a Freudian slip. And that was kind of sort of my read as far as the defense as well. And then they picked up on that. And then, but I think that that's what that was, because it's like the way the defense use it is like the crime scene, because there's other fuckery happening there, right? The crime scene doesn't involve their client, right?
2024, if you start at page 103, Attorney Jackson, to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Bukhenik that is lying about his position or about what he saw, or that Trooper Bukhenik admittedly saw the inverted video. Not the case. Trooper Bukhenik reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you've seen in anticipation of your testimony? Now, remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting. I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Lallyport that we saw yesterday, correct? He says, Trooper Bukhenik, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. Answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Bukhenik, clearly. That is not correct, because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they asked you to reach, that Trooper Bukhenik watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance, because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So
Do you have the grand jury cite? I
I'm
might have got it from this a little earlier, but the grand jury testimony.
Really confused, because I mean, beyond whatever Higgins was saying at the grand jury, it came up at trial. We all heard it. I don't understand. I feel like, is it just me, or am I confused? I feel like Brennan is not addressing the obvious major issues and the biggest issues raised by the defense. I mean, am I crazy?
Of Brian Higgins. I have it. It's just easier if you have a cite to that.
I have it tab, but I don't, perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it.
I'll provide it momentarily.
All right, thank you.
So what really arises from the subterfuge
From the subject.
is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering.
Okay.
And so ultimately, the import of the defense's argument is that this evidence, this information is exculpatory. It's exculpatory because what they claim is that
I would just love for someone to ask Brennan the question, Mr. Brennan, if you were a defense attorney on this case, how would you view this?
Show that Ms. Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barrows' testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight to my best ability and recollection, that tail
Like the doubling down and doubling down. I mean, it's like over and over again. It's what the Commonwealth's been doing, and they're still doing it. I just feel like it should have happened a long time ago, but the honorable thing for them to do would be like, look, we fucked all this up. We're just going to drop. Like, they should never have come back with charges after the mistrial. I mean, I thought to myself, I know everybody was saying they're definitely going to do it again because they really want to prosecute this. I was like, they would be crazy to bring forth that to go for round 2. They would be crazy. They should never have done that. But even though they did, I mean, at some point they should have just said, you know what, we are going to do the right thing and we're going to stop the bullshit, right? And instead, what do? They're spending all this money to bring in Hank Brennan, you know, taxpayer dollars. And it's like, and then even when you, so there's that, like the overarching, they, you know, doubling down in terms of prosecuting Karen Read. But then even when you make it, you go small scale with it and you come down to even just like each particular argument, doubling down. It's all the way through from the littlest detail all the way to like the general overview of what's happening. It's crazy. It's crazy.
light was not completely damaged, it was cracked. But they forgot the next part. And there was a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barrows, says more. And so if that taillight is not just cracked, that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring because there can be no plant of fractured taillight if it's already gone before it gets to
But one piece missing, one piece is still different than 47 pieces.
Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing.
And we know that it ends up being missing later. Like we know it goes from whatever state it's in to then all of it being gone. And that's also true. He does not get to say that it's right. Exactly. That is also true.
Missing well before that car ever gets to Canton. And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the claim that the Lallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense. And I just wanted Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the Lallyport area. Now you can see, if you stop that please, thank you very much. On that wall, on that garage wall, there's a 4. It is backwards. This Lallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Bukhenik. It was in existence well before Ms. Reed's car showed up to that Lallyport. Similarly, front wall camera, could you please put on exhibit 3? Exhibit 3 is from January 28, 2022, a day before Ms. Reed's vehicle makes it to the Lallyport. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police.
What is the point of having, if this is a police station, why the fuck would you even have a camera if this is what your shit looks like, dude?
This is the way the camera worked in Canton. Thank you very much.
Then everybody needs to be fired because this is insane. Like, what are we doing? Like, either way, this isn't good for them.
And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, What we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please.
I still have questions though. So the interior Lallyport camera, the inverted one, I still have questions about why there's like, people appearing and disappearing and there's chunks of time missing and the apparitions, because part of what's confusing here is it's like, there's different cameras, right? And so when they were talking about how they had the entirety of the footage from when the car was there, was that from all the cameras? Does anybody know? Or was that just referencing the interior or the exterior? I would imagine it's all the cameras, right? Because this is just really confusing. But yeah, I feel like regardless, the thing that's not been addressed that much today at all is like the issues with that interior camera. Okay, fine. Even if you say it's always inverted, whatever, but what about the chunks of time that are missing? What about people appearing and disappearing, right? All that shit. So anyway.
This is from the Ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Lallyport video is relevant to show any
You've already seen this though.
break or planting of evidence. As Miss Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so you can get a clear look.
Why are you doing this?
Of that rear tail like this.
This is just a distraction. This is not. Okay.
Forward, please. Thank you.
Come on, dude.
And then ahead one more. You can see the white light shine.
I want to just reiterate something. I think what he's trying to do here, I think, is he's trying to show that it wouldn't be exculpatory because we were correct about the taillight or whatever, right? I mean, I don't agree. But even if you do agree, remember, there's other things as it pertains to Brady, and that's impeachment. And that's why the thing with Brian Higgins is maybe something that no matter what Brennan says about the taillight or whatever, there's that the Brian Higgins thinks is a whole separate but equal argument from the defense's standpoint of Meg's here, yay, welcome Meg, of the fact that he said he wasn't on the phone, right? And now and maybe that was part of this whole effort to make sure they didn't get this footage, is because they were trying to hide. Like, there's 2 things here that are coming up, right? It's like, are they trying to hide what was going on with the taillight? That's the interior camera. Were they trying to hide the condition of the car? That's, again, interior, but also the exterior camera. But then also, were they trying to hide the phone call with Brian Higgins, they being the Commonwealth, right? Him being on the phone, again, exterior camera. So even if you dismiss the taillight, which I don't think anybody's doing, but that's what Brennan's arguing about, you still are left with this whole thing, because if there's impeachment evidence that's material to the defense, that still counts as Brady, right? So there's 2 different elements you can go with there. And so impeaching Brian Higgins with the phone call, right? That's still a thing, even if you go with what Brennan is saying, which I don't think anybody's going to be doing. I don't even know if Judge Bev's going to go with this. Which is saying a lot for her, right? Meg, did you hear the question? I was just asking because I'm still, or anyone else that's listening to, because again, clarifying, like, when they said they had all the videos, like that came out, like they had all the from the entirety of the car being there. Do you guys remember were they referencing a specific camera, or was it all cameras? Should we go back and look? I can try to go back and hear that part again. See, in my brain, I'm trying to process all this information and understand it, and it's just confusing because of the different cameras. Because again, the reason I'm asking the question is because what still hasn't been addressed is the interior camera. Even if you say, okay, fine, maybe it's always inverted, fine, whatever. But the thing that hasn't been brought up again is the part about people appearing and disappearing, and then the chunk of time missing, right? There's like 47 minutes or whatever. There's a chunk of time missing from the interior footage, and then it like jumps and skips, and then people appear and disappear. Even if you say, fine, the inverted part is normal, whatever. Are you saying roll the tape right here, or go back to the part where they talk about the having the entirety of the footage? Like, my interpretation of that. Okay, they carry backup camera. When you say backup camera, do you mean her car backing up, or do you mean the backup disk drive thing that they were saving it on? Because backup could mean different things there. So my interpretation when that came up about having the entirety of the footage from when the car was there, the way I understood that, and it sounded to me, was like all cameras, right? But the reason I'm wanting to double check is because if that's the case, then they're also missing the footage from the interior that doesn't have people coming in and appearing and like ghosts and disappearing, and also the chunks of time, right? That because that would just be a whole other thing. Oh, okay. The camera in the Lexus when she backs up. Right, I know. That hasn't been talked about that much. I don't know what the deal is with that. I can't even fucking remember at this point. I mean, it wasn't. Did that come up in the first trial? Gosh. They clearly didn't get that much from her car, right? Like than what you would expect, which is interesting. And I feel like I wouldn't be surprised if part of it was whether it was due to incompetence or intentionally, whatever that would have been saved on would have been somehow destroyed due to, again, either incompetency or intentionally when law enforcement was doing the forensic examination of the vehicle data. And remember, because there was a lot of, then you had Trooper Paul, but the tech stream and Jesus Christ, like that. But like, if that's the case, the defense should be, why aren't they'd be, I feel like they would be bringing that up too, right? Like that would be another thing of potentially exculpatory information that is lost. So I don't know why, so if they're not talking about it, I don't know. Interesting. It's a good question. I mean, if it exists, it would be either inculpatory or exculpatory, right? Yeah. Weird, right? I mean, the backing up camera because of this part, but also, of course, obviously at the house. So, yeah, where is that? That's another, we need to keep that. Thank you for bringing that up, Meg. We need to keep that in our minds because it is odd that it's not being talked about. Oh, this case.
Stop. You can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white. The defense position is also contradicted by the AGGRIEVED witnesses. If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36. ADA Lally asks the good doctor,
okay.
Now, doctor.
Actually, Meg, so I just thought about it. I thought, I wonder maybe what if the cameras don't save the footage? You're right that the vehicles do save all kinds of data. I mean, that was huge in Murdoch, right? But then I was thinking about it. I was like, let me just do a quick Google search. So I did a quick Google search and it says, most standard vehicle backup cameras do not save the footage as they are primarily designed to display a live feed while reversing, not to record. They don't store the backup camera footage. Unless the car has an additional aftermarket dash cam system. Aftermarket. So I don't think Karen's, so okay. So that wouldn't exist then, it sounds like. They're meant to provide a real-time view of the area behind the car. Okay. Well, there we go. There we go. I guess that's the answer to that one. I mean, there's still plenty of data that seems to be lost from the vehicle in general, regardless, but the camera, it sounds like, would not have saved it.
course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1.
Now that's one, speaking of the sensors, right? Like that bumping into something, that's something that might be saved, right?
Now, as far, line 2. Now, as far as you're aware from the review and your testing and everything that you did in this
Although
case,
that did come up.
if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam footage.
This is like a red.
Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Lallyport area. If we could play Exhibit 7, which is dash cam footage showing Mr. O'Keefe's car in his driveway
Wasn't
at
this the one?
8:22 a.m.
Right.
If you could
Wasn't this the one where it's like you can't really see it because it's covered in snow?
close up to the
See
court,
it.
please. If you compare
Are
the
you joking me? Are pardon? Are we supposed to be able to see?
right side to the left side, although covered and impacted by snow, if you could close more close up, please, you can see that taillight, just like the detective from Dayton said, just like the 508 ring video shows, is missing. Is missing. There's no plant.
You can't tell if that's snow or not.
The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are 2 videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Dayton in the driveway.
Oh, snow! Wow.
The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for? We can play video 9. And this is when the car is being put on the tow truck before it makes its Canton. And just like 508 in the driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
You cannot.
Can you zoom in on it?
Wow.
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay.
If you look at it on a small screen, see right there?
I do see it.
Yeah, and then you'll see it again. So the alarm.com video contradicts the defendant's position that there is anything exculpatory about these Lallyport videos. In fact, this whole idea of third party or plant doesn't come to town until 9 months after Ms. Reed is indicted.
The thing though, and I'm
Perhaps
remembering
the
this
best-
came up in the trial. The thing that's interesting though is the part that they're trying to say is missing right here, and then also in the previous one where it shows it covered in snow. That's not where it's cracked when they showed the pictures. Do you guys remember this from trial? Where it's cracked when they show the pictures is the red part. It's like on the other part. It's like the front of it, not the side. You guys remember that? This is like a different place. Like if you're picturing, if you're behind a car, right, and you see the taillight and you're like directly behind it, and then you know how it wraps around the corner and then it goes to the side. They're trying to show here it's missing from the side, but that's not like the other pictures from trial was like the where it had like the middle part missing, like the piece missing, right? That was the front, not the side. And I remember that came up at trial. It was like, wait, what? It's a whole different part of the taillight. So
Evidence that contradicts the defense's position that there's any relevance to the Lallyport video, that there's any type of plant by anybody from the defendant herself.
yeah, Meg, I don't think that would get recorded. It was a good question about the beeping, but I'm sure that wouldn't get recorded either. That to me would be in the same sort of realm of like the backup camera. It's just meant to provide a live feedback for the person driving for safety. I don't think that would get recorded. Yeah.
Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen, but it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the Lallyport, so there can be no claim. That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen because of the collateral consequence of tampering with the jury. It would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable the defense motion to dismiss is not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim.
Hold on. This just reminds me of something.
Ordinary evidence. There is no evidence of jury tampering in this case.
On.
There's no evidence of anything in this case.
Sorry.
Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. Then why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. It can be no retort. The government can't respond. No facts, no evidence. Just
no, wait, no rhetoric. Hold on. Is he saying that wrong? Is he? What?
National exposure, and they just seep the information. They just seep it into the public and let it resonate. It can be no retort. The government can't respond.
I think he's supposed to say, I think he's saying retort, actually.
No facts, no evidence. Just saturate the public. Now, it's important to see or hear or read what is said. Because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant.
So Meg's saying from Lexus, the vehicle records and transmits location, driving data, right? That all makes sense. I mean, that's true with most vehicles. And all this came up in the trial. Her location, but the location isn't in dispute, you know what I mean? And I think also the cell phone, you know, they had the location from the cell phone as well, I believe. And if I recall correctly, as far as the location information, it didn't, you know, it showed her like at the house, if I recall, you know, but it wasn't updated like as frequently enough to be like, maybe she potentially could have left. Well, of course, the other thing is this, right? It depends on, you know, it's in dispute, right? As to when John O'Keefe got into the front yard anyway. So, right. Yeah. I mean, but I don't know, but I feel like Meg, I feel like her location, I feel like they had that. Like, I don't know though what that would show. Like the location, I believe is just going to show we know she was at the house, right? And also, hi Kane, welcome back. You know, we know she was, and again, her cell phone, you know, so that's not really in dispute. The only reason it would matter would be like if they could get pinpointed location data, like by the second, to where it's like maybe she left too soon and it was before anything happened to him. But again, then the issue there is like, well, when did the body appear on the yard? And there's not a specific time of death, right? Like, for example, and if it was a different case, right, where they had a really specific time of death, and then you could prove the location data that the person had left the scene before that, like then, you know what I mean? So in this case, I don't think that would really help, because we know she was there, and, you know, because then the only other thing you have in terms of the timeline is well, you have the reliability of the eyewitnesses, right, saying they didn't see a body. I mean, and then you had Sister Nagel saying she saw a blob or whatever. But that I mean, I don't put any stock in any of them, what they testified to anyway. So yeah.
That this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning, not a coincidence. And so during this interview,
he's trying to
that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. Question.
That's okay.
Is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer. I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question. One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury. Not sure where these questions come from. Answer. Right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well in the trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question. Is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
Yeah, agree. There you go, Meg. There you go.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively. The next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, the villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired
Stop it.
state police officers in Massachusetts.
He covered up the whole Sandra Birchmore. You've got to be kidding me. You've got to be kidding me. How is he saying this? I'm confused.
After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They tried to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the pleadings. Counsel was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor. Sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury.
So here's what I think. Judge Bev seems to be really, because she started this whole hearing with this business about Lieutenant Fanning. She seems to really be upset about this whole thing. And then also there's like the whole thing about that sidebar and regarding the invoice and stuff. So again, those are separate from the motion to dismiss. I think it's going to be tough for even Judge Bev to deny at the very least an evidentiary hearing regarding all the Lallyport videos. But I do think that there could potentially be, some sort of sanction, like a fine or whatever, right, on the defense for the candor to the court, or additionally in terms of like what he's saying here, like they're coming out and saying this stuff publicly, giving interviews. It could be the type of thing where maybe, they aren't allowed to give any more interviews until trial, kind of like a gag order, right? Or something to that effect, right? And honestly, I think that's fine. I don't think they shouldn't be taking the time anyway at this juncture. It's 27, or at this point now it's 26 days until trial. They shouldn't be taking the time to do any more interviews anyway. I don't even know that they would. But I think a remedy here would be like, don't talk anymore to the media, right? I mean, I guess in terms of like, is this sanctionable? I don't think so. But the outstanding issue would be the candor to the court as it pertains to paying the bill for the ARCA dudes. And again, that might just result in like a fine or something along those lines. So she does seem to be not happy about this whole thing with Lieutenant Fanning, but that doesn't mean that it will, that doesn't mean that she's going to deny the motion to dismiss, right? Or whatever, right? It's just a completely separate, you know, they brought the jury tampering up in their motion to dismiss, right? But so they raised it as like an issue to support their motion to dismiss. But now instead, the way it's being discussed is the opposite. It's not like, oh, is this actually part of your motion? Instead, it's being talked about now in terms of like, they said these things that aren't true. If that makes, like, you see what I mean? It's been flipped into like, it's just interesting. Instead of supporting the defense's argument, it's now being just talked about and discussed as in, did they violate, you know, an ethical guideline, or did they make false statements and and like, should they be punished for that essentially? Or I guess sanctioned in the sense that like a, you know, like a gag order or something like that, right?
And he had access to the jury. Think about what those statements say to our community. We're going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Super Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat
this is so
of
dumb.
Trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now.
This is just like all distraction from the issues. I mean, this is just so crazy, just going on and on and on about like.
In the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact, Lieutenant Fanning was not in charge of juror security. Fact, Lieutenant Fanning did not have control of the jury. Fact, Lieutenant Fanning did not access the jury. Fact, Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact, Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact, at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror. Fact, no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact, Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact, Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court and is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror. Your Honor, these claims in the motion to dismiss have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
Yep. Look how quickly he
If I may,
popped up. Yes.
Thank you.
Get it. Let's do this. Yeah. All right.
We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. It's words matter. We claim that there's interference. He indicates that that would be an abhorrent transgression
Welcome back, Meats and Seeds.
if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated.
He
In just a
did.
second.
We see it.
Because this is a fact-based inquiry, one that we asked for, standing right over there at sidebar, and didn't get.
Oh,
But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that.
okay. This is important. Let me. Well, I'm going to back it. I'm backing this up so I can hear this because this is interesting. Of course, Brennan would have left this out. Did leave this out. This argument.
I'll get to the facts that he very dramatically stated in just a second. Because this is a fact-based inquiry, one that we asked for, standing right over there at sidebar, and didn't get.
Okay.
But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts.
Yeah.
Facts after facts.
Here's the thing. So far we're learning there's been a number of substantial, like obviously sidebars, right? But there's certain sidebars that have been referenced numerous times in this hearing and previous hearings that seem to have been especially important. There's the one that dealt with the invoice from the ARCA dudes. There was another sidebar. Oh fuck, what was it? It has something pertaining to the Lallyport videos that came up earlier. And now here's another sidebar where they asked for, what was it? I want to make sure I get it exactly. Okay, hold on.
Fact-based inquiry, one that we asked for, standing right over there at sidebar, and didn't get.
Okay, they asked for an inquiry into, I guess he's going to say, I guess this is Trooper or Lieutenant Fanning. So interesting. So it sounds like they inquired or wanted an inquiry and Judge Bev denied it. Interesting. Hold on. Let's see what happens.
But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing.
Literally, what did I say? I was like, this is a distraction. This is a red herring. Yeah, that's
nothing but the highest respect and regard
for
the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't. He also said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, "It's the greatest guy on the face of the earth."
Right.
I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. That's not really the point. It's in the personality contest.
Right.
He said, we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen. When somebody else identified him. Wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal.
Okay. There you go. So that addresses the issue. Okay, interesting. Right. And it was all redacted too. So that's the other thing. Remember how there were so many redactions? So in that case, then a remedy here, if Judge Bev finds there needs to be one for whatever she deems this even is, false statements, I don't know. They didn't wait, hold on. Now I'm back to this. So I'm thinking, so they did mention it. Hold on, let me back this up because okay, Brennan said that they brought this up in one of the interviews. It might have been the Gretchen Voss interview. So that could still be on the table. Let me just back this up again, make sure I can get specifically what he's referring.
Fat, dumb, and happy, not knowing what was going to happen when somebody else identified him. Wasn't us. And by the way, everything that we filed concerning this was under seal.
Okay. So everything they filed concerning this was under seal. And then again, I was referencing the part that was redacted. So that's right. That pertains to the filings. So maybe he's about to get to the part where they brought it up at, in an interview. We'll see.
We didn't disclose anything in any court document. It wasn't a public document. It was under seal.
Thing too.
Mr. Brennan then states that he was also a subject, this person with his unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc. When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before. The question, or questions, if I could, that surround this inquiry, and the reason we included it in our motion to dismiss is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened?
What?
How would they know these things?
What?
How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the...
Okay, this must be things that were in the filing that were redacted. I'm going to back this up because I'm like, what? Hang on. Okay, wow. New information, I believe, because again, there were the redactions regarding this part. Okay.
Who the juror sitting in one of these seats was if she was at a private location. I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people?
Okay, I'm backing up one more time. I'm trying to figure out, are they referencing a different juror or the juror who they thought was friendly to the defense? Because I'm thinking this sounds like a different juror. I don't know. Let me just listen one more time to try to figure out, because they're not being, so he's the reason why it's confusing, right, is because he can't be more specific, right? And so, okay, let's see.
Know who the juror sitting in one of these seats was if she was at a private location. I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who was then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course, it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual courts security, the personnel security, the party's security to whatever degree that is necessitated, but maybe most importantly, the jurors' security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given.
Okay, y'all. What is, so are they saying that at some point, and again, like maybe it's sidebar, like needs to do the same, like, are they saying that somebody was saying there's some jury tampering going on, right? I'm trying to figure out, and this is like, we don't know who it is, right? Some juror, maybe, I guess. And then what they did was this juror reported what they thought was going on to Lieutenant Fanning, and that's how they got here. With like, wait, why are they reporting to Lieutenant Fanning? Like, I don't. Okay. They're talking about jurors at a bar, maybe McCarthy's pro-defense. Okay. Interesting. Wow.
But we do know this. He was this same Fanning that was just randomly picked to go report this to, was also the person that was in Ms. Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet we were denied an opportunity, Your Honor, an important opportunity to simply inquire before this juror was dismissed. That's all we asked.
That was going to be my follow-up questions. I figured, I was like, that must have come from Turtle Boy, because it would have to be somebody local who wouldn't have the scoop. That makes sense.
Get Lieutenant Fanning in here. Let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true. But lo and behold, minutes before I stood up to give my summation, that juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right.
So yeah, you're right. You were correct. It needs to be, was it sidebar? Okay.
There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Lallyport video and how unimportant it is. How unimportant that video is. And I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Lallyport videos if you're investigating a bar fight. This was the purported murder weapon.
I mean, yeah, obviously.
This truck.
Thank you for making
is the thing that the Commonwealth suggests.
Yep.
Was used to kill a cop.
Yep.
You think the video of it being pulled into the Lallyport might be some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality. Oh, but I do know this. I do know this much. One guy who thought it was important, the lead investigator, he pulled it all of it. He was super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years.
Yeah.
Mr. Brennan spent some time talking about the difference.
Are you saying because she's not talking? I mean, yeah, I've definitely noticed, if that's what you're referencing, I've definitely noticed that there's been a couple things. I know you just got here recently. There's been a couple things that like I've been pointing out where I'm like, actually, even early on when it came to this, where it's like, it looks like she's, I mean, shockingly considering her track record, right? But like she sees that this is an issue, and at the very least, like early on, she said something. I don't remember what it was at this point, but like that was like, Oh, now I remember what it was. She was like asking if Mr. DJ, whatever the dude who's retired, if he was available. And I was like, okay, that to me is like she's thinking along the lines of an evidentiary hearing, right? Thank God. So I've definitely noticed things along the way of like, surprisingly, again, she seems to actually recognize that this is problems, many problems, big problems, and we need a hearing at least. Yeah, okay. And just
cracked and missing. Interesting point. Now, I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has very, very good memory. We've never, ever disputed that the light was cracked at 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety, almost, except a piece was still missing.
Right. I forgot about that.
Piece unaccounted for. It's a big difference between a crack
and
the condition of that taillight, which we've now seen.
I had actually forgotten about that. But I mean, I remember that was crazy at trial, right? It was like that was the piece that was missing.
Where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the Lallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Bukhenik, in front of a jury, present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now. I remember it because I was sitting there. He asked the question, did you see, Mr. Probably something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the juror. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of that.
I don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the Grainy video. So, and hey, look, some of these cameras are just grainy in other particulars as well, at other times and places. Maybe, or maybe not. What's interesting is the Grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. That video he just played is at the top. That's the exact same video. If it's apples and apples, oranges and oranges. Why is that different? That's interesting.
Yeah, good point. Good point.
And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Lallyport.
The way Brennan quoted her, Brennan said, she said some pieces. He said some. Now, I don't know. Hold on. Was this from the Gretchen Voss interview? What is this from? Is this the Gretchen Voss or the other recent one? Because I feel like they're saying something different, but they're both trying to quote her. Hold on.
That interview that was played, or I'm sorry, top. That's the exact same video. If it's apples and apples, oranges and oranges. Why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited.
Which one?
She said,
damn it.
Some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing.
Hold on.
It's completely.
So we'll come right back to this. It's 4:58:43. I'm going to jump back to where Brennan says it because that's Interesting. He says it differently, if I recall. I mean, that's what I remember him saying. So I'm just going to see if I can find it.
In the case, he's the one who directed a review of all physical evidence and data files. I would have to guess.
My review at that point. And when he cross-examines Nicholas Garino, he is pretty clear. An enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert.
I think it's right.
Have time to speak about the claim of jury tampering. I understand the temperament of the jury on. That nudging did not cause the damage to that taillight.
Okay, it's right around here.
The defense position is also contradicted by dash cam footage.
Go back a little bit. No, wait, maybe it's after. We're close. We're in the right arena here. I remember this part because I was like, that's when I was like, wait a second. It's like the side versus the front, this part. Okay. And then this is the part where they're zooming in. Let me just go forward a little bit more. Okay.
Driveway.
Okay.
And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been. There's like the bulb is showing.
Here we go.
On June 20th, 2023.
Okay. Gretchen Voss. Now that's what I wanted to know. So it's the Gretchen Voss interview.
And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45.
I'm glad I went back. He says this. Now, it sounds like he's quoting her. Now, my question is this. Do you guys know, like, that Gretchen Voss interview? Because I know there's parts that aren't available. Because I'm like, now, like, should we go and double check this, right? Because hold on, let's listen again. It sounds like he's quoting her and reading from it.
She said, when my car was seized, there was a few small pieces of taillight missing.
A few small pieces of taillight. Now let's go back to where we were with Alan Jackson. I really don't want, I do not want him to misrepresent or whether, right, even accidentally, anything at this juncture, right? Let's not be doing that. And I understand he's got to be exhausted, but this is just not going to be good, right?
Now seen where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah,
right.
It's relevant.
He says,
and it's exculpatory. The condition of that light when it pulled into the Lallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Bukhenik in front of a jury present that video? No, I don't think I have it. Sure, we can get that for the court.
It was right after this.
Also, he played a video of the Grainy video. Showing, hey, look, some of these cameras are just grainy. That video he just played is at the top. With regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said,
all right,
some of the red plastic is missing. Some of the red plastic is missing. In other words,
all right, we're gonna do it. We're gonna find it because one of them is not correct. Dude, all right. Hang on. Did anyone else notice this when you guys were watching it earlier? For those of you guys who watched this already earlier, did anyone else notice this? This is crazy to me. Okay. So it was just a written one, right? Because he says it wasn't played, but I don't think it is like, I guess it might have been filmed, right? But that's not been released that way. Let's just see here. Who did she write for? Boston Magazine. Okay. I'm trying to find it, and everything I'm finding is about this type of issue, but not the actual interview itself, which is wild. Why can't I find the actual interview? Like, what the heck? Okay, I might have found it. Hold on. I think I found it. I think I found it. Let me share this to you guys. Don't make me sign up. Okay, let me see if this is it. Hang on. Okay. I think this is it, guys. So, I mean, yep, Gretchen Voss. Okay, let's just see. This is her just giving background. I don't know that I ever actually read this. I think that I just heard it talked about, so I never read it. Do you guys want to actually read this? It's interesting to see because she's characterizing what happened, right? I mean, it's so funny. As someone myself, right, that doesn't actually watch mainstream media, I don't have cable TV. I don't, whenever, if it's like, if anybody's reporting on this story and they go through like an overview, I skip past it. It's really funny. And my point is like, I don't even remember the last time I saw something that was characterized in this type of manner where it's like a story, because I don't ever go to stuff like this, right? I read the court filings. I watch the shit. Okay. Yeah, I'll go. Let's read it then. Cause this is interesting. It's almost like kind of like the way it's like a movie versus a doc, you know what I mean? Like I don't even watch movies anymore. I just watch trial and hearings, right? So it's like, wow, I forgot that this is a thing. I don't know. Hopefully it's accurate, but it'll be interesting. Like even if it is accurate, just how will they make it jazzed up, if you will, or whatever, you know what I mean? So let's read it. Yeah, here it is. All right. It was kind of difficult to find, but we got there. All right. I'm also pleased that it's not behind a paywall. All right. Snow had just, this is exactly what I was talking about. Snow had just started to fall. See what I mean? I'm like, oh my God, I forgot shit like this existed. Snow had just started to fall as John O'Keefe and Karen Reed stepped into the Waterfall Bar and Grill. See, I'm used to like factual background, right? Anyway, stepped into the Waterfall Bar and Grill on Washington Street, Canton's main drag on a Friday night in late January 2022. At around 11 p.m., it was the couple's second stop of the night after visiting another local pub. O'Keefe, a burly, brown-haired Boston Police Department officer, had been living in Canton since 2014, raising his niece and nephew after his sister died of a brain tumor and her husband succumbed to a heart attack 2 months later. The kids affectionately called their funkle by his nickname JJ. For the past 2 years, he had dated Reed, an equity analyst and adjunct professor at Bentley University who lived in Mansfield but spent much of her time at O'Keefe's helping with the kids. Inside the bar, O'Keefe spotted friends sitting at a high top, oh my God, near the band, and he and Reed walked over to join them. At the table sat O'Keefe's neighbor, Chris Albert, town selectman. His brother, Brian Albert, also a BPD officer who leads the fugitive apprehension team and was featured on TNT's Boston's Finest, and Brian's sister-in-law, Jennifer McCabe. Sorry, I automatically said Jen. All had been raised in Canton, a middle-class town of some 24,000 people located about 20 miles south of Boston, where families' lives and social calendars are often dictated by high school and weekend sports. Accurate from what we heard at trial. That night, as the storm rolled into town, parents in the bar had a pretty good hunch they'd get a hall pass from the typical Saturday grind of shuttling kids to sporting events. As the band played, the mood was festive and upbeat. That was what the testimony said. That's accurate too. O'Keefe downed beers while Reed drank vodka sodas, lots of them. Okay. When the clock ticked to midnight, it wasn't nearly last call. The night wasn't over though. Brian Albert announced he was headed home to have a beer with his son for his birthday and invited the group to join. O'Keefe wanted to keep the party going. Reed, tired, buzzed, and hungry, was less sure, but agreed to at least give him a ride. On the way out, O'Keefe grabbed a half-full cocktail glass off the table, took a slug, and carried the rest of the drink out the door with him. The couple walked over to Reed's black Lexus SUV, leaving foot tracks in the white dusting of snow, and climbed inside. Reed sat behind the wheel, and O'Keefe plugged the address 34 Fairview Road into Waze before they drove off. When they arrived at Albert's home, O'Keefe stepped out of the car. Reed, though, decided to leave. Several hours later, around 4:30 a.m., Reed says she woke up alone in the same clothes from the evening before on the couch at O'Keefe's house. From a living room window, she could see the nor'easter bearing down hard. His niece was asleep upstairs, and his nephew was at a sleepover, but O'Keefe was nowhere to be found. Reed says she thought to call McCabe to ask if she'd seen O'Keefe. Reed didn't have her number, but knew that O'Keefe's niece, who was close friends with McCabe's daughter, probably did. In a panic, Reed woke her up and had her dial McCabe, who had no idea where O'Keefe was either. McCabe, who said she had, McCabe hung up and called Chris Albert's wife, Julie, who lived just a few doors down from O'Keefe, to ask if he had passed out at their house. Meanwhile, Reed called O'Keefe's longtime friend, Carrie Roberts, who also lives in Canton. Neither woman had seen or heard from O'Keefe. Where was he? Reed says she wondered. I'm trying to read it kind of like, like it's like a story. Within an hour, Reed, McCabe, and Roberts met up at McCabe's home, and after returning briefly to O'Keefe's house, piled into Roberts' car to look for O'Keefe. In the back seat, Reed screamed about her boyfriend being missing as the women drove through the pre-dawn streets of Canton, snow swirling and dancing in the car's headlights. On the dash, the temperature read 18 degrees Fahrenheit. That's not too bad. There's the house, and there's the fire hydrant. Now remember, it's so funny because all the pictures make the yard look really big, but we know from people who are local that the yard is surprisingly tiny. As they approached the house where Reed had last seen her boyfriend, she shouted that she spotted him and scrambled out of her car. It was pitch black outside. Now, this thing scrambled out of her car. I don't know. Not that it's that big of a deal, but that's a discrepant. To me, my brain, right, trying to recall back to trial testimony, that to me is not what I recall. I remember it being characterized as like frantically jumping or something, but, scrambled, she says. It was pitch black outside, but on the left side of the property at 34 Fairview, she saw O'Keefe's body lying covered in snow. Reed raced toward him, dropped to her knees beside him, and frantically cleared the snow off his torso. She then lifted both their shirts and laid on top of him, trying to warm his ice-cold body. Roberts, who had run over to O'Keefe's body, cleared the snow off his face. Reed began giving her boyfriend mouth-to-mouth CPR while Roberts administered chest compressions. Yeah, it's just a right. Yeah, I guess you could think of scrambled as being frantic. In my brain, I thought of scrambled as sort of like, I don't know. For whatever reason, I just pictured crawling. I don't know. That doesn't make any sense, does it? That's just what I pictured. Anyway. But yeah. Okay. Administered chest compressions. Blood ringed his nose and mouth, and his right eye was blackened and swollen. O'Keefe's baseball hat and one of his black Nike sneakers were missing. McCabe brushed over with blankets from the vehicle to warm O'Keefe and dialed 911 at 6:04 a.m. As they waited for the ambulance, Reed repeatedly cried out McCabe's name and Roberts' names over and over. Her boyfriend's blood smeared on her face. Soon the police arrived, followed by an ambulance that rushed O'Keefe to the Good Samaritan Medical Center in Brockton. Doctors pronounced him dead at 7:50 a.m. Detectives began investigating, and within days, and that's another thing that's easy to forget. There's so much in this case, right? But it's so sad, right? Because had somebody noticed him earlier, he maybe could have been resuscitated, Detectives began investigating, and within days, Reed was charged with manslaughter on suspicion of hitting O'Keefe with her Lexus. But that wasn't the end of the story, far from it. A year later, the court case would blow up on local news sites and become the focus of conspiracy theories that ignited protests, or ruined reputations, ended friendships, and divided the community of Canton, shredding the social fabric of the tight-knit suburban town. For 3 days after finding O'Keefe dying in the snow, Reed lay curled up on her parents' couch in Dighton, shocked and confused. What had happened to John, she kept asking herself. She missed him terribly, Reed says, and couldn't believe he was gone. She called her doctor and asked for medication to help her sleep. She also located an attorney, David Yanetti, online and retained his services. When State Police Trooper Michael Proctor, a longtime Canton resident who was in charge of the criminal investigation, and his partner later came knocking, she answered their questions. The day she returned to her Mansfield home, Reed says she was in her kitchen talking on the phone with a close friend who lived in Florida when she noticed a Chevy Silverado pickup truck parked in front of her house. Soon, she says, about 6 other vehicles appeared. Then nearly a dozen police officers converged. Crazy, because you know that so wasn't necessary, right? She would have turned herself in, I'm sure. I would imagine. Anyway, can't say I'm sure. At 7:40 p.m., officers handcuffed Reed and drove her to the Blue Hills State Police Barracks. Reed spent the night in the jail until the morning when officers took her to a holding cell inside the Staunton courthouse. Wait, sorry, Stoughton. Why did I say Staunton? Stoughton. It's like if I hear someone say it incorrectly, I'm like, oh, they said it wrong. But see, I guess I've never seen it. I've not seen it written out. So it's so funny. Like seeing it written out, I said Stoughton. Okay. Anyway, Staunton, right? Now I'm second guessing myself. I think it's Staunton. Anyway, okay. Reed says that she and Yanetti stood on opposite sides of the jail bars and reviewed the charging documents. The medical examiner had noted several bloody abrasions etched into O'Keefe's right arm, 2 swollen black eyes. Interesting. Several bloody abrasions. Several. I mean, it's more than that. Anyway, 2 swollen eyes, small cut above his right eye, a cut to the left side of his nose, an approximately 2-inch laceration to the back of the head, and multiple skull fractures that resulted in bleeding of the brain. His pancreas was dark red, indicating hypothermia had contributed to his death. The rest of the information contained in the official reports was even harder for Reed to hear. According to witness interviews, Reed had told McCabe she had last seen O'Keefe at the waterfall, that she and O'Keefe had gotten into a fight and that she didn't remember dropping him off at the post-bar gathering at 34 Fairview. According to Roberts' account, in the charging document, Reed was so drunk at night that she had told Roberts in the morning she didn't remember anything from the night before, though she had wondered if O'Keefe was dead or got hit by a plow, and that Reed still seemed drunk that morning. Before Roberts, McCabe, and Reed found O'Keefe's body, Roberts told police Reed showed them her cracked right taillight, saying she had no idea how it happened the night before. When an emergency responder asked Reed how O'Keefe had injured his face, the document stated, Reed said, I hit him, I hit him, I hit him, I hit him. In addition, it stated that Canton police found a broken cocktail glass and multiple patches of blood in the snow near where O'Keefe's body had been located that morning. The Massachusetts Special Emergency Response Team, CERT, also found pieces of plastic, 2 red and 1 clear, in the same vicinity as the body. Items consistent with broken taillight on Reed's Lexus. The document noted that officials seized the car and found that it had broken glass embedded in the rear bumper. Now remember, that ended up being plastic, but they called it glass. A deep scratch and a dent on the right side of the rear tailgate, and 2 scratches plus some chip paint on the right side of the rear bumper. Considering the evidence, police and prosecutors concluded Reed was intoxicated when she backed up and struck her boyfriend and drove off into the night. In the holding cell, no sooner had Reed and her attorney read the evidence being marshaled against her than a bailiff came for Reed. He led her, wide-eyed and terrified, into the Staunton District Court, where O'Keefe's family and dozens of his friends and fellow Boston cops, including the uniformed BPD Superintendent-in-Chief Gregory Long, packed the courtroom. On the other side of the aisle, Reed's mother prayed as a judge arraigned her daughter on manslaughter charges. Then Reed entered her plea not guilty. And for anyone who's just now joining us, I am fact checking what we heard, what was in the hearing, as it pertains to this Gretchen Voss interview, because both Brennan and Jackson seem to be representing that they're quoting this interview. But what Brennan said was that Karen Reed said that there was a reference to some pieces of taillight missing. But then Jackson, on rebuttal argument, brought it up and said some taillight missing, which is different, right? And so I was like, let's go to the article and fact check it and see what it says. But then it was like, it occurred to me, like I had never read this. And so we're reading the whole thing and we will find the answer as well in here. Afterward, Yanetti told reporters outside the courthouse that his client was in shock and that O'Keefe's death had been an innocent accident. Reed had no criminal intent, he said. She loved this man. She's devastated. Does anybody know who this dude is? I bet somebody does. The one in the middle. He kind of looks like that actor dude. I forget his name. The one who's like a Louis C.K., right? Doesn't he kind of look like that? Okay. or comedian, whatever he is. Okay, it wasn't long before a far more sinister theory of what happened began to emerge. On his drive home after the agreement, Yanetti says he returned a call to a tipster who had previously called his office. A man with a gravelly voice, who initially offered up a fake name, picked up his phone and told Yanetti he recalls something to the effect of, quote, "Your client is innocent. John was beaten up by Brian Albert and his nephew. They broke his nose, and when O'Keefe didn't come to, Brian and a federal agent dumped his body on the front lawn." See, this is interesting because, like, I didn't know any of this. Some of you guys may have heard of this. I did not follow this case at all until trial because of the toxicity that was surrounding it. I didn't want nothing to do with it. And then I heard Yanetti's opening statements, and then I was like, that's it, I'm covering it. So this particular, I didn't know that this tip came in. I didn't know about this. So this is interesting. I'm glad I'm reading it, again, to get to see what was going on that people knew. So interesting. And do we ever know who the tipster is? Did we ever learn that? An attorney in parentheses says an attorney for the man Yanetti identified as the tipster denies Yanetti's version. Interesting. Yanetti didn't know what to think. Was this even plausible? Good question. He thought about the people at the after party that night. Brian Albert, the homeowner, was a prominent Boston cop. There was also a federal law enforcement officer at 34 Fairview that night, Brian Higgins, a special agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, with whom both O'Keefe and Reed were friendly. Given the new information, Yanetti and Reed say they began to believe that Reed was being framed. They hired a private investigator to knock on doors in Canton. Most people turned the gumshoe away, but Canton resident Tom Beatty, a friend of both O'Keefe and Reed, offered up a new tidbit. His daughter, who was friends with Brian Albert's nephew, Colin Albert, said that Colin had been at 34 Fairview Road the night O'Keefe died. When Reed heard this, she says, the news transported her back to a night during the spring of 2020 when O'Keefe's home security alarm went off and he bolted out of bed. Oh, interesting, because this came up in the trial. She followed him down the stairs and says she remembered seeing Colin Albert and several teens in the front yard. "Go fuck yourself," Reed remembered Colin yelling at O'Keefe. "Get the fuck out of here," she recalled her boyfriend replied. The next morning, Reed says the couple awoke to a dozen empty Bud Light cans strewn in the bushes. The police were never called, but from then on, she says there was bad blood between Colin and O'Keefe. Now, I will just say, this is just my personal opinion. There could always be more to the story, but I would not think that one incident for most people would be enough for most people, right? When you talk about an adult and like a teenager, right? Some Bud Light cans in the yard, whatever, like this interaction right here, I would not think would be enough for most people to then cause bad blood, let alone bad blood resulting in murder, but even just bad blood. This just seems like, oh, it's annoying teen. You know what I mean? Like, I feel like for most people, that would just be like, whatever, right? Okay, let me keep reading. In fact, she now adds Colin was the only person with whom O'Keefe ever had issues. So again, I feel like there's got to be more to it, right? If indeed there are legit issues beyond just being annoyed, right? I feel like there was some other stuff with the yard that came up, right? It became like a thing. But like even that whole thing, I know I'm remembering it at trial. See, even all that though was weird to me because I was like, there's got to be something else going on. Because this just seems like, why are adults behaving this way like children? Remember, there was like the thing with the pictures on the fence, and I don't know. It was weird. After hearing that Colin Albert had been present at 34 Fairview, Reed says another apparent clue in the case soon appeared when Reed and her father, William, met with Yanetti in his office. For the first time, Reed saw police photos of O'Keefe's body. She could barely draw a breath, she recalls, waiting until taking the elevator back down to the lobby to break down into tears. It looked as though someone had beat the shit out of him, she says. As she and her father drove home on Route 93, Reed called her mother and described the bizarre injuries on O'Keefe's arm. Her mom suggested that they could have been from an animal. That is really interesting. I didn't know that. Did you guys? Like that's where that first came from, it sounds like. That it was Karen's mom. I mean, I'm not surprised. I think most people would look at that and be like, that looks like an animal, right? It looks like that to me. So it doesn't surprise me, but I just didn't know that it was her mom who first suggested that. Reed called Beatty. Do the Alberts have a dog? She asked. Yes, he replied, a German Shepherd. Chloe. Then 3 months later, Reed says a couple that Reed and O'Keefe had been close to came over to Reed's house for dinner. They had just testified before the grand jury in the case, summoned along with others who appeared in Reed's call log the morning O'Keefe died. Over Italian takeout at Reed's mahogany mahogany dining room table next to a sideboard crowd with pictures of Reed and O'Keefe, one with a rosary draped across it. They told Reed that State Trooper Michael Proctor, a Canton resident and lead detective on the case, had mentioned that he had known members of the Albert family for years. To Reed, that sounded like a conflict of interest. When her guests left, she went upstairs to the bedroom, pulled up her laptop, propped herself against the pillows on her enormous white bed, and started reading through Proctor's publicly shared Facebook page. That led her to Proctor's sister's account, where Reed said she combed through some 1,300 photos. At 4 a.m., she found what she was looking for, a photo taken at Proctor's sister's wedding that showed Colin Albert, the ring bearer, a young Colin Albert. Oh, this came up in the trial. Then Reed found another photo of Proctor's parents and sister alongside members of Chris. So this is really interesting because these came into the trial, and this article is saying Karen Reed was the one that found these, which is interesting, right? Not detectives, not private investigator, not whatever, but Karen did. Reed was speechless. As she sat there on her bed, she says the dots in her mind began to connect, forming a theory of who had really killed O'Keefe, a theory that would prove her innocence. The way she saw it, the bad blood with Colin. And see, this is the thing for me, though. The bad blood with Colin provided the motive for a fight inside the house that night. Now, I don't know. Maybe it's what, as it goes on, maybe she's going to say her theory changes. I guess I could see with what we are reading that she knew so far. I guess I could see that being like, okay, maybe. But at the same time, it's like, I would not have connected those dots. I would not, because to me, the thing with Colin and the beer cans would not be enough. I would not think that could be enough. That's just me, though. That's just me. I don't see how that, yeah. The Albert's German Shepherd also jumped in, which might explain those mysterious arm injuries. Then the parties tossed O'Keefe outside to die in the snow. The tipster's information had already helped convince Reed that she was being framed, but she'd wondered who was pulling the strings. Now Reed says she believed she had her answer, Proctor. Meanwhile, far from coming to the conclusion that someone else killed O'Keefe, prosecutors doubled down on their belief that Reed was the killer. After the grand jury reviewed the prosecutor's evidence and concluded there was sufficient evidence to also charge her with second-degree murder, implying that she'd intentionally killed O'Keefe. On June 9th, Proctor himself, along with several other police officers, walked up to Reed's home and once again arrested her. Because remember, initially it was manslaughter. Reed was now facing a potential life sentence in prison. After posting bail set $100,000, she went home to take a long, hot shower. This is getting real, she thought to herself. The stakes kept getting higher. She knew she needed bigger legal guns to help her. And there's Brian Albert. 2 months later, Reed sat at her laptop, her fingers hovering over the keys. She wanted an eye-grabbing subject line for an email she was about to send to Alan Jackson. So she found Alan Jackson, it sounds like. Interesting. A famous criminal defense lawyer in Los Angeles who once defended Harvey Weinstein and Kevin Spacey. Murder of a Boston cop, she typed out. It worked. Soon after, Reed, her father, and Yanetti all dialed into a conference call with Jackson, who had already received O'Keefe's autopsy over email. As Yanetti summarized the case, Jackson interrupted, "How the fuck are they saying he got these injuries?" Between O'Keefe's swollen black eyes and the gashes on his arm, Reed's boyfriend appeared as though he'd been beaten up before being attacked by a dog, not run over by a car. Reed's lawyers also realized that, according to Proctor's original affidavit in February, 6 months earlier, the lead detective said he'd arrived at Reed's parents' house in Dighton at 4:30 p.m. and towed her car at 5:30 p.m. But the Reed's security footage, as well as the Dighton police report, showed those times were wrong and that Karen's SUV was actually towed closer to 4:12 p.m. That 78-minute discrepancy, Reed and her attorney claimed, would have left Proctor alone with the car with plenty of time to break her taillight and plant the pieces at 34 Fairview Road for the CERT team to find it when it arrived at 5:45 p.m. Jackson officially joined the defense. So this is interesting to me that according to this, it sounds like this entire thing, the theory of like the third party culprits, if you will, right? Or any type of fuckery came from Karen. And it sounds like really it kind of initiated with the whole thing about Colin. I'm surprised to hear that that's kind of the start of all it was with Colin. I would have thought it had something to do with maybe, like, if I was trying to imagine, maybe it was like a dispute between the different law enforcement officers, right? Like, because I've always viewed Colin, this is just me, as like an not accessory, that's not crazy, but like, say, like adjacent kind of to this whole thing, or like a what's the word I'm looking for? I guess adjacent, you know, like not as instrumental to the case. Like, I guess, you know, my mind would have thought maybe it was something like that, you know, he had something else was going on between him and Brian Albert, right? Because we know they both worked at the Boston Police Department. I mean, I don't know. I wouldn't have gone to Colin right away. But again, I'm just saying, that's just me. And so it seems like this really kind of started with Colin and then the beer can thing. And then she found those Facebook pictures connecting him to the Alberts, you know, and then, or at the wedding and all that. And then like, and then from there, you know, so in other words, it wasn't her attorneys, it sounds like, that first looked into this theory. And I'm saying theory because it was Karen's theory to start with, right? Like that's how this started. So, okay. And it's their theory of the case. So it's interesting. And all that led them to all these different things, one after another. Okay, so Jackson officially joined the defense team and began looking for evidence that would back up their alternative theory. There it is, theory, and exonerate Reed. They found suspicious details, such as Brian Albert getting rid of his dog and selling his house in the wake of O'Keefe's death. Still, it wasn't until early March that they found what they considered a bombshell, an incriminating Google search on McCabe's phone, which she had turned over to the prosecution voluntarily. According to the analysis, McCabe appeared to have Googled Hoss Long to die in the cold at 2:27 a.m. the night O'Keefe was killed. That was hours before the three women found O'Keefe in the snow. The same search appeared again at 6:23 a.m. and again at 6:24 after McCabe says Reed asked her to search for it. On April 12th of this year, Jackson submitted a 92-page affidavit to the court laying out the defense team's theory in detail. Reed's attorneys knew it would help their efforts if someone in the media started paying attention to their version of events. That there was more than meets the eye with this case. 5 days later, their wish came true. After multiple news tipsters told him to investigate the O'Keefe murder, Aidan Kearney, a blogger who goes by the name of Turtle Boy, sat down in his Holden home, surrounded by his young kids' plastic toys and board games, and read through the case filings. Both Kearney and Reed's team say they've never been in contact with one another. This is at the time this article is being written, right? So Kearney, the controversial figure behind TV Daily News, formerly Turtle Boy Sports, says he knew immediately this was the kind of story his devoted followers would love. Kearney worked on his piece throughout the night, finishing it at 3 a.m. and posting it under the headline, Canton Cover-Up Part 1. Corrupt state trooper helps Boston cop cover up murder of fellow officer, frame innocent girlfriend. Kearney's story laid out the theory that Reed's lawyers had presented to the court, alleging that McCabe had planted the idea in Reed's head that she might have accidentally run over O'Keefe and implied that Proctor had planted pieces of her taillight at the scene. Karen Reed is a completely innocent woman wrongly charged by corrupt cops who would see her rot in prison in order to cover up a murder of a fellow officer, Kearney concluded. Kearney suspected that as soon as he published his article, it would blow up online, and he was right. His website nearly crashed under the strain of the traffic, he says. Meanwhile, back in Canton, the coverage was about to rip the town in half. The next day, news of the possible conspiracy spread like wildfire, from the deli counter at Shaw's to the links at Brook Meadow Country Club. I don't know what that means. Links? I don't know what that is. Before Kearney's piece, there wasn't much talk of O'Keefe's death beyond those immediately involved. Suddenly, it was the topic du jour, and residents started taking sides. In response, the town's police chief tried to ease tensions by releasing a press statement asking for patience. We have heard the same sensational accounts as our townsfolk, Chief Rafferty wrote. Unlike defense attorneys, prosecutors, and oh my God. Oh God. Okay. Sorry. I thought she was going to say something else, but she didn't. Never mind. Unlike defense attorneys, prosecutors and police are ethically constrained to what can be said outside the courtroom. Kearney had no such constraints. He continued to write about the case, one story after another, as his monthly page. I'm not worried about reading about how much his channel exploded, whatever. Okay, let's keep going. By the time Reed and her legal team arrived in court 2 weeks later, it was clear to Reed that the tide of public opinion had turned in her favor. A crowd gathered outside the courthouse. One person shouted, "Go get him, Karen." Okay. People applauded. Jackson rose and presented the defense's alternative theory, which was essentially what Kearney had posted. The witnesses in the case, those outside the house that night, had hidden evidence of the gruesome events that transpired outside the home, leading to O'Keefe's death. Then their close friend in law enforcement, Michael Proctor, helped cover it up and frame O'Keefe's girlfriend. The prosecutors poked holes in the defense's theory and pushed back with their own evidence against Karen Reed. Meanwhile, beyond the walls of the courthouse, the town's residents were at war among themselves. And I'm going to skip that paragraph. This is a lot longer than I thought it would be, which is fine. But the division and toxicity is exactly why I was not interested in this, so I'm not gonna bother with that. People had beef, whatever. High school students turn on each other. I hate that shit, to be honest with you guys. I wish people didn't do that. Tabloid drama. Incidents involving Turtle Boy. Okay. Vitriol. Yeah, see, this is the stuff I just don't like it at all. Yeah, I'm all good there. Okay. Free Karen Reed. There were people supporters. Okay, so this is just, again, people on opposite sides here. Okay, the prosecution has obvious reasons for wanting Reed's cell phone data. After all, it would reveal or could reveal who she called and texted that night and where she went in the hours before she called McCabe in the morning. This is particularly important because according to court filings from the prosecution, O'Keefe's Ring camera system registered 15 events between 6 p.m. and the night he died at 6 a.m. the next morning. Yet there is no video of Reed's arrival back home that night. Data in her phone could also help explain surveillance footage taken of Reed driving toward the waterfall at 5:11 a.m., away from the waterfall at 5:15 a.m., and then heading toward 34 Fairview before arriving at McCabe's that morning. What was she doing there? Has she already searched for and found O'Keefe's body? That might explain how she spotted O'Keefe in the dark, given the police officer who responded to the 911 call had to use a spotlight from his cruiser to see the woman crouched over O'Keefe's body in the darkness. Even foregoing the missing cell phone data, though, there are some possible holes in Reed's alternative theory. For starters, the thesis that O'Keefe was assaulted inside 34 Fairview hinges on Colin Albert's allegedly... Okay, right, and this is what I was saying. I was like, I don't know about this. Colin Albert's allegedly contentious relationship with O'Keefe. In an exclusive interview, though, Colin Albert told Boston that he walked out of the house at 34 Fairview right when Brian Albert was arriving, said hello, and stepped in the car of Jen McCabe's daughter, who then drove him home. According to the court documents, no one else, including O'Keefe, had arrived by that point. Text messages which Boston has seen confirm he was picked up at 12:10 a.m., and his parents say he was home for the rest of the night, all of which counters the theory that his animosity with Colin led to O'Keefe's death inside the house within minutes of his arrival, and then his friends tossed him onto the lawn in the blizzard to die. Also problematic for Reed's alternative theory is that according to multiple people who know O'Keefe and Colin in Canton, it doesn't seem there was any bad blood between O'Keefe and Colin, as Reed claims there was. What's more, two sources claim the confrontation between O'Keefe and the boisterous beer-drinking teens on the lawn actually involved another teen entirely, not Colin at all. And when it comes to the suspicions raised by Brian Albert getting rid of his dog and selling his house, a source with knowledge of the situation says Albert got rid of the dog after it got in a fight with another dog and had already contacted a real estate agent about selling his house prior to the night O'Keefe was killed. Meg's still here. Awesome. I agree. Also, it needs some Z's that hope the defense. Yeah, absolutely. That they focus more on what, not the who else, but what caused John's death. Absolutely. For sure. Maybe. I feel though, isn't the vanity, is that behind a paywall? I can't remember. Again, it's the type of thing where it's like, people, just like with this article, right? I never actually read it, but like people have referenced it. So I can't remember if I've read the Vanity Fair article or not. I probably did if it wasn't behind a paywall. Okay. There also seem to be some holes in the defense allegations concerning the conduct of investigator Proctor, who Reed's lawyers allege planted the evidence at the crime scene. According to the DA's spokesperson, Proctor's police report listing the incorrect time in Dighton, supposed evidence of his having had plenty of time to plant evidence, was simply an error that was amended in later filings. Scribner's error. Police reports and the DA can also confirm that Proctor was never alone with Reed's Lexus and never returned to 34 Fairview after it was seized. An even larger problem for Reed's defense is evidence that there were microscopic pieces of taillight found on O'Keefe's shirt. When it comes to the timestamp on McCabe's Google search for house long to die in the cold, the state's own forensic experts say the timestamp of 2:27 a.m. was a result of McCabe typing the search bar of a tab that had been opened at 2:27 and left it open. Yes, we know. Okay. Okay, so now they're talking about, they are saying the Lexus that, you know, they states crash reconstruction. Oh my God. Brings ever-changing narrative. The phone shows he never entered the house. Right. Dateline is filming. Jesus, this is really long. Okay, I'm gonna just, okay, 2 sentences story. Interesting. Wait, what? Is that, where's, you gotta be kidding me. Where's the part about the pieces? Okay, hang on. Did I scroll past it? I thought like it just ends there. This must have been before the trial then. Okay. I for some reason thought this was more recent. Yeah. Okay. None of this. Right. Okay. None of this takes into account the fact that prosecutors have evidence which they've yet to currently set. So this is before trial. Okay. This is before the first trial. I didn't actually even realize that. Wow. Interesting. So let me go back and see where it has the part about the pieces. Unless she gave more than one interview to Gretchen Voss. I mean, but I don't think that's the case. Let me do it this way. Okay, so pieces. Planted pieces. Pieces of taillight on the shirt. Huh. Okay. So now I'm going to look for, was there more than one? So they said Gretchen Voss. Unless Gretchen Voss did the Vanity Fair article. Do you guys know? Because that's why I went back and looked, right? Because I was like, which interview are they referencing? And then it's Gretchen Voss. I mean, my understanding was Gretchen Voss was Boston, and I don't know who did the Vanity Fair one, unless Gretchen Voss. Okay, so then let me look for, let me do Taillight. Oops. Because I'm looking for the statement that both of them referenced, right? Okay, it has to be in this article then. This is talking about planted pieces of taillight, right? Pieces of taillight found on the shirt, on his shirt. Look, I don't even see the statement that they're referencing. This is crazy. Okay, hold on. Maybe right here. Maybe this is the part. Reed showed them her cracked right taillight. They're both not saying it correctly, exactly, right? Reed found O'Keefe's body. Reed showed them her cracked right taillight. It doesn't say some of a taillight or pieces. It just says, like, neither of them. Why didn't they? Guys, it blows my mind that nobody bothered to do what I did and just, you know, put this in, quote it verbatim, right? That's what it says right here. I'll make sure this is clear because this is crazy. Like, they both said it wrong. Although in terms of misrepresenting it, honestly, unless it's in, okay, the only thing is, remember how they wanted the extra notes, the reporter's notes or whatever, unless it's in the reporter's notes, which is possible, okay? Because remember, that was the whole thing. But this is what it says here in the article. Reed showed them her cracked right taillight, saying she had no idea how it happened. Maybe it's in the reporter's notes, in which case that sucks because we can't fact check it then. Fuck. But I don't know. It seems like the stuff that was in the reporter's notes would be stuff like, because of the fact that this is even in here, it seems like this is what they're referencing, right? Like, for the whole thing about the reporter's note seemed like it was stuff that was more like attorney-client privilege type stuff or whatever that they were maybe discussing. Or no, that was with the Vanity Fair. That was with the Vanity Fair one, wasn't it? God, now I can't remember. The one where they wanted the reporter's notes. Was that Vanity Fair? Meg says Vanity Fair was amazing. They hired their own PA. That's cool. Yeah, not an exact quote by either. Because the Vanity Fair, like my interpretation of the one that they wanted the reporter's notes from was like when they were on camera and then off camera. Do you guys remember? Oh, they wanted them all. Okay. Interesting. Dang. Let me do a little search real quick here. Let me do a quick search. Okay, no, well, so the just to refresh everyone's memory, including mine, the result of the whole thing about Boston Magazine for Gretchen Voss did not have to turn over her reporter notes. Did not have to turn over her notes. That was the result of that. So there you go. So that's what matters. So that now we have a solid answer. This is because the thing is, like, I'm not going to make an assumption. That's why I was like, let me look for the result here. And I remember that happening recently, but there's been so much happening in this case, right? And it is confusing because sometimes they talk about there's so many different interviews and they reference an interview and like don't specify, right? But just to confirm and reiterate that Gretchen Voss did not have to turn over her reporter notes. So anytime that they reference the Gretchen Voss article, anybody, this is it. This is the article. What I'm going to do is I'm going to put this in the Discord because this is actually really important, right? This is referenced a lot and we can fact check whenever people reference this. So, and you know, all you have to do is Control F. That's what I did, right? I was reading the whole thing and then I realized it was like over and then I was like not expecting it, but then I didn't realize this was from before the trial and I was like, oh, weird. So anyway, but you can do Control F so we can fact check it. So I'll put this in the Discord. And it's good to know that if they reference this, it's literally what we can see, which is nice. It's not like stuff that we can't see, right? So there you go. Reed showed them her cracked right taillight. So they both got it wrong. That is freaking hilarious to me. Yeah, I just couldn't remember. I just couldn't remember because there's more than one thing they were discussing. Like what Needs some Z's say, like it's hard to remember and keep it all straight, right? Because there's the Vanity Fair, and then now they're all, you know, the other thing is now there's that newest interview too. And yeah, so yeah. So anything with Gretchen Voss is in this article that they reference. So Reed showed them her cracked right taillight. So now let's go back. It's nice when we have the ability, though, to have all the information needed to fact check things ourselves, I feel like. So, okay.
To Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the site.
I'm really confused because that's not at all, like that's so different than what, I mean, missing, there's nothing about missing. Like, I'm going to just do another quick search here for missing and just see if like am I missing, speaking of missing, am I missing the part? No, boyfriend is missing. That came missing cell phone data. Boyfriend is missing. Sneakers were missing. That's it. What are they talking about? Like, the thing that's an issue here is how much taillight is missing. That's just not even in the article. That's wild. Let me do a search for plastic. I mean, this is crazy. I'm just trying to be like, am I missing it here? Plastic found on the shirt. They found pieces of plastic in the vicinity of the body. That's not a statement from her. Turtle Boy's kids had plastic toys. That's it. You gotta be kidding me. So I have no idea how they're getting it so wrong. Are they getting it confused with a different interview? Weird. It's weird. Okay. Anyway, as far as it pertains to Gretchen Voss, like, that's now we know. Okay. But yeah. So I just wanted to double check. It's just so, like, it's just so different than what it says.
With regard to the facts that were cited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why's the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's.
Oh, right. I remember this when this happened. Do you guys know, or I heard, do you guys know, hold on. So, does this happen with every feed? Oh my God.
TV. So
yes, advocating for my, that I stood up in rebuttal and said that it was in court advocating for my client. He then said CourtTV is not a courtroom.
So before you go further,
yes.
I don't know if Mr. Brennan was going to give me a CourtTV site on that. Is there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yanetti is referring to that comment that was a court comment. And so I intend on remedying that record.
Is that all that's missing, though? Is just like whatever, it's like 10, 20 seconds or something? Or, well, maybe 2 minutes. Okay, so this needs to be fact checked as well, the CourtTV thing.
Rebuttal and said that it was in court advocating for my client. He then said CourtTV is not a courtroom.
So before you go further,
yes.
I don't know if Mr. Brennan was going to give me a CourtTV site on that. Is there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yanetti is referring to that comment that was a court comment. And so I intend on.
All right, a couple things. So, okay, yeah. So, in other words, they leave it when it's not, when they have technical difficulties, they leave the thing up, like they don't cut. So it looks like it's 1 or 2 minutes. But the hearings, this is almost the end of the hearing. Here's what I want to do, though, because this is just insanity. I meant to do this anyway yesterday because this came up at yesterday's hearing, right? So let's pull this up. The comment about CourtTV. Now, what's crazy is, like, I'm pretty sure she asked for this yesterday and he still didn't provide it, which is what's interesting. So give me a second. And let's take a look here. Again, Brennan not providing like anything to back up anything of what he's saying or doing. No, I mean, it's crazy. So hang on. So let's find that part. It won't take long at all because I remember it was towards the end of his bullshit.
later on February 19th. I gave written notice and called Attorney Yanetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it when the reality is now that that case is closed.
If I may just briefly respond, Judge. I'd like the court to take particular care when we're talking about extrajudicial statements, not to take into account statements.
Okay, so this is, you just find when he brings it up before.
Certainly, the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jeff
Okay.
McCabe is involved.
Okay.
Participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows.
Okay, so just to clarify, this is from the March 4th hearing, okay? This is because they're talking about it again, and it looks like he still did not provide the video interview or anything. So I just wanted to see where this was, because then that way we can find it.
Or reasonably should know, will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. There really is nothing to undo the taint. Violations date back early on in the case.
Okay.
And they continue to this day. Fox 25, defense is quoted, certainly the rest of the folks that were in that house, there's concern about disparaging witnesses, really concerned about the credibility of about ARCA and federal witnesses and what the campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a Barbie, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The defense has not only trampled over 3.6, they've alluded 24. District Attorney Morrissey is well aware he's a target of a federal investigation. 18, 2024, district about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said?
Okay.
Where was that made?
That was made by Mr. Yanetti, and I have a clip of it.
Oh my God.
He also
Oh,
appeared on CourtTV.
okay. So that statement he just said was at a hearing. Okay, so that's fine. But now we're here. Now here's the CourtTV part. Sweet.
Reed. He also appeared on CourtTV with Miss Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is.
Where was that CourtTV?
I can get the date for Your Honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up.
I can get the date. So there's a couple things here. We want to see we want to fact check this, but also she's asking for the date here. Look at this though. He's not providing it. So
I can get the date for Your Honor. Recently, on February 18th, when we were arguing.
So he's not saying it happened recently. Recently is starting the next sentence with something else. So I can get the date. So we don't know the date. She appeared with Mr. Yanetti. I wonder if it's before she had Jackson on then and like on as her team. Interesting. Hold on.
Protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed.
Okay, so now I'm going to look for that clip, but now I'm going to keep this here in case we need to reference it. But now I'm going to go back to the hearing from today where they are talking about this. And she's asking, Judge Bev is asking for the video, right?
In court advocating for my client, he then said CourtTV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a CourtTV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yanetti is referring to that comment that was a court comment. And so I intend on.
Oh, it was a court comment.
I intend on remedying that record. There was also a conversation after with Court TV.
All right, so provide it to Mr. Yanetti.
Oh
Mr.
my
Yanetti-
God, he did it again? He did it again? He misrepresented it again? Oh my God. Did anyone else notice this? Okay, it was a Zoom hearing. Okay. So, oh my God. Oh my God. What? Here's the thing. We just watched it. Remember, he's like, I can't give you a date. Why is he doing this? This is insane. One more time, because I want to make sure this is clear so you can see the weasel activity of it all. Okay. Remember when I said I'm going to leave it up in case we need to reference it? This is exactly why. Okay. Because, and remember how I clarified, because he goes on to the next sentence so quickly that I was like, oh, wait, he's not saying it happened recently. He's starting a new sentence. He's trying to change the topic. Look at this weaseling. This is insane.
Let's read. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is.
When was that CourtTV again?
I can get the date for Your Honor. Recently, on February 18th.
Incredible. And he doesn't get her the date. He just says that, right? I mean, yes, also true. Also true. Wow.
When we were arguing discovery motions, Attorney Little stood up.
Okay, so that's something else. So now I'm going to go back. Wow. So the thing is this. So he didn't get her the date, right? Exactly. No, 100%. He said it that way on purpose. Yep. Totally did. He didn't get her the date. He's not providing a site, right? And the reason is because he knew it was a hearing. Like you said, it was over Zoom. It was a hearing. And now this is just like what happened, whenever that was, the other hearings, right? From like 2 weeks ago or whatever, with the discovery, right? Saying it was like the defense hadn't turned over the discovery, right? And the TUI request and all that. And it's like, I can't believe this. So only because she asked him, he's like, now I'm going to correct the record. Wow. But then he tries to tack on, or he does tack on. He says there was a statement made after to try to make it seem like it's okay. Okay, hold on. Let's listen again. This is crazy. Now, I want to know if that's true. That was there an actual statement after? See, now you see everything he says. Hold on.
I'll have to provide a video. I think that Mr. Yanetti is referring to that comment that was a court comment. And so I intend on
wow.
I intend on remedying that record. There was also a conversation after with Court TV.
All right, so provide.
You intend on remedying that record only now that she's asked you again for the site? Yesterday, she asked you for the date. This is crazy.
I did to Mr. Yanetti. Mr. Yanetti, I'll give you an opportunity to respond.
Hold on, I'm going back one more time just to hear the part about the statement after or whatever.
Provide a video. I think that Mr. Yanetti is referring to that comment that was a court comment. And so I intend on remedying that record. There's also a conversation after with Court TV.
All right.
So it's also a conversation after with Court TV. So he's adding that on to make it, you see what he's doing there. And I remember, so it's funny because I remember Yanetti correcting the record. I do remember that. But then that's why I wanted to double check, because I was like, then why is he bringing it up again today? Right? Like I mean, Brennan. Like, why is he bringing it up again? Like, why is it coming up again? So I figured it was something different. I assumed he's oh my God.
So provide it to Mr. Yanetti. Mr. Yanetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me
Well,
what you
it's
want to tell
just
me
that
now.
right now it's out in the court of public opinion that I made this extrajudicial statement.
Right.
I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was
right, and that's exactly what it is. Right.
No CourtTV interview where I said anything of the sort. That was a Zoom hearing. Excuse me, where I was arguing before Your Honor. You know, I would just note, Your Honor, you know, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable.
Right.
You know, it's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds. That
You can take your time, Mr. Yanetti. You're not going to be
well, we're all
35 minutes.
Right. I certainly will not be. You know, this new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a site, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly, which is wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a
I'm pausing it because I'm pulling up. So I'm going back to the part that was missing. So I'm just going to pull up. Let's see if this doesn't have the same issue with the missing chunk. So it was right towards the end of the Commonwealth's argument, and it was right at the beginning of Mr. Yanetti's rebuttal. So let's just see. Or no, maybe it was, sorry, it was the end of, hold on, let me just double check. Where was it? It was, no, it was during Alan Jackson. It was during Alan Jackson. And then when it comes back, it's Yanetti. Okay. So now let me just go back and find that on here. So Alan Jackson, and then it switches over to Yanetti, and right in between, like a couple minutes. Okay. And actually Brennan talks, it looks like, in between. So I'm glad. Okay, we're just going to make sure we don't miss anything here. Let's see what happens if it's from here, if this is the right spot.
Consistently, that is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion?
See, I don't think we heard this. So this, I'm glad we missed some of this. And it's like the end of his argument too. So we're going to just make sure we don't miss anything. And yeah.
Was unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing. Why is the first time I'm hearing about this when he stands up and tells us?
No, that's absolutely Meg.
That has been the
Meg, absolutely. He definitely thinks Meg, or he definitely thinks Bev will let him get away with it. That's 100% true. That's very clear. I mean, you say it's just your opinion. I appreciate you saying that, but I think that is accurate. I think that is factually true. Yeah.
Pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion?
Right.
Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's irremediable harm. Irremediable harm. This case should be dismissed because of the conduct of the Commonwealth, including Michael Proctor holding onto those videos, hiding those videos, and then others involved with strategizing how to use the videos against us, against the defense, in a murder trial without our knowledge and without giving us the videos. But if the court, in the face of all this, determines that it's either unconvinced at this juncture to dismiss this
Evidentiary
case,
hearing.
urge the court to have an evidentiary hearing. That's what this demands at the very least.
I agree.
An evidentiary hearing so that the court can perfect the record. We shouldn't be guessing at things. And I'll submit.
Okay, there we go.
Mr. Brennan?
No, thank you.
Mr. Yanetti, do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right. I know you want to do your motion, Mr. Alessi. I cannot imagine that you can summarize it all in 10 minutes, can you?
I cannot, Your Honor.
Okay. So I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
I will.
I mean, your pleadings are very thorough.
I will do so, Your Honor.
Okay.
That's crazy. The next hearing is not until the 18th. They're supposed to start trial on April 1st.
Not yet.
Here's the thing. And we're just going to watch it from here because we, again, the other feed cut out, but we saw like, I don't know, 30 seconds or whatever of the part. This part was still cut out. But anyway, look, thing is this. If they're going to have to do an evidentiary hearing, which they need to, this throws a whole loop in like the April 1st date. There's just no way. And she's still saying, like, I'm in shock. She's still saying, I'm not going to see you again. Hold on.
I urge you, Mr. Alessi, to...
Your Honor.
Okay. Summarize it all in 10 minutes, can you? Follow up, Mr. Brennan?
No, thank you.
Mr. Yanetti, do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right. I know you want to do your motion, Mr. Alessi. I cannot imagine that you can summarize it all in 10 minutes, can you?
I cannot, Your Honor.
Okay. So I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
I don't even know. I feel like, okay. Part of the thing when I was saying, we were talking about how like that in terms of the candor to the court regarding the ARCA dudes and the invoice and all that, right? It's like, one of the main reasons why I was saying I don't think she's going to remove anybody from the defense counsel is because it's like she would have to change that date, right? The April 1st date. And, we're trying to push towards trial starting, right? If she has to move the date out anyway, because now they're going to do an evidentiary hearing, I mean, you see where I'm going with that? Like, this is really crazy. I don't see how she cannot hear this. There has to be an evidentiary hearing. There has to be. But my point, I guess my brain is like, whoa, the implications of this are a lot of them, right? It's like, but the reason it's weird to me is this. Because of this statement where she's like, to condense your argument. That makes me think she still thinks they're pushing for April 1st. Y'all.
All in 10 minutes, can you?
I cannot, Your Honor.
Okay. So I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
I will.
I mean, your pleadings are very thorough.
I will do so, Your Honor.
Okay. Not yet. So I gave the parties until, instead of Friday for all the motions in limine, next Monday is fine. But by the following Friday, I want any responses, oppositions, any responses to the other side's motions. And then we'll have a hearing on the 18th. Jim, did we put aside any other days as well?
We did, I thought.
This is crucial. What's she going to say?
Just a sec.
She does.
Yeah, we did 18 and 19.
That's what I had, yeah.
That
I would expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here. All right. All right.
I mean, the fact that it's like, okay, there's so far, there's no mention of an evidentiary. There's not like, can we take a look at dates? Like, in other words, the way that she's acting about this, like nothing's changed. Like she's acting like nothing's changed, right? Okay, we're going to wrap it all up. Be quick with your arguments. We got 2 days and then trial starts. Yay. Either can mean one of two things. She already knows she's just going to flat out deny the evidentiary hearing and they're just going to move forward to trial. She's like, whatever you said was bullshit. Like, you know what I mean? It's either that or she's like, maybe she's going to flat out dismiss it. Like to act like nothing's changed is very interesting, right? I understand. I mean, but we know she never rules from the bench, obviously, but this is scheduling. And if something's going to change to the schedule, they need to talk about it. Trial starting in 26 days, or we're supposed to. I'm shocked. It's going to be one or the other. It's going to have to be one or the other because they're not discussing making any changes. So if there's any changes, like for an evidentiary hearing or whatever, she's just acting like everything's normal. I'm just shocked.
Yes.
Fox 25 produced the materials at the beginning.
Okay, now here's this part.
To see if I could get a copy. It's on a hard drive. I can't simply look at it in the clerk's office. I would like permission from buyers to be able to get a copy of the hard drive, or if I can get the hard drive and make a copy and return it.
Does the defense want a copy as well?
Yes, Your Honor.
All right, so you can make copies.
I'll make 2 copies and then I'll return the originals to the clerk.
Okay. All right.
Just before you leave the bench, Judge, I do not want the court to decide that motion for sanctions until I just supplement the record. I could do it in 3 minutes, and if
Go ahead.
you can cut me off.
Go ahead.
Thank you.
Go ahead.
That's what she
Just
said.
briefly, Judge. Yesterday, Mr. Brennan represented to this court that I had made an extrajudicial statement regarding Mr. Morrissey and the federal investigation. You'll recall that I stood up in rebuttal and said that it was in court advocating for my client. He then said CourtTV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a CourtTV site on that. Is
Right.
there one, Mr. Brennan?
Mm-hmm.
I'll have to provide a video. I think that Mr. Yanetti is referring to that comment that was a court comment. And so I intend on remedy that.
So I want to hear this again. But the other thing that's so interesting, that's wild, is at the beginning of the day today, that comment she made about is Mr. DM Jigo, what a dude, right? Is he available right now or something along those lines? What we're going to do is this, guys. What we're going to do is this, because we're almost at the end of this hearing. We're going to finish out this hearing, and then I want to go back and do 2 things real quick. I want to hear her comment that she made about Mr. What's-His-Face being available, because that was like, why would she ask that? Like, available for what? If your court day's already, you've got 1 more hearing or whatever, 8, maybe 2, like, it's for the motions in limine, right? So, like, you can't just, okay. It's just odd. It's like, why would you ask that question if you're not thinking about a date to bring him in, right? But anyway, so we're going to hear that. We're going to finish this out. We're going to listen to that. And then what I want to do after that real quick is go back to the parts I was referencing where they are talking about the video footage and I'm just thinking out loud because there's like, so I just have so many questions, but like trying to clarify when Alan Jackson is talking about the footage that they had the entirety of, did he specify which cameras? So we'll finish the hearing and then we'll go look for those 2 little things real quick. I think I'll find them pretty easily at this point. So yeah.
I'll have to provide a video. I think that Mr. Yanetti is referring to that comment that was a court comment. And so I intend on remedying that record. There's also a conversation.
Thanks, Meg.
All right, so provide it to Mr. Yanetti. Mr. Yanetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me
Well,
what you
it's
want to tell
just
me
that
now.
right now it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor. I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds. That
You can take your time, Mr. Yanetti. You're not going to be
well, we're all
5 minutes.
Right. I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, the lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a site, then I need you to.
That flat out fucking lie from her right there, by the way. I'm sure you guys know. That pisses me the fuck off. You already haven't been. That's disgusting.
Let us all know that as well.
I mean, if there's any truth to that, we already know she's so biased. But even if she wants to just pretend like there's truth to it, even just from what we just saw with him today, Brennan, with this just last bit about I intend to correct the record, he needs to be filleted like a fish. Like, I don't even have words. Like, at least he's the Commonwealth. Are you joking?
Convenient to retort that they were 10 lies by the court.
Just pick anything he says. The vast majority of what he says would rise to prosecutorial misconduct, like in any court apart from this one, and maybe like Judge Gull's court, and then maybe there's maybe a handful of other exceptions, right? It's like, but there's just one after another after another.
So, Mr. Brennan, if you do not have a site, then I need you to let us all know that as well.
Well, it's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly were just wrong. I didn't cite a champion today. It was part of advocacy. And there was a conversation. And if you remember, when I related Ms. Yanetti's remarks, it wasn't in relation to 3.6. It was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide.
For your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It must be related to that point, not 3.6. But I will provide the videos. Mr. Yanetti is right. The exact statement that I used was from a court hearing, but then there were subsequent statements made. So my regrets to Attorney Yanetti, but it wasn't action of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials.
He keeps mentioning the subsequent statements without saying what those are. This is so stupid. And the only reason he's doing that is to make it seem like he got confused, right? Because if the subsequent statements were something else that could have violated the protection order or whatever, right? Then he would be referencing those, right? In other words, the statements that were supposed to be the problematic were not, because they were in a court hearing, right? And then he's like, but now he said it twice that he made subsequent statements after. But that's all he says. He doesn't say what they are. He doesn't include them. That would be your opportunity, right, Mr. Brennan? If he said something to Court TV after a Zoom hearing and he said something he wasn't supposed to, why wouldn't you reference it? So the only reason he's mentioning it is to try to make it seem like he got confused. And he said it twice now. Look at his hands on the table. Can you guys see his hands on the table? It's very interesting. There's I feel like he's almost starting to worry he might get in trouble, but not nearly as much as he should be. What do you guys think? This is fascinating. The way he's trying to couch this to both maintain that he was correct. He's trying to do both at the same time. He's trying to make it seem like he was correct all along, but also that he's being candid to the court by correcting a misstatement. But he's trying to still maintain that he's correct, even though it was a misstatement. This is insane. And so, and he's also simultaneously, in a way, trying to apologize, essentially, right, or whatever. Admit he was wrong, but he can't admit he was wrong. Like I'm saying his personality, right? He should, like, obviously, it's like his ego or whatever, right? Like, it's crazy. It's crazy. It's crazy. Yeah.
And I accept that. There was a conversation, and if you remember, when I related Ms. Yanetti's remarks, it wasn't in relation to 3.6, it was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide.
Or your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials in order to seal that couldn't be rebutted to make suggestions. It can be based at that point, not 3.6. But I will provide the videos. Mr. Yanetti is right that the exact statement that I used was from a court hearing, but then there were subsequent statements made. So my regrets to Attorney Yanetti, but it wasn't in fact a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site, I'll give you until tomorrow afternoon to find the CourtTV site.
Very well.
If you have it, supply it to all, Mr. Yanetti. So I'm ordering the Commonwealth if they have that CourtTV site to provide it to all of us. And if you don't, provide that as well. Provide that information.
Thank you.
Thank you. All right. That's it for today.
All right, so what, please?
I'm going to look for that part as well because I want to see what they said after. So now we're going to go back to the part where the initial. This was a lot. I feel like I do want to watch a couple things through here. I'm glad Meg was like, take your time, because there's things that, are going to be different going back through. It's funny with hearings. It's not always like there's some hearings, y'all know, right? Like, for example, some of the BK hearings, right? It's like, how many times have we gone through some of those? I mean, we as a channel and individually, right? Where it's like, you feel like you should almost have the hearing memorized, but you still need to go back and like double check something. I mean, right? That's not usually true with other cases that the hearings are so like, you keep going back. Anyway, my point being, the hearings today and yesterday, I feel like but especially today, I would say, I feel like these are exceptions to where it's almost like a day in trial with like really key testimony where it's like, hang on, what? Because there's so much information, but there's also so much going on. And there's like a lot. So, yeah.
You were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported.
Oh, right. So I forgot that the other feed, it's so funny. So the other feed is the one that has the beginning of the hearing. Okay, hold on. Let me go back to the other feed. And this one has the ending part. We might be able to just use the other one, I think. What are we doing? Hold on. Okay, hang on. Let me pull it up, guys. Oh, why did it? That's weird. It's not showing me on the thing. That's so funny. StreamYard's doing a whole lot right now, changing things around, and it's full of surprises. Okay, I'm pulling this one back up. You guys have I guarantee you'll hear this from other channels. I guarantee you, because there's just a lot going on with StreamYard. It's really funny. Okay, so let's do this. Back to this one again. Okay. Right? I know. Same. Backtracking Brennan. That's a great name, Meg. Bullshit Brennan. I mean, we could have fun coming up with some nicknames for him, right? Dude, that's a great idea though. Okay, and what's helpful here, this CourtTV one has got some timestamps. Now they're not always accurate, but it is at least helpful because for me, it's like even just seeing that there is a segment. It's like I have like a really good memory for like, well, y'all know for different things, but one of them is like, I remember how far I clicked from like a segment versus just the whole thing. Anyway, so, okay. So we're going to go back to, do we have closed captioning? Yes. Okay. So we're gonna go back to because again, it's so funny, right? Because the other feeds didn't have cameras on. This is the earliest one with cameras. So
Ordinary governmental misconduct, a true and correct, to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state is fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that. And I'd like you to stop.
And this is exactly why I said he's still in hot water for this issue too, because she's saying he represented something and he didn't have a good faith. Like this is big, right? She's saying this thing is just simply not true. You need to have a good faith basis. It's going to come down to when did they learn about it. So like, this is just a lot to digest because each one of these, all the things that are happening have like big implications, right? And there's a lot on the table. Ugh. Stressful.
It's simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that. And I'd like you to start there.
If the court recalls the discussion at sidebar, we were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that because that was the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay.
And here's the thing. So remember, this has come up, but I and probably anyone else watching didn't have the context for what the hell they're talking about, because we get that more information at towards the end of this hearing, right? And that's why I was so confused with the whole juror misconduct thing. In fact, I didn't read all of that when I covered the document because a lot of it's redacted, but I was like, this is not going to go very far. And I just was saying that because it's like, it seemed like they were just sort of saying they're making like a boilerplate type of argument, right? Anyway, I just okay, let's
about
watching it.
This issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that because that was the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously
You were not, just so we're clear, you were not told that by me.
No, we were told that by, I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury.
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror.
Hold on a recording of what? What is happening? Hang on. The other thing, okay, hold on. Do you guys remember
that Lieutenant Fanning had reported this?
the thing that has been coming up in my brain, but I can't remember anything specifically about it. I don't remember where it was, if it was in a hearing. Okay, one of you guys will remember, I'm sure. It came up at some point in time, briefly, fleetingly, that there was something about Judge Bev following the jury home or something. Do you guys remember that? It was like, oh, what was that? I honestly, it's like there's just been so much. I can't remember what it was from or when it was. But I remember being like, what the fuck? And then I feel like we never learned what the fuck that was about. But one of you guys, I'm sure, will remember, because that was crazy. It was like Judge Bev followed the jury or a juror or did something with a juror. And I was like, the fuck? Because I have questions, because that seems like it could. Okay, you never heard that? Interesting. Need some Z's or anyone else watching? I mean, I don't think I dreamed it. I can't say that it's out of the realm of possibility, but I'm pretty sure I didn't dream that. Pretty fucking sure. Unless it was in Delphi, maybe was it Judge Gull following juror? Maybe that's the only thing I think of is that I got it confused with Delphi, because those are the only two judges who would have. It had to be one or the other. That'd be the only thing. Did that happen with Delphi? Did I dream this? Oh my God. Yeah, I believe you guys if you say you didn't hear anything about that. Interesting. Weird. I'm trying to think, could it have been any other case? I feel like that happened though. Sometimes this will happen with my dreams, and it's really funny. I was just referencing this. I don't even remember one just recently about how like I'll have these dreams and it's like something and then I'm like, I think it's like something as if it don't really I don't realize it was a dream until it's like it seems like a memory. It's like a memory, right? So I don't realize it's a dream. It seems like a memory of something that happened, and then whatever's in the memory, and then it's like, oh, it hasn't happened yet. I must have dreamed it. But then it's funny because what happens sometimes is then the thing ends up happening anyway. So, okay, interesting. Gull had dinner with the jury. I specifically remember it being something like they drove them or followed them. I feel like she shouldn't be having dinner with the jury, but I don't think that's what I'm thinking of, because I remember in my brain, whenever this thing happened, there was like imagery. I got imagery of like driving. That's y'all. It is. Yeah, at least I'm not alone. Heather, I don't know where Heather went, but she would be like 100%. Heather, if you're listening on Replay Crew, I wonder if did you have the same dream? Or if it's a dream, I don't even know. That's really funny that you guys can relate though. Okay, well, all right, I'll table that. We'll table that. And because I was thinking, well, maybe that's related, but it's not, because it's apparently not a thing, at least not in this case. And maybe not even anywhere, because maybe it's a dream. But you guys, if it happens in a case, you heard it here first. Wouldn't be the first time.
Based on a reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember. No, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does
at
not
sidebar.
say he has access to or control over the jurors.
It says that
And
he
I'm
has.
just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yanetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us, we were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar
No.
that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations
Oh,
of the
dear.
court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time.
I mean, we watched this, but I don't even, it feels like, it feels different. I guess I feel like I'm watching it for the first time in a way because now there's more context, but she has the transcript. That's why this is wild, right? She has the transcript.
In good faith, both Mr. Yanetti and I asked the court to take evidence from Lieutenant Fanning.
I think it was Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue. So I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues.
Right. It was at sidebar. Right. But she keeps saying she has the transcript. So it's another one of those things where it's like the fact checking, right? It's like if he's misrepresenting. So she's like, I have the transcript and what you're saying is wrong. That's what, like, and I don't even remember what the comment was that he said. But it seems like it's like, what was the title that he was told of Lieutenant Fanning? And that's the thing that's at issue here.
That he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Yanetti and I asked the court to take evidence from Lieutenant Fanning.
I think it was Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me
I
to.
didn't go back for it.
He wasn't. Again,
You were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told
I have the transcript.
of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the.
This is important, right? What the thing that they're talking about is, was he told that day? Was Alan Jackson and the defense team, were they told that day at sidebar? This is apparently closing arguments now where we learn that later, that he was not directly involved with the jurors. Or was it later? Because they're trying to figure out when sorry, no, this sidebar would have been more recently. Because this is all about, did he have a good faith basis to put this in the pleading? So it's when did he find out that he didn't have, because the whole thing is this, what Alan Jackson is saying is he's got this title called commander, and that would be reasonable to be like, yeah, he's a commander, so he's in charge. Okay. That means he could have had contact with the jurors. But then if somebody says, oh, well, I know that's just a title. It's just a title. He's not there. He has no contact. That's not allowed in mass, whatever, right? And that he has no direct contact. And then if you're told that, right, then you can't then also make the inference, well, he might have contact. You see what I mean? So it is reasonable to think, well, he might have contact. He's called a commander. That's reasonable. But then also if somebody says, no, that's just a title. It doesn't mean anything. He doesn't have contact. You see what I mean? So it does matter when they learned that information. Now what's happening is Jackson saying they didn't know it. And at the sidebar, and she's saying you were told that at sidebar. It's in the transcript, and I have the transcript. And this is odd because it's like, fuck, hold on, dude.
Of the extensive security operations in this case, it is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar
No.
that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the Extensive Security Operations of the Court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time.
Okay, so what it is, so I'm going to clarify there. So in other words, they were told he was a commander. And he's saying, okay. What she's doing is she's making a leap there, say you were told he's a commander and you should know that a commander doesn't have any direct interaction. So Judge Bev here, sneaky weasel, sneaky snake weasel, smooth activity because yeah, wow. She tried to make it seem like he was given that direct answer about the contact, but they weren't given that. They were just told what his role was. And that's why she says earlier, like, or maybe she hasn't said it yet, I can't remember now, but like Mr. Yanetti is like, she's like, Mr. Yanetti knows that a commander doesn't blah, blah, have any contact, right? That's different than being told.
In good faith, both Mr. Yanetti and I asked the court to take evidence from Lieutenant Fanning.
I think it was Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue. So I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we didn't know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case. And he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly. I take
So
the court
we
at its
will,
word.
we
But
will
the-
move on from that, Mr. Jackson. We'll move on from that.
Okay.
So
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason, because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case. And he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly. And the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror? That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
all right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
Well, hold on. I was gonna say something. I'm gonna go to where they come back, and then because they follow up. They say something, they follow up on it, and then they segue into the motion to dismiss. So, and then I'll say what I was gonna say.
Thank you for that. The court invoked Mr. Yanetti and said, as local counsel, he knows this not to be true. Mr. Yanetti just indicated to me that that's not quite the fact. And so Mr. Yanetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yanetti. So if the court would allow Mr. Yanetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
I'm happy to, Your Honor, and thank you for giving me the opportunity.
If we have time later, and they don't. Wait. Did they come back to it? I mean, the witness thing, it comes up later, but I don't feel like it's with Mr. Yanetti. Did it come back with Mr. Yanetti later? I mean, I remember Mr. Yanetti talking, but I feel like that was with. Okay, so hold on. Before I get into that. So, So Mr. Yanetti doesn't necessarily know. Okay, hang on. Interesting.
Mr. Yanetti and said, as local counsel, he knows this not to be true. Mr. Yanetti just indicated to me that that's not quite the fact. And so Mr. Yanetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yanetti. So if the court would allow Mr. Yanetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
Okay, so here's what's going on here, I think, personally. So this remember, their motion to dismiss the indictment, right, had different grounds. Most of them had to do with the Lallyport, but they also had this grounds of jury tampering. Okay, what does that mean? And the reason I'm saying this is there's a reason I'm saying this, because we have to remember the context of what is happening here. So if they are asking for an indictment to be dismissed because of jury tampering, right, they would need to have something to substantiate that, right? And again, a lot of that was redacted in the filing. And I would imagine that what they probably referenced was what we've heard a little bit about, which is like the talking to that juror, maybe, and, whatever, right? And then, of course, we know that the involvement into the case, but really it's the juror, it's communication with the jury that matters, right? If you're trying to establish jury tampering. And so there's, in terms of the proof, there's kind of two things going on here. There's the one thing is like proof that he could have had communication with them, right? Because what Judge Bev is saying is like, you know, well, at first she was like, but you know, he didn't have didn't have the ability to have communication or contact with them. And then he's like, no, we don't know that to be true. And then she's like, but you have nothing to prove it, right? And he's like, well, we can't prove it or disprove it. And so to the extent that it's like, well, where does that fit in? So once he says that to me, they can't prove it or disprove it. When it comes to something like a motion to dismiss for jury tampering, right? That's why that will not be grounds, right? Like that's why that will not be, if she dismisses it, right? If that happens, it's not going to be for the jury tampering, because in order for that to be the case, they would have to have some sort of proof. And compare it to Murdoch, for example, right? There would have to be something to substantiate it. So to say, well, we don't have proof one way or the other, normally that would be something where it's like, well, now we need to have an inquiry, right? Because we don't know about whatever it is. That would be more like something like a request for discovery, maybe. But it wouldn't be like, if you're already like when you're moving to have something dismissed on any type of ground, it's like that means you've already that's at the ending. That's like the end result, right? In other words, it's like, it's not like we want to learn more about this. It's like you're already alleging that this has happened, as if you have the proof already. So you see what I mean? So in terms of where it matters, when he says, well, we don't know one way or the other, we don't have proof that he did or proof that he didn't. The reason that matters is because essentially it sounds like they're almost in a way, by they, I mean the defense, kind of conceding that maybe this was not the strongest argument and maybe they would not have even included it, right? It sounds like maybe they had a sidebar after it was filed and then they learned more information. Jackson even said they learned more information from the the Commonwealth's response, right? Maybe they wouldn't have included it, right? If they had that information at the time. So we morph from, is this grounds for a motion to dismiss, into, we've morphed from that into more of like the defense being on the chopping block from Judge Bev of like, did they have a good faith basis to put that in a filing? Because, and this is what I was going to get to here, is I think a lot of this has to do with Judge Bev's bias, and she would love, I think, to be able to put sanctions on the defense team and the Commonwealth. There's on the table, there's a motion for sanctions, right? And what are those sanctions for? Well, we've heard a lot about that, right? And so to me, I think the reason why this is coming up so much, and now it's in a completely different context, right? Like they're not arguing about this issue in the context of, is this grounds for dismissal? That's not even what it's about anymore. It's about candor to the court situation, right? So it's like, in other words, the Commonwealth would like to say that they only put it in the pleading, right? That they only included it in the pleading because they wanted to give misinformation to the public, right? That's kind of what I'm paraphrasing, but that's the long and short of it. Judge Bev would like to be able to side with them. I think that's my personal opinion, or and to use it as some other grounds to silence them or whatever, right? Impose some sort of sanctions, whether it's through gag order, you know, this was discussed, I believe, yesterday, right? Or like whatever, they can't put their filings public or whatever the case may be. And so part of it, right, if it's an illegal filing, that's one thing, but like that's where the good faith basis comes in. So instead, now it's no longer part of the motion to dismiss. It's morphed into supporting the Commonwealth's motion for sanctions, but it's being morphed by Judge Bev, who's asking them about it. It's kind of crazy, right? And so that's where the good faith basis comes in. So now when they're saying we don't have evidence to prove that we knew this, or that we don't have evidence to prove that there was jury tampering or that there wasn't jury tampering. It could have happened, right? Again, that is not a standard that we're talking about at all. We've moved away from this being the grounds for dismissal, right? we're talking about when they may put that into the pleading, was that on a good faith basis or not, based on what they knew at the time? And what did they know? First of all, what did they know at the time, right? That's what this is about. Because my interpretation from what I'm hearing is that the defense is still holding firm that they had a good faith basis. I believe them on that. But I do think that they're conceding that based on what they have learned after the fact, I don't think they would have included it in the motion. Because again, the burden is different, right? It's if you're going to include that in a pleading, it's not an inquiry, right? It's not like we need more information. It's like we have the information and here's what supports it, right? So the thought of like, well, maybe he did, maybe he didn't, that wouldn't be good enough. You wouldn't put that in a pleading. Now, here's the other thing. I don't even know why they bothered with it, because you know what? It's not necessary. Unless they had, like, I can't even think of an example where there's such obvious jury tampering with like proof to back it up. I can't think of many things. Let me take that out of the picture. Forget the jury tampering. I can't think of many things that would seem like as good of a grounds for dismissal than what we've seen in this case with the Lallyport videos. That is enough. That's more than enough. It's more than enough. That's the thing. So does that make sense? Like, that's why I was trying to go through this in my brain, like step by step of how I'm thinking about this, because it's like not even, who cares, right? Like, unless you've got proof that like a juror was like threatened at gunpoint by somebody, you know what I mean? Like it's going to be hard to talk. And you always want to you want to rely on your strongest argument, right? When you include weak arguments, it actually diminishes the strength of your strong arguments. And the Lallyport videos is more than enough. So I think that that's part of also why I'm interpreting this as like, they maybe would not have included it in the motion to dismiss, because it was iffy anyway. It was iffy anyway, I think, because, and it wasn't necessary, but then it's morphed into this other thing of like the good faith basis. And again, my interpretation of this is because Judge Bev would like to find that she would like to grant the motion for sanctions, is what I think is happening here. And like, for example, if she finds that they did not have a good faith basis, like the way she shuts it down, right? She's like, well, I don't like your answer. I don't want to hear from Yanetti, right? All that, the end of this exchange that we watched. Before she moves on to the motion to dismiss, it's clear that she wants to find a certain way in regards to that. Now, is it the end of the world? No, because again, I don't think their case wasn't going to get dismissed based on that anyway, right? I think that she wants to be able to grant that motion for sanctions and then be able to do something along the lines of like their pleadings, right? She has to approve them ahead of time, or they might be redacted or whatever. Some of the, there were different suggestions made, things along those lines. Or maybe something like the, no more public interviews. Again, I don't see how they would have time for that anyway. If they go to trial on April 1st, I don't think that they would be doing that. I just, but she could still say that just to impose that additionally. So that's what I think is going on there. I think all of this is because it's not about the motion to dismiss, but it's about the sanctions that she wants to be able to impose. That's what I think. And so the other thing, what was else I to say about that? And of course, right, she could still make a finding, because it's Judge Bev, and this wouldn't surprise me for her, right? That she could still be like, yeah, you didn't have a good faith basis, so I'm going to put sanction. You can't, you have to run your pleadings by me first, or they're going to be redacted, whatever, right? Stuff like that, right? Or no more interviews, gag order type thing. I could see that happening. I could still see, though, her granting potentially, or at least an evidentiary hearing. Okay, if we remove the April 1st deadline and we just look at what we saw today and the question that she asks, which I'm going to pull up here next, that makes it seem like she's leaning towards an evidentiary hearing. Like, in other words, that could still be granted, but she could still go with the sanctions. So, like, I think she wants to find in favor of the Commonwealth for the sanctions. I think that's true. And I think that that's what we're seeing here. But she could do that, and she could still find something in favor of the defense in terms of this motion to dismiss, for sure. Both could be true. But then what throws a monkey wrench into all that is our calendar, right? The April 1st trial date is what I don't even know. So I'm still processing all this information, but I'm going to find the part with where she asks, and I think it's early on. She asks if what's his face is available, Mr. DJ, whatever the fuck his name is. We're going to call him Mr. D. How about that? Because that's what made me think she's like considering a hearing.
At Canton PD is a critical.
Why am I bringing it up? Because now that we've gotten to the end of the hearing, we've heard her talk about the scheduling. I'm like, what? When would you bring him in? But we're gonna listen. So
Importance, and that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Lallyport video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, I want to walk through what videos we did get and when.
we all on a tornado watch?
4th, we got 2 videos. One was the Lallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Lallyport. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Lallyport interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D. Giampetro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD.
Okay, I'm going to back this up. This is twofold. I forget. I'm not just listening anymore. I remembered I had other purposes. Not just listening for the thing about the what am I calling him? Lieutenant D, Mr. D. I'm also listening because I'm trying to categorize the bits of video for a certain purpose because there's a point to it that I'm looking at here. What I'm especially interested in is interior and exterior Lallyport. I'm less interested when they reference the videos at whatever, anywhere else. I'm thinking about the Lallyport interior and exterior cameras because, okay. So we're just
of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got 2 videos. One was the Lallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Lallyport.
That one's not inverted then, right? I'm just trying to make sure I'm.
And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Lallyport interior back wall video. That was the video that is now sort of famous.
Back wall, hold on. So back wall, did he say front wall before? Because these would be separate cameras. This one, okay.
On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got 2 videos. One was the Lallyport interior front wall. That was the video that was missing 42 minutes.
I'm writing it down. I need another sheet of paper, though. There's a reason I'm doing this, because it's going to matter when it comes to all the other shenanigans. So the front wall... I love the way he's describing it because this makes it easy to categorize them, right? Front wall is the one that's missing 42 minutes. And I believe that's also the one where they're like the ghosts and shit.
Which was the 42 minutes where it would have shown the car being pulled into the Lallyport. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Lallyport interior back wall video. That was the video that is now sort of famously inverted.
Okay, back wall.
On
I
October
wrote
10th.
it down. So back wall is inverted. Okay.
2024, 2 days before Sergeant DGM Petro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Lallyport. And I highlight the word exterior because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Lallyport was given to us. That's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Lallyport video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Bukhenik, dated February 28th, which is 4 days ago, 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Lallyport. Exterior Lallyport. That means that the Massachusetts State Police not only had in their possession exterior Lallyport video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 25th. I'm sorry, January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had had, or is it the same wobbly?
Same.
Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Bukhenik admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony.
I'm backing it up a second for a reason, because there's a couple things that are important, right? There's the cameras that are going to show Higgins and the cameras that maybe could show the quality of the taillight. So that's why I'm backing it up, because once he said this was super wobbly and you can't tell what's happening. So there's different exterior videos.
I'm sorry, I reviewed video made available to me, which included video footage of the Canton PD exterior Lallyport. Exterior Lallyport. That means that the Massachusetts State Police not only had in their possession exterior Lallyport video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 25th. I'm sorry, January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly? Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this?
Here's why that matters. I think it's really kind of twofold, right? In a way. So the fact that it's so shitty, it's like, okay, it's like the fact that it's so shitty, it's like either somebody fucked with it, right? Because like we saw an example and it was so shitty. I'm like, what's the point? Either somebody fucked with it. Now, if that's the case, why does that matter? Well, because this is a motion to dismiss, and part of it, it's like the outrageous, whatever, prosecutorial misconduct, right? Fucking with evidence, yeah, bye-bye, right? Again, that kind of puts the burden, though, on the defense to prove that it could have been fucked with, right? But the other thing is this. The reason I think she's asking this question, now that I'm going back through all this, I think she's asking this question because of this. Fuck, she's going to side with the state, guys. Fuck. Okay, let me just clarify. When the first time watching this through, I thought she was asking this question because she's like, God, how is, like, this is all fucked up? Like, how is the footage all fucked up? Like, I thought she was asking this question because she's like, you know, getting what they're saying, right? But now I think she's asking this question because she's going to side with the Commonwealth. I can't even fucking believe it. I think that's why. And here's why I'm saying that, because I think she's asking because if it was good quality video footage, that would be a bigger deal, right? Because what is she looking at? Instead of her thinking about it from the realm of shit was fucked with, she's looking at it from the realm of they need to prove that they could have gotten something from it if they had it earlier. This is so messed up. It's just not how it should be at all. It's just not how it should be at all. This is crazy. She's looking at it from the standpoint of if it wasn't good enough quality to where they could have for sure been able to tell what the taillight condition was. It doesn't matter that they didn't have it. But in my mind, the way I think about that is, you know what? Boy, the fact that the quality is so shitty. If you're the Commonwealth, right? Either you just got really fucking lucky that your cameras are that shitty, because like that is certainly the way to get around getting fucked for this. Like it's like all too convenient, you know? Like the way to get around A, of the Brady violation, B, dismissal of the case, C, all the other shit, right? That seems like they should be having. The way to get around it is when you've got Judge Bev here, right? And if you're aware of what she's going to be looking for, and what she's going to be looking for is would it have changed something, right? Because could you definitely tell anything different from the car, right? It's just all too convenient that the quality is so fucking shitty, right? Now, in my opinion, it still should have been turned over. But here's the problem, because what she's going to be looking for to dismiss this is going to be, would it have changed something? Because could it have proved something, right? And that's the thing. The thing that's so interesting is that it should be up to the defense. The government, the Commonwealth should not be determining what's exculpatory or not. Here's the thing. Here's why this is so interesting about this video footage. Because the only way around that, right, is if it's so shitty that you can't fucking determine it, right? Like for example, if the quality was maybe kind of poor, but like it was still up for interpretation, you could still look at it, then totally that's a little bit different, because then it's like, well, you know, it'll be in the hands of the jury, right? Or if something's in question, like for example, with the inverted video with Proctor on the other side of the car, right? It's like he could have tampered with it. We don't know. You know, I'm trying to think of a better example. Like something that could potentially be exculpatory, right? Obviously. The thing is if the thing that could be potentially exculpatory is having the camera footage, yes, true. But then you get the camera footage, and the camera footage is completely fucking useless because you can't see a goddamn thing. You know what you don't have to worry about now if you're the Commonwealth? That argument, because they can't make it. They can't even argue that there's something potentially exculpatory because there's nothing to be gleaned one way or the other from the video. You see why this is too convenient for me, for the Commonwealth? Like the fact that this is the case. Do they do this? I mean, I'm starting to shift from like they did this just for this case, potentially, to maybe it's worse than that. Maybe this is like literally how it always is, because then they always have this to fall back on for anything, right? Like with any other case in the past, or I don't know. Like when people are like, hey, can we get your camera footage? It's like, oh, it's just completely useless. Sorry, you know? And then if they don't turn it over, they have the excuse, well, it's not Brady because it couldn't prove anything. You guys see what I mean? And like, isn't that even better in a way if you're the Commonwealth trying to get away with fuckery? Now you might say, well, this is what we've all said. This is what everybody said. This is so logical. It's like, well, but wait a second. wouldn't they want it if it proves their case? This is where it's like I'm saying this is worse than we thought, maybe. Because if it doesn't matter because you know none of it matters, because you know that the judge is going to side with you, and because you know that you're going to, however, like, if you know you can do no wrong and you're still going to get a conviction based on myriad ways, based on myriad avenues, all of them are fucked, then no, then you wouldn't worry about it, right? In other words, if you're not going to really be proving a case anyway, you would rather not have evidence. And boy, doesn't that make sense? Like, hold on. I'm just putting a lot of this together here in my head of like that. Listen to this clip here.
There's no evidence of anything in this case.
Play that all the time as a joke, right? However, I'm thinking about this differently because let's put it into perspective with the red Solo cups and with the snowblower and with all the other stuff. Is it almost like their goal is to just destroy evidence or to not collect it and then to have some sort of fail-proof plan of how you can make an excuse for it that maybe wouldn't fly elsewhere but would fly here? You know what I mean? Like, again, most places, like, wouldn't you want the video so you can prove your case? Yeah, that makes sense. But guess what? Not if you're not worried about it, because it's just going to be open and shut anyway. This is like crazy. Like, in other words, you would rather not have it, right? Because it wouldn't prove it. Like, either the evidence, if you were to actually collect evidence correctly and have actual evidence, it's like either it wouldn't prove your case and it would show that, or you don't, it just doesn't matter because you just don't need it, right? In other words, if you're taking it with the risk assessment and you know that you're going to be doing fuckery and shitty things and blah, blah, right? You're going to weigh that risk benefit or cost benefit analysis and look at it like from a risk assessment standpoint. It would be riskier to have it if there's fuckery afoot, right? When you know you can prove it without it, right? You guys see what I'm saying? Like, you're not looking for proof in that situation. You're looking to minimize proof, really, because then it could go either way. It could prove the fuckery, or, am I making sense? Like, but this is crazy, though. Right, absolutely. Yeah, for sure. This is the cops' homeless for sure. Absolutely. I mean, but the thing about, for people that live there talk about the wide scale corruption. And I'm wondering if like it almost wasn't even that targeted. You know what I mean? It's like, it could almost be like they don't care who it is. They're just going to convict they're just going to pick a person and convict them, and they do it with everybody. Maybe, I don't know. Like, the thing about these cameras is it's one of two things. It's like either they fucked with everything with this case, possible, or it legitimately is how they have it all set up. But the only reason you would have it and we see the example that was just referenced, this video that's useless. We see an example of that later. We already watched it earlier in the stream too. But when you see that, I mean, literally, I was like, what are we doing? What is the point of the camera? It's like, well, rethinking it now that we're putting everything back into context, it's like, well, if your cameras are always like that and you don't do anything about it, I mean, come on, like. And the reason I'm saying it is because here she asks that question on purpose. What is the quality of the video? Is it like, that's the thing. She's asking about the quality. And that's what made me, that's where I got to all this, because her question here is indicating that if it wasn't of a good enough quality to where it could have shown something differently, she's going to say you don't have, like, it's like you don't have an argument here, right? Because it wouldn't have changed anything. Instead of saying this is fucked, they shouldn't have cameras like this is messed up, like, why are we, like, instead of seeing it the way that it seems like she should, which is, yeah, it's like she's only able to look at it through the lens of dismissing this and not through the lens of, I don't know,
And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had, or was it the same Wobbly? Okay.
Same. Wobbly, Grainy, can't make heads or tails out of hardly any of it. No.
Again, he's answering that, and probably from the same standpoint as I was understanding it the first run through of this, which is that, God, that's so shitty. You know, how is their evidence so shitty? What did they do to it? How did it end up like that? Da, 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 da. And I initially interpreted Judge Bev's question to be along that same line. I don't interpret it that way anymore. And in fact, I think it's probably even worse for the defense that he elaborates here. Because if he just said, yeah, it's about the same quality, there still could be maybe some wiggle room until you see it, that maybe it could have changed something, right? But then when he says it's wobbly, can't make heads or tails of it, now it's like, okay, the video is useless. God damn it.
The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th,
the thing is like, they are going with this third-party theory, and you know, we all have thoughts about how that's not maybe the best strategy to go with the trial because there's so many other, they don't need it, right? But setting that aside, here's the thing that is so crazy here. That is what their theory is, and we went through and read that article, and now we know that it was really Karen who first. That's how that all started, and the thing is this: is that. Again, it's a little bit convenient, isn't it, though? That all of the things that this entire time, all of the things that would prove that there is some sort of fuckery, like you need a way to prove it, right? You need to prove that there's fuckery in terms of in terms of to the court, right? In these, if you're making, you know, for evidence tampering and whatnot, right? You know, like, and it's like, okay, you got to prove it. And it's like, oh, well, we're trying, but hey, problem, all of the proof is basically useless. Initially, it was like we didn't have it. It was maybe destroyed. Well, now it's like, okay, well, now we have it, but it's like, you know, you can't make heads or tails of the video. Like, you see what I mean? It's like, they're like, the burden, Judge Bev is putting the impetus on them to like, okay, you have to be able to show it would have made a difference. You have to be able to show there was tampering and blah, blah, blah. But it's like, at every turn, anything that would do that is fucked up. I know that point was made, it has been made a lot of times about in reference to any time that you would actually see the tail light, but it goes way beyond that in terms of just them arguing to the court or making their case on a broader scale. It's not just, it's more, it doesn't even need to be as specific as the tail light. It goes beyond that, right? It goes beyond that. Like, for example, that this video that we just have been referencing, the one that you can't make heads or tails of, that video, there'd be no way to prove that there was fuckery or that was fucked with because there's no proof of it. They don't. So that's why it sucks, because it's entirely possible it was fucked with, right? But how are they going to prove it? So like, to the two levels, it's like, is the evidence itself fucked with, or is the thing that should capture the evidence fucked with? But you can't prove any of it because all of it's fucked. That's what it is. And so therefore, she's going to use that circular reasoning and fucked upness to probably deny this motion, which is mind-boggling to me. Instead of being like 2 + 2 = 4, she's like 2 + 2 = -2, -4. That's what she's doing. That's how I can best explain this in my mind, is like, instead of being like, it's worse, and then it's more worse, and it's more worse, and now the result is more worse, it's like the opposite. It's like 2 + 2 = -4. The leaps and bounds that you have to do, mental gymnastics, I think is what is going on. Probably. I hope not. I hope I'm wrong. I would love to be proved wrong. I would love to be proved wrong here. So.
To reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Lallyport video? We now know that
Gall is worse. That Gall is worse. Although when this, if what I'm saying is correct and she does deny this, which is again, I feel like feel crazy saying it, but I think that with all that I've just explained, that's where this is headed. She's going to be pretty on par, right? What do you think, Meg? If she does if she does deny it and just goes ahead to trial, if she denies this and just goes ahead to trial, where does she fall then compared to Judge Gull? Would that change things for you?
Watch some sort of exterior Lallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Lallyport video and intentionally withheld it across. This is binary. It only happened one of 2 ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Bukhenik was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the Lallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through.
Now or no? If you can, if you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided. Okay. It just very obviously. There were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them.
Yeah.
On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession. And that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been.
Okay, so now I'm going to go ahead to where he gets back to the timeline of the videos, because that's what I was also listening for here.
Of this case, not one but 2 separate agencies. Own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Bukhenik. That was likely the in first trial, so it can't be him. Proctor, as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time, and it took 2 months to produce an incomplete production of these videos. We didn't even get all of it at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who? That's a facts question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in?
Now that matters, again, for all the stuff I was just talking about, right? Like, was it fucked with? Was it like, is what we saw? We saw an example and it was useless, right? Of the new some of the new camera footage, it was useless. But is it true that it was already like that, or was it tampered with? The only way they're going to get her, the thing is this, is like, their only prayer here for Judge Bev is that they were able to show the possibility things were tampered with. Do you think she's going to believe that, guys? Because if she can't get to the thing about it would have changed something because of what it would be able to show, right? Like, in other words, clear footage of the taillight. If instead it's like all of it's fucky because it was tampered with, which is what I was just explaining, then she has to find something's fucky because it might have been tampered with. And if she finds that, then the result of which would be to inquire further with an evidentiary hearing to learn more. Like he was just saying, how does it look like this? But in order to even get to the evidentiary hearing, she's going to have to first find that it might have been tampered with. And that's just going to come down to who does she believe more? Really, that's what it looks like to me. If she really believes that like, this is how they were when they got it, this is just the cameras just look like this. Oh, God.
No facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor.
And Meg, I'm with you that Gull is worse, but I will say that right now I'm really hating Judge Bev.
Also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024.
Oh, wow.
According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, in July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective.
Wow. That
is
really fucking interesting. I did, the first time through, I missed the part about, I mean, I heard the name Louis Jutras or whatever, but I missed the part where he was the dude who installed the cameras and then replaced the quote unquote defective one. That's an interesting point though, about how that was the only one that was clear. He's right. I hope she's listening. She's probably tuning him out. If you listen to this, I don't know how you can find other than we need at least an evidentiary hearing. We need to learn more about what is going on with this shit, right? And you should care as a judge. She should care because of the fact, like, don't you want your law enforcement officers to like have cameras that don't just malfunction all the time, that actually have a point? And additionally, don't you want to have competent, like, don't you want to have police officers that are competent enough to like notice that that's a problem and be like, hey, we should fix this if it actually is like that? And if they're actually tampering, I mean, then that's the rhetorical question right there. If it's being tampered with, do you want to know? And it's like, well, if you're biased, probably not. God damn it. God damn it. You would rather not know. God damn it.
It's certificate of compliance. After the defense brought to the court's attention that 42 minutes was missing from the Lallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We weren't sure. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably.
Okay, so go break for lunch.
45 minutes, I'd say.
All right, so we'll break. All right, Mr. Jackson, go ahead and continue.
Thank you, Honor. When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is the I don't know if it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they
I
argue
think
that point.
that where I'm at now with this is like the inverted video, the fact that it's inverted doesn't matter anymore. We have to move past that. I think the bigger significance is actually the fact that it's the only one that is clear and the rest are all pretty much useless. And it was the fact that, never mind that it's inverted, right? Like, again, I think now we're seeing like that's the least of their problems. The other ones are worse. That's what's wild about it. The other ones that we saw are worse. And so the thing that you need to think about now, I think, well, to myself anyway, is like the fact that the inverted one, like they weren't waiting. Okay. In other words, they weren't waiting to turn it over or hiding it from the defense because it was inverted. I don't think anymore. I think really it's because it was the only one that is actually useful and helpful because it's the only one that's clear. The rest are useless. More useless than the one that's inverted. The one that's inverted at least is clear. So that's really the bigger thing. You get past the inverted part and be like, okay, it's clear footage at least. Clearer, I should say, right? And the rest is like, you know, ranges from useless to shitty to terrible.
Still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about
Okay. Oh,
having
interesting, Meg. So I have thoughts on that, and I'm before you tell me what they think, I'll tell you what I've been thinking, which is that they were still thinking that they could get a acquittal. They wanted to push for an acquittal, like they wanted her to be acquitted, versus asking for mistrial, potentially being granted a mistrial, and then knowing the Commonwealth would come again. That's what she said. But that's the synopsis. So what did they say? I'm curious, but I wanted to say that before, so it'll be interesting to see if they say something along the same lines.
and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally. Perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them. And that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that altered video.
Yeah, no, it is crazy they didn't ask for mistrial. I agree. I assumed they were going to be doing that, and then it didn't happen. So did they say it was for the same reasons, though, that they didn't? I mean, it could be a problem, right? I mean, I think it's a problem. I think they totally should have. In my mind, it was not a good call. Like, it's, in other words, it's like they still should have done it, right? But in other words, wanting to get that acquittal or like prove their theory of the case was maybe more important. I mean, and it kind of maybe is also why they didn't go the safer route, right? Of leaning less on the third party, as much as I hate to say it, right? It's like leaning less on the third party stuff and more on they didn't meet their burden. They could have maybe done that and had more success, but they chose not to because they really wanted to go with third party defense, and that's their right. Similar thing. I'm not saying it's the right call. I'm saying I think that was wise because it was more important to them. They wanted to get that acquittal. So I'm curious if that's also what they're thinking. Wait, I thought you said they did say why they didn't ask for a mistrial. But then you said you don't think they said? I'm confused. I thought you were saying that you knew they had also weighed in on that. Hi, DSN. Yeah, so what had happened was we went through the whole thing, and then I was like, we need to go back through certain things. And we also had we took a side quest with the Gretchen Voss interview because as it turns out, everybody was misquoting what it says in the article, interestingly enough. And you know me, I'm thorough, so I had to make sure 100% that I didn't miss anything and that literally it was nowhere else. And then I also had to make sure that they weren't relying on the reporter's notes, which they aren't, and that literally somehow everybody is misquoting what the article says, which is interesting. So we've had a number of side quests, and like the thing is there's things that happened at the end of this hearing, in my opinion, that happened towards the end that change everything at the beginning. Like, it's like, oh, so, and a lot of that has to do with the scheduling. Like now I'm like, I have to go back and reinterpret a lot of this. So we're not listening to the whole thing again, but we're processing this. This hearing was insane. This hearing was fucking insane. There's a lot going on to think about here in a lot of different ways. Like what's going to happen in the future, what's really happening on the videos, just this, there's a lot. There's just a lot. So, but happy to see you, DSN. Oh, they were questioning why they didn't ask. Okay. But they didn't give the reasons. I see what you're saying. They were questioning why they didn't ask for mistrial. And then they did give their reasons, but you don't remember. Okay. Gotcha. Oh, dang it. That's too bad. I'm curious. Yeah, no, I mean, goes up saying, I think most people would agree, like they should totally have asked for a mistrial. And the only reason not to do that is probably something that's not the best reason, right? Lallyport shenanigans. I'm saying, I'm trying to get everyone to say Lallyport instead of Sallyport, by the way, DSN. And I always shout out to you. I always give you credit for that every single time, by the way. I even on other, like even with Defense Diaries, right? When I was in the chat the other day, I was like, it's Lallyport. We love you. And by the way, everybody always references you whenever we're talking about Murdoch. It's so fun. Yeah, right there. Right there. Thank you, Meg. Yeah, it's a shame, right? But again, it kind of goes in line with the whole thing of like relying on the third party defense, even though that they didn't, there's nothing wrong with that. But when you've got a case like this, that is a disaster, which is like, this is like, you don't often see this, right? It's like a present in a way. If you're a defense attorney, it's like, why go that route, right? Or you could have done it and just not done it so much. The biggest thing of all I will say is this, is in closing arguments. That was the biggest thing, because in closing arguments, I was so sure that I remember it starting out and I was like, I'm still holding out hope. Like, I'm like, he's totally not going to spend this whole time on like the third party stuff. And I remember I covered it live with you guys and I was like, don't worry guys, da, da, da. And I was like, surely, because this is your last opportunity. I was like, surely somebody's got to talk about the jury instructions, right? Somebody's got to talk about the burden of proof and beyond reason, like, you know what I mean? And like all this stuff. And it was like, nope. And I was like, of all of the things, right? I mean, yes, it was focused too much during the trial also, but I think it still could have made a big difference if he had handled the closing arguments differently, because that's the last thing the jury's going to hear before they go deliberate. So anyway, but when you think about the fact that they still didn't do that, then it's like, okay, the only reason they wouldn't have asked for mistrial at the time is because I think it's pretty clear, like they wanted that acquittal. Just to prove a point, you know what I mean? When in doubt, blame Proctor. Yep.
Video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Bukhenik with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth during this debacle had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Bukhenik under direct examination by Mr. Lally, going into the next day, still under direct examination by Mr. Lally. They played that video completely inverted. They talked about it.
Right.
They discussed it. They described it. Not once did Sergeant Bukhenik or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Bukhenik about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Bukhenik started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, Under direct examination by Mr. Lally, Sergeant Bukhenik was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point. That
Let me go ahead a little bit to the part we're looking for here. Michael Proctor walking around the car. And again, we watched this entire hearing, but we're going back for specific things here. Okay, I think we're back to this is what I'm looking for. We want, what's his name? Mr. D. Whatever, DM Chiamcho. I'm calling him Mr. D. I have no idea how to pronounce it. Okay.
Can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutor sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence, the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter. It was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering. LOL, laugh out loud.
Oh my God.
So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations.
And what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Bukhenik, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos.
Here we go.
And then we have on top of that, in the middle of trial, I think it was Mr. Lally, maybe Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth, in a report from Sergeant DGM Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Lallyport video of SUV inside Lallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022, Lallyport video of the SUV exterior footage.
Okay, this is the crucial part because I have it categorized. Let me listen one more time because there was inside and then there's outside. Lallyport. By the way, in case, did y'all hear that the ruling just came out? Donna, I mean, not a surprise, right? That she's denied bond, but it just came out.
He writes this report on the 27th.
Like in other words, I just pulled 2 new things from the docket that were from the 3rd, but I don't think they were up there till today. There's a memorandum in support of their motion to suppress the freaking phone call. And then there's also the order denying bond.
Which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Lallyport video of SUV inside Lallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022, Lallyport video of the SUV exterior footage, that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been.
Okay, hang on. Did he misspeak? So let me just read. There's a reason I'm looking at this. So here's the thing. Okay. So there's, in terms of the interior Lallyport, there's the front wall camera. The front wall camera is like for example, the one that was provided that we saw at trial where there's like the 42 minutes that's missing. The back wall camera is the one that is the clearest and best quality, but it's all inverted. There's also the exterior Lallyport, which unless there's more than one, and this is really the question here, unless there's more than one exterior Lallyport, because they just keep calling it the exterior Lallyport and without specifying, okay? But remember, so far I have it written down, when they reference the exterior Lallyport, it's been the one that is wobbly and grainy and useless. And we see an example of it later on, and it is completely and utterly useless. So, okay, so it matters what one he says here. So,
and why did we get another video in January of 2025? What was the delay?
Yeah,
how could this be seen as anything other than intentional? We know now that Sergeant Bukhenik, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DG Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, maybe Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth, a report from Sergeant.
The thing is so that is the same one then, because he mentioned January. So this video that they just got January of this year, right? That's the exterior Lallyport. He's already conceded, Alan Jackson has, that the video is completely useless. And we see examples of it later in the hearing. And for those of you guys who've been here for hours, we already saw it earlier too. But the point being that it's just so wild, right? How like the argument can't be it's a big deal that we didn't have it because it would have changed something, because you can't see anything. So instead, the way that they have to go with this is it not being turned over until now, and them having it for like the 2 years or whatever, not turning it over, and it being so shitty in quality is because it was fuckery. That's the only other thing about it that they can go with here. So they have to hope Judge Bev sees it that way. God damn it. Fuck.
DG Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Lallyport video of SUV inside Lallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Lallyport video of SUV exterior footage, that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Lallyport video again of the SUV exterior footage. Quote, this is from his report. I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting. This is the first we're hearing of any of this last Thursday. How is that?
One of the things I wanted to try to figure out here is when they say the video, he's quoting, I guess here, the video from the entire time the vehicle is there. Does that mean of every camera? Or is it just of a particular camera?
Time frame that the suspect
on.
Proctor requested Lallyport video again of the SUV exterior footage. Quote, this is from his report. I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station.
Okay, that sounds like all the cameras. And the reason I'm saying that is because he references the exterior video footage, right? And then this is said additionally, like it's a separate thing. And then it says recordings. It's like, I believe it was around the same time that I downloaded all the recordings. So that would make me think it's every camera from the entirety of the time the car was there. Now, why does that matter? Here's why I think that matters. I think that matters because here's one thing we still don't have an explanation for. The 42 minutes that are missing from the, where is it? The front wall camera, interior Lallyport camera. Because that's the one that also has, I believe, the ghosts and shit, right? Ghosts and shit. And then 42 minutes of it are missing. But here's the thing, where even if you take away the inverted part, even if you take away the ghosts, the fact that any of it is missing, anything is missing, is still noteworthy to me because now we know that the Commonwealth had footage from the entirety of the time. Now, I guess maybe that they could try to say, well, it was not activated because of the motion sensors. I guess they could try to say that. But still, like, that just doesn't make sense, though, to me. Like, if I think about footage where, well, it doesn't make sense anyway for a number of reasons, even before any of this new stuff came out. Like, it doesn't make sense anyway, because we all know a car is going to activate it and a person moving around is going to activate it, right? But, like, I feel like the 42 minutes one, yeah, they're trying to say that the 42 minutes, I don't know. Like, if you're saying that you've got footage from the entirety of the time the car was there, that to me negates the 42 minutes part, right? Like, that means... that to me was something you would say if your cameras are not fucking motion activated, right? Because if you've got cameras that are motion activated, then there's no possible way for any vehicle or anything that you can say, yeah, I've got footage of the entire time, because there's no way that would be the case, right? Like, what do you guys think? Listen one more time.
30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Lallyport video again of the SUV exterior footage. Quote, this is from his report. I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting. This is the first we're hearing of any of this last Thursday. How is that? Sure. Ms. Lou just handed me a clean copy of the DJ and Petro report. I would like to have this marked and handed to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes.
You probably did.
So I've seen it.
Okay.
Hold on. What, Ms. Little?
We'd still like to make it part of the record if sure, right, Your Honor?
Sure, I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
Okay.
So are we marking it? So we need it if we're marking it.
I'm sorry. My mistake.
Exhibit 1 so marked. Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023?
Okay.
Now, I'm going to go a little bit
So
slow.
here's the thing. Part of what I wanted to do here is figure out, yeah. So when they say they had all the footage the entire time, it's like, what was it talking about? I think we've answered the question. All the cameras, right? So I think for the defense, part of the biggest thing about the timing of when things was turned over, they're going to try to use that to point to fuckery with the footage itself. And that without, the only way to prove fuckery with the vehicle would be to have footage that is not fucked with. They're going to have to hope Judge Bev sees it that way. So the only other thing that is interesting to me, and I thought, I don't know how we didn't hear it, but let me go back a little bit, is the part where Judge Bev asks if what's his face is available, because that kind of hints at her leaning towards an evidentiary hearing. And then I want to hear the scheduling again at the end, because that was wild.
Indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on.
Not this
He
part.
has access to or control.
One of Michael Proctor's supervisors. He interviewed several prosecution
It's not
witnesses in
this
the
part.
orbit of the
Actually, I guess all of this is related to Fanning, so it has to be right.
Jury. What's the nature of the conflict?
And by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want taillight. The condition of that SUV passenger taillight at the time it was brought into the Lallyport at Canton PD is of critical importance. And that may be one of the most important facts in this entire.
Okay, we heard this. Okay, let's see. It might be in this section here where she says it.
Videos. One was the Lallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Lallyport. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024.
You heard it from him right there, right? The part where it's missing the 42 minutes when the car would have been pulled in. It should have, if it's motion activated, it should have activated it, right? That was one of the reasons why, like that right there, as I was just referencing to, like when they're like, yeah, we have cameras or the recordings of all the cameras from the entirety of the time the car is there. And I'm like, well, we still haven't figured out, we still don't have a good answer for that 42 minutes, right? Because the motion activated doesn't make any sense. So I think that again, for things that are going to be the easiest to show, and not that it matters, they're not like if it were me, right? If I was the defense team and I'm like thinking about how Judge Bev is going to understand this and what she's going to need to get to an evidentiary hearing, because that's the best they can. I would imagine that's the best they can do, right? Like they've got to show something that is irrefutable that could make it look like shit was fucked with, and that the only reason they can't prove more about the taillight or whatever being fucked with itself is because the cameras that would show it were fucked with. And that I think is one to highlight, because again, it's a problem. The problem being with the other shit being so grainy and useless on that footage is tough because it can't prove anything either way. And that's exactly the argument the Commonwealth ends up making. Like it's not inculpatory or exculpatory. It's like, oh, God damn it.
By the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Lallyport interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant DGM Petro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Lallyport. And I highlight the word exterior because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Lallyport was given to us. It's a grainy and very wobbly video that
that's the useless one.
Nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Lallyport video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Bukhenik, dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Lallyport. Exterior Lallyport. That means that the Massachusetts State Police not only had in their possession exterior Lallyport video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 25th. I'm sorry, January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly? Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Bukhenik admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Lallyport video? We now know that Bukhenik watched some sort of exterior Lallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Lallyport video and intentionally withheld it from us. This is binary. It could only happen one of 2 ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or
it was a problem at the time. You didn't do anything about it.
Exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Bukhenik was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show.
Cumulative effect of the bad. Okay.
I will get to the prejudice as I move through.
Now or no? If you can, if you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine them.
Okay.
Sure. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements. And there's myriad excuses in their opposition paper.
Okay, I think this is the right. I think I'm in the right territory now for when she asks that question.
And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But at the point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Lallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs, crime scene photographs in support of the vehicle in the Lallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Lallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Lallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Lallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Lallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Lallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41. 11 minutes, long after the car had already been secured in the Lallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. That's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense quote struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Lallyport is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Lallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor from the very beginning of this case had been lying about the time he first took possession of that.
Hi, Gen X is here. Woohoo! Sweet. Oh, yeah. Are you kidding me? This is not This is normal. 7 hours is not that long for me. Oh yeah. Well, I don't have my camera on, but that's just because there's no reason to, you know what I mean? It would definitely be, I can totally understand, like, if having the camera on, that would definitely feel a lot more draining, because then it's like, you're also just aware of, like, I guess like, am I looking at the camera or whatever, you know what I mean? But like, I don't know. It's not that bad, just especially because we're just watching it, you know what I mean? But I'm happy to see you though. Also, let me know if you want a custom command. And for anyone also who hasn't heard, we do have memberships now. And I'm just hoping this is getting to the part for anyone who is like, what are we doing? So this is our like second time through. I'm waiting for the part where she says, Judge Bev asks that question about if Mr. Dijingpingo or whatever his name is available. And because I think it's really interesting. And then I want to pair that with what she says about the scheduling at the end. But the problem is that I'm not finding it this time through, but I remember it was early on in the hearing. So it might be that we've gone too far, but anywho, there's a lot in here and I'm happy to hear it all again anyway. So
that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Lallyport. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate savings time. Oh, no. These claims that car was in Michael Proctor's possession. We retrieved it at 4:12 the Delaware in 2022, that the SUV got to the Lallyport, and that was the centerpiece.
Okay. Peaches early investigator.
Not something that's supposed to be parsed.
Thank you,
all
Jack.
physical evidence be preserved. That's pretty straightforward.
Next is gifted some memberships. Awesome. We love it. You know what? I bet I've just unlocked the ability to add more custom emojis. Every time we have more members that come in, I think it's like you have to have like a certain number, but I'll be able to add some more custom emojis, which is awesome. Let me know if you guys have any requests. The first thing I'm going to work on is the 2 gray boys with their lasers. YouTube is so funny like that. And welcome, P Fox. So that is super awesome, super exciting too. And by the way, guys, I have a some of you guys may have seen it. I have a thread in the Discord for requests for members only stuff, because this is new. We just started doing this and it's super fun. And yeah, so oh, what else was I gonna say? I'll think of it here. Hold on.
The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has. So
I know what I was going to say. I remember this part because I was joking about, he says a game of Wordle, and I play the Wordle every day. Yeah.
To be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Lallyport videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Lallyport because the Canton PD is not the crime scene. You asked for crime scenes.
Okay, I remember this part.
Remember the prosecutor was not aware of the existence of certain federal grand jury paperwork showing that Michael Proctor testified to it.
Okay, I think I've gone too far. I'm trying to find that spot. So she starts out right from the get-go.
Ordinary governmental misconduct, a true and correct, to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st.
It's like she does this, they do this whole thing, right? And then they switch gears. And I feel like it's pretty soon into the motion to dismiss, she asks that question about
the second exterior Lallyport video that we ever received. Sergeant D.G. Petro.
Okay, I went too far, I think.
And both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also...
Okay, too far. Okay.
At least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yanetti.
One more time.
So if the
One more
court will
time
allow
for
Mr.
the
Yanetti to
win.
explain what his experience is, that may elucidate on
That's
Mr.
We have time later. Go on with your argument.
I'm happy to, Your Honor, and thank you for giving me the opportunity. The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers through their agents, has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Lallyport videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it's...
Hey, Gen X, you probably haven't seen this, but, you know, for Wendi Adelson, right, we've got Fievel, because one of our school friends, Heather, very astutely realized that when Wendi had a... Wendi is Fievel, like Fievel, oh my God, what's his last name? Oh my God, Fievel. Oh my God, what's his last name? From Fievel Goes West. Oh my God, I can't remember his last name all of a sudden. Anyway, Wendi is Fievel. And so I pulled up a picture of Fievel. This was, I don't know, like maybe 2 weeks ago or maybe 3 weeks ago. I pulled up a picture of Fievel, like actual Fievel. Misconduct, that's what it is. And he has, this is his outfit. This is his outfit. And I literally said on the live stream, I said, gee, I wonder if it's possible. I was like, I don't know that I'm skilled enough to do this. I was like, we need Wendi to wear his outfit. Like, we need her to wear his outfit. And I was like, I don't know if I can do it, but I'm going to try. And here she is wearing literally his outfit, Fievel. And we have her as a custom emoji as well that you guys can use, members. But there she is. So I just wanted to throw that in there. We have a lot of funny Wendi clips too. Sorry. I'm going to take a quick Wendi break briefly here because we've been working on this for a long time. And I just, you know, quick Wendi break. So,
my friend Elizabeth is a mortician. She's the prettiest mortician I've ever met.
You guys, Andy's friend, the fucking mortician. What is happening?
I ate a lunch. Like, I had a whole delicious lunch. Yesterday, I was taking a walk around 5. I met a new friend. We went to Tallahassee food trucks.
Wow.
Last night, hung out with her for hours.
Yeah.
Wendi made another new friend. Are you fucking kidding me? Why?
She also Googled. There was a shooting, do you know? Both she and John.
Stop.
Why would they
I'm
Google?
going to die.
Why would that just come
I'm
up?
going. Sorry. Heather says, I met a new friend on a whole hawk. Bitch, how old are you? So I was just typing in the chat. A billion scroll points go to DSN, who knows Fievel's full ass government name. Look at this. Oh, wait, did you add Trescott? Oh my God, you're so funny. Trescott, Fievel, Trescott, Misconduct. There it is. That's it. I don't care. That's it. That's official. Wonderful. Freaking love it. Thank you. Oh, that's awful. Credit card fraud. I'm sorry, Gen X. Sucks. Yeah, we've got, dude.
Is there any way that you would think
somebody tried to kill my ex-husband? They should be prosecuted to the full extent of the law.
And then we have another new one. This is Charlie with the double extortion theory in summary. And we have also a new command for that. Whenever I talk about this theory that I'm like, I don't even know how to explain it because it makes no sense. One more time, we'll put too much speed. This is it. This is the whole thing right here. This is it.
I'm trying to tell her that this is a big deal. Like if we go to the police on the second extortion, they're going to catch the second extortion, and when they catch them, they're going to turn, and the second extortion is going to turn in the first extortion. And then when you catch the first extortion, the police are going to come talk to us, and then when we tell them what happened, you're going to be in a lot of danger. There's no way I can talk to the police. So by catching the second, it's going to turn in the first. And that's exactly what I say in there.
Makes perfect sense to me. So initially I had it with it's like the puzzle pieces, the cash, the tooth, TV, gun, the mouse, that's for Wendi. The binder, that's the 800-page divorce binder. the Band-Aid, that's for Donna, puzzle pieces. And then I had it like equal, and then it was like question marks or whatever. And then Heather brilliantly, I think this was last night, was like, it's the third extortion. I was like, yes. So now that's the third extortion. It's great. So, and for anyone again who hasn't heard, Judge Everett has denied Donna's bond. So that was our little Wendi break and our little 5 break. I just freaking love it. So
I think it bears upon the court at this point to consider most prominently the Lallyport issue, or the Lallyport video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, sergeant by the name of DJ Petro.
I bet this is the part I was looking for.
Who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Lallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Yes, thank God. You guys, I'm just so excited. I've been looking for this part. Here it is.
Revealing previously withheld Lallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious. So he's still around?
He is.
Okay.
Yes, and he's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion.
All right. There's only one reason she would ask that question, right, guys? Right, guys? Right, guys? Why would she ask that question? Evidentiary hearing? Evidentiary hearing? That's what that looks like to me. This is why, in my mind, I had to recalculate everything once we got to the end and heard the scheduling. And then I was like, hang on. Because the lens under which I've been interpreting this has been because of that comment or that question that she's leaning towards an evidentiary hearing, which makes sense because how could you not, right? At the very least, if not dismissal. But then you get to the end, and some of it cuts out here where she initially says something about coming back on the 18th, but they come back and talk more about scheduling here. So we're just going to roll with this here because this is shocking.
I only need 30 seconds. That
You can take your time, Mr. Yanetti. You're not going to be
we're only
5 minutes.
right.
After this.
I will. It's convenient.
After this.
But I will point second, then do a subsequent statement. That wasn't the intent.
All right. So if you have the site, I'll give you until tomorrow afternoon to find the CourtTV site.
Very well.
If you have it, supply it to all, Mr. Yanetti. So I'm ordering the Commonwealth if they have that CourtTV site to provide it to all of us. And if you don't, provide that as well. Provide that information.
Thank you.
Thank you. All right. That's it for today.
All right, support, please.
Wait, so I guess the scheduling is completely cut out of this one. Oh, fuck. Okay. So then I do have to go back to the other feed. Hold on. Give me just a second. All right, let's do this. That's so funny I thought it only missed part of the scheduling on this one, but it misses all of it somehow, which is honestly, I will just say for anyone who doesn't check the other feeds, if you're only watching this CourtTV feed, you're missing probably the most, in my opinion, important part of this entire fucking thing, because the scheduling is the craziest part, in my opinion, and gives you the most information as to what Judge Bev might do, even though it makes literally no sense. So let me just put that up real quick. Okay, so it'll be okay, so it's right towards the end.
All right, so provide it to Mr. Yanetti. Mr. Yanetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court.
So now we need to go back a little bit. Okay. Right, here we go. Okay, this is the thing.
Juncture to dismiss this case, then we urge the court to have an evidentiary hearing. That's what this demands at the very least.
Now remember, trial is supposed to happen in 26 days, people.
Evidentiary hearing so that the court can perfect the record. We shouldn't be guessing at things. And I'll submit.
Any follow-up, Mr. Brennan?
No, thank you.
Mr. Yanetti, do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right. I know you want to do your motion, Mr. Alessi. I cannot imagine that you can summarize it all in 10 minutes, can you?
I cannot, Your Honor.
Okay. So I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
I will.
I mean, your pleadings are very thorough.
I will do so, Your Honor.
Okay.
What? This is where I'm like, what? Because they're not coming back until the 18th. Trial will be on April 1st, right? Assuming they go forward with it. And she's still sticking to trying to get everything done because they were expecting to have finished with Mr. Alessi's. I forget what he's even arguing about at this point, but he was supposed to be done already. And they're going to hear the rest of the remaining motions and all that on the, whatever it is, like the 18th. And I think they say maybe the 19th. And so because she's trying to stick to the schedule, this is the part that's crazy, because she's trying to stick to the schedule. She's like, can you condense it and make it shorter? Because now they have to fit that into. That's what she said. So like, if there was an evidentiary hearing, it would have to be factored in, right? Like, it would have to be as soon as everyone's available, right? But I mean, it's hard to imagine that it wouldn't make the trial date get pushed out. But even if it didn't, they would have to be talking about it, right? In other words, there's not time. This is the thing. There's not time for her to go and take it under taking it under advisement, as she always says. There's not time for her to take it the fuck under advisement and then come out with a ruling and then try to schedule this shit and get this all done before trial. Right? That's the thing. And she didn't even ask. She didn't even say anything like this. She didn't even say, just in case I don't know, I'm a rule, but in case we're going to do an evidentiary hearing, are there any other days that you are available next week or the week after? She didn't even ask that question just to even look at the schedule. Like this to me means, like I said earlier, it's one of two things. Either she already knows she's going to deny it, or she already knows she's going to grant it. And by grant it, I mean, it would have to be dismissal, right? Because if it's granting it as an evidentiary hearing, that means you're going to have to all get together and have a hearing, right? So it's one or the other. Because she's still acting like they're going to, and this is the other thing. So the fact that she's still acting like they're going to just be on schedule and go to trial starting on April 1st, and they're just going to see each other for 1 or 2 more days, and then that's it. It's like, okay, so if she's leaning towards, I'm definitely going to dismiss this, then you'd have to say she's just doing that to try to make it seem like everything's normal because, she's taking it under advisement or whatever, right? Either that or it's actually genuine because she already knows she's going to, sorry, hold on. I want to make sure I didn't get it backwards. Like either she's going to either she already knows she's going to grant the dismissal. And so she's just like acting like everything's normal. So then she can take it under advisement, right? Or whatever. Or she already knows she's going to deny it, right? And then that's why she's acting like this, because it's legitimate. In other words, it's either a ruse or it's legitimate. If this is a ruse, it would be because she's like, this is useless. We're not going to be going to trial because I'm going to be dismissing the indictment and granting the motion, right? Or it's legitimate because she's like, I'm going to be denying the motion and we're going to trial. But what the thing that is so fascinating is what this cannot be is an evidentiary hearing. It can't be anything in the middle like an evidentiary hearing because they would have had to talk about the schedule. And there would be no point like, yeah. So does that make sense? Kind of crazy.
So I gave the parties until, instead of Friday for all the motions eliminated, next Monday is fine. But by the following Friday, I want any responses, oppositions, any responses to the other side's motions. And then we'll have a hearing on the 18th. Jim, did we put aside any other days as well?
It's gross. It's like not even any mention. It's like not even pretending to, even if it's fake, to even consider, even if it's fake consideration, the possibility of an evidentiary hearing. Doesn't even try. Doesn't even try to pretend to fake it. It's crazy. Rude, even, honestly. You should at least pretend. And that's the other thing. If you're going to take it under advisement, right, you should at least then pretend with the rest of this shit so that seems legitimate.
Just a sec.
Yeah, we did 18 and 19.
That's what I got, yeah.
All right. I would expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here.
Wrap it up. We're not. Yeah. Oh, great.
All right.
Great. Sounds good to me. Not.
Yes.
Fox 25 produced the materials.
And then this is where he does this thing where he walks. Okay. So that's disgusting, right? She's like, yep, we're just going to, I mean, one more time, just because this is blowing my mind. She's not even pretending. If you're not even going to pretend, why aren't you just ruling from the bench? Gross.
Just a sec.
Yeah, we did 18 and 19.
That's what I got, yeah.
All right. I would expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here. All right.
And that's got to be Mr. Alessi's, whatever he's doing. I mean, I don't think wrap up whatever we have here. That's not an evidentiary hearing with all the Lallyport stuff. That would be a whole thing. So I would say that this is indicating to me, sadly, that she's just going to flat out fucking deny this motion to dismiss, not even have a hearing, doesn't give a shit. And that the only thing still on the table for Judge Bev, as what we heard about today, is probably going to be the sanctions for the defense. And not only sanctions potentially for candor to the court, in her opinion, regarding the invoice with the Archidudes, but potentially additionally sanctions, potentially due to the jury tampering that was included in their motion to dismiss. And in her mind, they should have, whether or not they had a good faith basis to say that. Like, because where I started this whole thing, I was like, well, there's still sanctions on the table, but like, it was looking to me initially like she was going to, again, grant that evidentiary hearing at the least. And now I've just completely changed my mind because hearing it all twice, the scheduling is insanity to me. DSN says, I'd love to hear about Wendy's demeanor during the Mosaic whole delicious lunch. I know. She just drove by the crime scene and was waiting for the cops to arrive at Mosaic. I highly doubt she ate well. Yeah, she references being full though several times, but it is interesting. And the thing is you better believe at her trial, we will hear from those friends. I keep saying this. It's going to be really interesting because there's a lot of witnesses or people that will be important to this case that like haven't come up yet because there wouldn't be a reason to. Like when you think about Wendi and just like the stuff that's like going to be only like Wendi related, like it wouldn't be admissible otherwise. There's going to be a whole lot. There's going to be a whole lot of new information we get from Wendy's trial. So she'll have to continue right? But that's the thing. She's acting. The thing is this. When you're this close to trial, right? If there's going to be any change, because it's so hard for them to coordinate their calendars, if she's going to make any changes at all to that calendar, that is, and with the intention of also still going to trial on April 1st, there's not enough time to wait to do that. So that's what's so wild about it, because it's like, I don't know, man. I think that the reason they're going to start on time is because she's just going to like you just heard her. She's yeah, we just got these motions in limine and, we'll hear his thing. Can you do it in 10 minutes or whatever? We'll wrap it up. She says it's still on the screen. We'll wrap it up. Wrap it up. We're almost ready to go. That is her demeanor here. Like there's nothing pending. It's insanity to me. Like not starting on time is like for normal people. That's the normal thing. Why? Because everything's messed up as fuck, right? And we at the very least need to have an evidentiary hearing. Normal logic. Judge Bev, not phased at all, seems ready to go. So, and it's the same thing too, right? Like if she were to have an evidentiary hearing at the, or if she were to do something like remove one of the defense or remove Alan Jackson or whatever, which, I mean, we haven't even seen freaking Bettero, right? Where is he? I mean, Like, is he going to show up the day before trial? I don't even know. I don't understand. Like, where is he? Like, is he, because like at this point, if he ends up, materializing in this court, at best, he'll only be there for the 18th and the 19th, and then trial. It just seems insane to me that he would be involved earlier. It's just so anyway, but if she were to remove an attorney, which I don't think she's going to do, and part of the reason I was thinking she wasn't going to do that is because I was thinking she's trying to push for that trial date, and then that was before the hearing today where I was like, well, fuck, because my thought was she's all about getting trial on time no matter what. I mean, think about the first trial. There was a joint motion to continue, and she's like, nope, we're going to trial on time. She cares about that apparently above literally all else. And even if faced with potentially getting rid of a defense attorney, which she would love to do, if it means continuing the trial, I was like, I don't think she's going to do it. So then if you imagine, evidentiary hearing because there's clear fuckery afoot and we need to do something about it, I don't think that's a motivating factor for her. So it's just. Hi, Andrew. Welcome. If you're new, I believe you're new. Who was defending Turtle Boy? Was he? Hi, Julie. Happy to see you again. Yeah, I'm still awake because I'm stunned. I'm just stunned. I'm stunned second round through with this where we're at with this. I'm just stunned. I just can't. And in my opinion, if you're going to be biased enough to already know how you're going to rule, you should at least not be so disrespectful as to not even pretend that you're considering it. Like I said a second ago, at the very least, try to do some fake sort of thing of because she's taking it under advisement as always, right? At least be like, okay, are there any possible dates in case we have an evidentiary? At least, because this is just disrespectful, because what she's doing is she's saying, yep, it's all's well that ends well, saying plowing ahead to trial, right? But yet she's not ruling from the bench. So what this says to the defense attorneys is she already knows she's going to deny the motion, yet she's not going to do them the courtesy of ruling from the bench, and she's not going to do the courtesy of scheduling an evidentiary hearing. It's just disgusting. You should at least fake it. It's disrespectful. Just can't with her. Bettero. Oh, you're answering my question about Bettero. Thank you, Andrew. I appreciate that. Thank you. And thank you also, Julie, for gotcha. Okay. I see what you're saying. Thank you. He was defending Turtle Boy. Okay. Of course, I should have figured that out. I should have put two and two together. But right. She ain't getting rid of Jackson. Right. Again, because I think she wants to push forward to trial. That's her being. That's what she cares about more than anything. And that's a problem, right? Because if there was an evidentiary hearing, again, there's only two options. Either the trial would have to get pushed out, or they would have had to discuss those dates today. That's the thing. And they didn't discuss the dates today. And she's acting like they're going forward to trial. I will be shocked if because of the scheduling here at the end, if it wasn't for this, and again, it's so crazy. If you're on the CourtTV feed, you don't get to see any of this. If I'd only watched the CourtTV feed, I would have come out of this hearing thinking, yeah, she's going for an evidentiary hearing and the trial's going to get continued. And that would be how I'd be like, yep, going to get continued. We're going to have an evidentiary hearing. Who knows when we're going to trial? But because thankfully I was like, well, hold on. It's only a couple minutes that are missing from the CourtTV feed. But I was like, let me go to the other feed and see. That's where they talk about the scheduling. It changes the entire thing. And now it's like, oh, all right. Now that's the opposite of what I thought, right? The scheduling is crucial here, in my opinion. Okay, interesting. Is that televised at all? Probably not. I mean, I still don't think she's officially even ruled on that pro hoc vice for him, but it seemed like it was just a formality because she wanted some sort of other affidavit. Yeah. Oh, interesting. Okay, Zoom link. Interesting. That's interesting. Yeah, I haven't watched any of the Turtle Boy in court proceedings, but obviously this has been, you know, yeah. And the thing is, I do agree with the unforced errors regarding ARCA. Like they should have, you know, they should have, whenever they did get the invoice and then whenever they did pay the bill, that should have been turned over. Right. And they should have just turned it over. Right. And then they should have, and then they wouldn't have had the candor issues. They only had the candor issues because they hadn't turned it over and then stuck by the whole thing of we didn't, you know, pay them and stuff. But a lot of this shit though, honestly, it's because they're being rushed. It's like she refuses to continue it. And again, even if you think about, like, look at all the discovery that's come out since the first trial, that should have been there for the first trial. Part of the reason they wanted to continue it, and she denied it. It's just crazy. It's like nothing will stop her from going to trial on the date that she sets, basically, it seems like. And actually, didn't she already continue this once? She did. It was initially supposed to go in March, I believe, right? She continued it by like 2 fucking weeks, and she was like, that's it. I'm pretty sure, if I recall. That could have been, I'm covering a lot of cases, but I'm pretty sure that was this one. It has to be. So, yeah, because I remember it was like so insane how it was like 2 weeks or something crazy. So, but when you've got that, I mean, you can see why it's a problem, right? Because they're just not given enough time to do the things. And they're all like, you know, pedal to the metal, as they say. Interesting. Well, that it wasn't contingent on that, though. Like, it wasn't like, I mean, I guess she can deny it, but there's, in other words, when they made that motion, it was before, oh, Andrew Brown is thinking that Bev wants to pull a Miss Becky. Yeah, that's not a bad idea at all. I could see that for sure. You're not wrong. You're not wrong. Right. Commonwealth. Yes. They both wanted a continuation. Yes. First trial and second trial. They both did. Yes. 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 That's correct. That's correct. Okay. The first date was in January. Okay. I was thinking it was February, but yeah. Yeah, but anyway, I was saying, like, I don't remember it being contingent on Alan not being here. I mean, again, she can't always deny it for any reason because she's allowed to. But it would be weird if she denies it and says it's because I'm keeping Jackson on, because that wasn't on the table at the time. And the other thing is, the other reason that would be weird is because nobody's formally asked for him to be kicked off the case. That, right? I mean, just to reiterate, the Commonwealth has never asked for that. It's just one of those things that's been talked about because of how she reacted that day, and then like sanctions on the table, but no one's actually asked for that. So anyway, oh, I'm sure that, yeah, she only agreed as a continuation because the Commonwealth, yeah, yeah. Jesus Christ, it's just insane. So I think that'll be it for this one, guys. Welcome to all the new members. Love it. We do already have some members only stuff that, even though we're new, we've just started doing the memberships. We've already got some members only videos. I think there's a members only live stream, and we're going to be doing more. And anyone that has requests or suggestions, please feel free to put all your ideas in the Discord as well. And what was I gonna say? Oh yeah, up next, what we've got all these BK documents. So in the Idaho case, and that's insanity. And it was like all of them are released at once, and here you go, open the floodgates. I'm glad you caught us as well, for sure. And there are probably some other SDSers here earlier. I can't even remember at this point. This hearing broke my brain, guys. You too, Iowa. Thank you guys. Thank you guys. Thank you guys. Y'all are why this is fun and why the Scroll Crew is the best. DNA under fingernails. Yup. And the ones we're going to do, I believe, the ones we're going to do today are going to be the bushy eyebrows, the Amazon click thing, the autism spectrum disorder, and what was the other thing? Oh, now I can't remember that. There were 4 things. Anyway, it's on the thumbnail. I can't remember the other thing. It might be the DNA under the fingertips. But anyway, yeah, there's 4 of them because I've looked at what I thought would be appropriate for. Now, can't say it won't. I won't end up doing more, but my goal is to at least get through those, and because some of those are quite long. And then again, we do have 2 new documents for Donna Adelson. We've got the defense's memorandum for the motion to suppress, and then we have Judge Everett's ruling denying bond, which of course I don't think anyone's surprised, but it'll be fun to see what he says, won't it? So we'll cover those 2 as well, maybe today, maybe tomorrow. But anywho, love y'all. Y'all are amazing. What time am I live? Good question. It's probably going to be when I finish with my lessons tonight, which may not be good for you, Julie, because Julie's in the UK. And that would be probably, let me think. At the earliest, probably 10, if I can finish everybody, 10 p.m. my time. But usually that it's hard. I struggle to do that because I'm not a meanie, and I'm like, no, I'm not like, up, your hour's up, bye. It's like, that's not me. I'm like, okay, go find your pencil, and like, anyway. So that's why I'm always running over with my lessons. But so it might be more like 11. Unless something happens and people cancel or something like that, or need to reschedule, and then that would be different. But I always need like a block of like many hours, especially well, every now and again I've got shorter ones, but usually I need a block of hours. I guess I could split it up into like 2 streams and then do like 2 shorter ones, but anyway, it'll probably be tonight in all honesty. So, but love you guys. Y'all are the best. Welcome to the new members. Welcome to any new Squirrel friends, whether you're a member or you're just here for the first time, and old friends, because we love everybody and y'all are the best. And I will catch you guys next time. Let's hope that Judge Bev does the right thing, but it doesn't look like she's going to. So, but anyway, with that, I'm going to roll the outro, and I will see you guys next time.